Did some leaflet for the speak last week. I was too shy for sending in.
Everybody's in the room, so yeah, Violetta, if you want, I think we can start.
Perfect. Thank you very much, Maya, and thank you, everyone in the room, virtually and physically, for joining today. My name is Violetta Moreno-Lax. I'm Professor of Law here at Queen Mary University of London and the Director of the Borders Centre. This is one of the events that we hope will constitute the first of many in which we will try to launch and maintain a dialogue between practitioners and academics on matters of common interest. So the idea with this workshop, and I'm very thankful to Maya Grundler from Royal Holloway University of London and a former alumna of ours at Queen Mary, to bring us together, academics and practitioners, to discuss the issues that complex asylum claims give rise to, from both the perspective of the academic, but also from the bench. So we're going to be working together throughout the day, zooming into a number of very tricky and topical issues of asylum and immigration in the UK context, with solicitors, barristers, judges, and academics to discuss these areas of common interest. And we're going to hopefully nurture links that are of mutual interest to both sides of the dialogue. And in particular, we would be very interested in knowing how academic work can sustain practitioners, and how academics and practitioners could work more closely together for a better impact on potential reforms that we would all like to see happening at some point in the future. The event is being recorded. I hope that is okay with everybody. For those online, questions should be submitted on the chat box, and we're going to be reviewing that. And for those in the room, please just raise your hand and we will moderate accordingly. We have arranged the event around two roundtables. The first is going to be on improving protection for asylum seekers with special characteristics, and there's been a change in the program. I'm going to be moderating that session instead of Professor Steve Pearce, who have very kindly agreed to swap with me. Unfortunately, due to a flight cancellation, I couldn't be there in person with you. But since this event is hybrid, it's only pertinent that there is somebody chairing online. We're going to stop for lunch at 1 p.m, but then return again for a second roundtable on improving protection for trafficked and smuggled persons. And I hope that everybody can stay around, because at 5 p.m, we're going to have a keynote by the one and only Colin Yeo, who's a barrister at Garden Court Chambers and the editor of the Free Movement website. And it's a big blogger and tweeter. I know that everyone is familiar with his work, and everyone will be very interested in hearing what he has to say, and hopefully pulling all the different threads together of what we will have discussed throughout the day. Hopefully, as I said, this is going to be one of the first sessions of these kind of events that the Borders Centre for the Legal Study of Borders, Mobility and Migration here at Queen Mary is keen in managing and sustaining through time. Just a disclaimer, so the Borders Centre, for those who might not know us, was founded in 2022 to focus on the study of bordering, ordering and othering processes through law in the academic sense, but also in the practical and social legal sense. So it constitutes an excellence hub for intellectual collaboration and the evaluation of the role of law in the making and unmaking of borders in the broadest sense of the word, and their impact on global immobility. Our aspiration is to connect scholars and practitioners and all sorts of interested communities within and beyond Queen Mary Law School to harness existing inter and multi-interdisciplinary research into law, borders, and immobility, and shape future policy and research agendas in response to global challenges. So without further ado, let us begin with the first roundtable. I'm going to introduce the speakers very briefly before passing on the floor to them. First, we're going to be hearing from Catriona Jarvis. She is the co-convener of the First Rights and Last Rights projects of Mythoria and is a former judge of the Upper Tribunal, the Immigration and Asylum Chamber. We will then pass on to Dr. Nicolette Busuttil, who is a lecturer in law at SOAS at the University of London, who is going to be speaking about the role of disability, human rights in this field. We will then move to Malak Benslama Dabdoub, who is a doctoral student here at Queen Mary University of London, specializing on statelessness and the intertwining effect of that part of the law with refugee status determination proceedings. And last but not least, we're going to be hearing from Dr. Julia Joffe from UCL, who's going to be speaking about children and the right to family reunification in the context of the asylum seeking process. So thank you all very much to the audience and to my speakers. I pass on the floor to Catriona.
Violetta, I think we're still missing Katrina.
So, okay, who is joining online? So we should.
Online. So I just emailed her, and also I think you might have missed out Colin from the list, who is obviously also speaking on this roundtable. But maybe while we wait for Katrina to log on, I can just thank you and the OrderS Center, because you've absolutely made this possible. You know, it's just so rare that you get to organize an event like this, I think, and obviously it costs money. So the OrderS Center very, very generously sponsored all of this, and Violetta was there to support it. So yeah, definitely a big thank you to you and the center, and then obviously also to the Queen Mary events team, because we wouldn't have been able to pull this off in any way, shape or form without especially Gulsh Khatun and Maham Masood. So a very, very big thank you to those two as well. And I'm trying to see if Katrina is here yet. No, so maybe I can just keep waffling on a bit.
Please do.
I think it might be it's interesting to talk a little bit about why I wanted to do this. So Violetta has obviously already mentioned collaboration with practitioners, which is extremely important. And I think it's also worth pointing out, though, that we have some really, really interesting early career researchers presenting today. And I think one of the reasons why I wanted to organize this event is that I know so many amazing early career researchers who do amazing creative legal research, and whose ideas should really be put out there and be you know, celebrated and possibly translated into impact. So hopefully we can talk about that a little bit today. And then, of course, I know all these fantastic practitioners, some of them are in the room. I mean, I say I know them, I really follow them on Twitter. This is how I know them. Yes, and as Violetta said, like, the idea is kind of to think about how both sides, academics and practitioners, can work closer together to sort of pursue this shared goal of improving protection for asylum seekers, refugees, and other migrants. And then, of course, as academics, we actually are asked to generate impact. So it is one of the requirements when you're an academic to kind of show that your work has impact in the real world. And impact is actually often defined, and I had to write it down because it's such a long definition, as an effect on, change or benefit to the economy, society, culture, public policy or services, health, the environment, or quality of life beyond academia. And I do believe that a lot of academic research and legal academic research actually has the potential to develop impact in society, and especially in courts. So I'm hoping that today we can kind of, through this knowledge exchange event, take a little step towards generating some impact in the future. And I'm hoping that this is going to be useful for legal academics. Katrina still isn't here, so I'm going to keep talking. And it's really interesting that there isn't that much research available at all on how to really translate legal academic work into impact. Interestingly, quite recently, Lady Justice Carr gave a very interesting lecture at Keble College, Oxford, which was about the role of academic literature in judicial decision-making. And thanks very much to Professor Pierce for drawing my attention to that. And that lecture is available online, and I can really recommend reading it because it's super interesting. But overall, Lady Justice Carr is very positive about academic work, which is nice. And she thinks that judges and academics actually participate in quite a constructive dialogue with one another, because academic work, not only states what the law is and how it has developed and so on, but it also helps judges to think more critically about their decisions through reform proposals and critique. And we have one former judge with us today, and that's Katrina, who's just joined. So yeah, I'm very, very curious to see whether she agrees with Lady Justice Carr's positive assessment about academic work and what everybody else thinks. So I think that's me done waffling now, and we can actually start the roundtable. So Katrina, if you can hear us, I think you're first, and I'm going to hand back over to Violetta to chair. Thanks, everybody.
Thank you, Maya, and thank you, Katrina, for joining us. We've already done the introductions on your behalf, so we are ready. Absolutely no problem. I mean, this is the one of the magics of technology, that we can keep going and fill up a little bit of the space. So no worries at all. We've already introduced first rights and last rights on your behalf and your work as a former judge. So if you're ready to share your reflections on the issue that occupies us today, the floor is yours. You have around 10 minutes, if possible, and then there will be questions following up. Thank you very much, Katrina, for joining us.
Thank you very much indeed, and my apologies for being a little late. I was caught up in another meeting actually, and it was not so easy to extricate myself when I wanted to do it. But first, let me thank Maya for her kind invitation to join you today. Although, as I said to her in my reply to her invitation, I'm really not sure how helpful I can be, since I did retire some years ago from the judiciary. That said, let me turn to the question that she asked me to answer at this stage of our gathering: whether, and if so, how you engaged with academic work in your professional life. I shan't go back to the beginning of my professional life, we don't have the time today, but recalling the position when I began work in the field of immigration law to represent refugees and asylum seekers, there was no right of appeal against the decision to refuse to recognise a person as a refugee. All that could be done was to request an MP to place a stop on removal from the UK and to send written representations, otherwise judicial review at a pinch. And I don't recall there being any recourse at that stage to academic argument. And things were not much different when I became an adjudicator in February 1992. But then we had the Asylum and Immigration Appeals Act 1993, with, for the first time, its substantive right of appeal to someone called a special adjudicator, as well as other rights of appeal. And this act opened the door to a new world, including much greater focus in the UK on the legal meaning of the content of the act, as well as the legal meaning in particular of the 1951 Refugee Convention. And from 1993 until the early 2000s, following the coming into force on 2nd of October 2000 of the 1998 Human Rights Act, was a deeply interesting time in terms of the development of use of academic argument and evidence within this field. And I became much involved in judicial training and endeavoured to enable my colleagues to hear from academics and experts in a number of relevant areas, including Jim Hathaway, drawing on Graham Madsen, and Guy Goodwin-Gill. And at first, there was what might be described as reluctance or resistance to the use of any academic arguments at all. And certainly arguments that originated from across the pond or elsewhere outside the UK. And it was the view of some that no recourse should be had to the views of academics. And there were, as Lady Justice Carr cites in her speech of May this year, to which Steve Pierce has helpfully referred us, they were to be seen as dangerous distractions divorced from the realities of judicial decision-making. Gradually, judges and practitioners began to open their minds and to develop an understanding of how to put academic approaches to effective use, especially after the coming into force of the Human Rights Act, as I mentioned, which brought with it a new set of rights that were justiciable in the UK. And we could benefit from the work of many academics, not only from the UK, but internationally, such as Philip Alston, Jane McAdam, Mary Crock, Geraldine Van Buren, Anne Skelton, Ellsworth Guild, and Steve Pears, of course, just to name a few. And in fact, the contribution of academics to the development of immigration, refugee and human rights law and European Union law, including children's rights, in both the 20th and 21st century has, in my view, been profound. And separately, there must be acknowledged the important role in these developments played by those who've given expert evidence on matters such as those concerned with anthropology, country-specific reports, including, for example, Dr. Anthony Good, linguists such as the eminent late Professor Jan Blommert, a Belgian linguistic anthropologist who sadly died in 2021, but whose expert evidence concerning the weight to be given to language or languages used by a particular person were of immense assistance to judges such as myself in cases where it was said that a person couldn't be from country A because they spoke language B. Another key area has been the contribution of academics in relation to EU law, and in my view, judges and practitioners alike struggled to come to terms with EU law, and their work would have been all the harder without the input that we've had from those who I've already mentioned, and obviously other academics also. There's not time for me to mention here every academic or every expert whose contribution has been appreciated. And it must also be said, of course, that like all of us, contributions have varied in their quality and their relevance. I want to quickly mention the case of ZH Tanzania. That was a case before the Supreme Court in 2011, where the court turned its mind to whether and when it would be permissible to remove a non-citizen parent of a British child from the UK, and also more broadly, the weight to be given to best interests of children who are affected by such a decision. And Lady Justice Hale was among the justices who heard that case and was, of course, herself an academic before becoming a judge. And we don't see it set out in terms in that judgment, but we know that the Supreme Court had the benefit of a great deal of written evidence from academics and heard about it in detail in submissions, including from the work of the already mentioned Professor Philip Alston, going to the interpretation of the rights of the child. And the Supreme Court unanimously held that the best interests of the child had to be considered and given paramount weight as part of the assessment of proportionality under Article 8 ECHR. And as it was put by Lord Kerr, it is a factor, however, that must rank higher than any other. It's not merely one consideration that weighs in the balance alongside other competing factors. Where the best interests of the child clearly favour a certain course, that course should be followed unless countervailing reasons of considerable force displace them. And in my view, it's for the party advocating that displacement to demonstrate cogent reasons why there should be a departure from that which has been assessed as in the best interests of the child. And such is the lack, I would say, of case law and legal reasoning concerning best interests and its content, its meaning, its application. I would argue it could only have come from academic evidence. In my view, it's been key always that judges, practitioners and academics meet regularly in a space where their thoughts, ideas and arguments can cross-fertilise. And I recall saying, it's a slight aside, but I recall when I was speaking on being a feminist judge at an event in London in 2017, that I concluded by saying, let us dare to hope for a female president of the Supreme Court and a female Chief Justice in the near future. So mindful of the time, I'll conclude with a brief reference to the words of Lady Carr. It's undoubtedly true that academic opinion can be instrumental in creating new legal doctrine, correcting apparent errors or deficiencies in the law, and providing food for judicial thought. Academic scholarship is vital, helping us to reach law that is conceptually, morally, and legally sound. Thank you.
Thank you very much, Catriona. Thank you very much. That gets us started I mean, provides us a great overview of historically what has been the interaction. At first, a bit the hostility or the suspicion with which academic work has been perceived by the bench, and how that resistance has slowly been overcome, and the dialogue has flourished instead. And so to continue in that direction, I'm going to give the floor now to the three academic presentations so that they can benefit then from your reactions before we open it up for discussion with everybody else. So oh, apologies, I'm receiving some instructions by Maya here.
I don't know why. I don't know why you have a version of the program where Colin isn't mentioned, but it's theoretically Colin's turn next.
Right, apologies for that. I have apologies. I have a version of the program that doesn't include Colin in as a speaker on the first panel, maybe because I was under the impression that he was only going to be providing the keynote. Apologies for that. So Maya, should we hear from the academics and then back to the practitioners and then back to the academics and then general discussion, or how do you want to proceed?
Well, the original idea was to hear from all of the practitioners, then all of the academics.
All right.
The practitioners sort of give their thoughts about the academic presentations, and then we can have sort of a bit of a back and forth in a discussion. But Colin has
Colin has views, actually. Focusing on preparing the keynotes, so it might make more sense if I sort of respond to what other people have got to say.
Well then, let's do that.
Please do that. Yeah, thank you.
So, thank you, everyone. I'm going to try and share my presentation first. Violetta, if you can indicate at some point whether you can see that on the screen.
The video from the room is pinned, so let me see if I can unpin it so that we can see the slides. 1 second.
That?
I actually think I cannot do it because I'm not the host.
What's pinned for you?
Can you see my slides, ma'am?
I can see the slides fine now.
Okay, so
Okay, yeah.
Violetta is controlling the screen. All right. Good morning, everyone, and thank you to Violetta, who I haven't seen in a while. So hi, thank you very much to Maya for bringing us all together, and of course all of you for whether in person or online for being here. I apologize. I'm going to stand up because I struggle to speak when I'm sitting down. Following on from Catriona, of course, a very tough act to follow with all her years of experience. And I'm going to be speaking from the academic perspective about a topic, about a group of people who I consider to be one of the populations that remain largely overlooked in the consideration of claims for protection, whether this is in the context of refugee status or whether it is in a broader forced migration context. And in fact, the work that I will be presenting today started out as part of my PhD a few years ago now, but it is work that I really think can do or can spark a conversation which is similar to what cases such as ZH Tanzania did for children, in that the way in which the law, the courts, which practice has changed to accommodate claims that are made by children who happen to be non-citizens is a revolution or an evolution in the protection claims of non-citizens with disabilities that can be brought about by the Disability Rights Convention, so the UN Convention on the Rights of Persons with Disabilities. Now, my key argument today relates very much to a subset of persons with disabilities, those whom traditionally and inaccurately, or rather pejoratively, we would have referred to as the mentally ill, right? But which under international human rights law, we will now refer to as persons with psychosocial disabilities. And before I actually present the argument, I would like you to keep in mind two specific contextual points, which I hope frame how we approach the way in which the law, the way in which migration, refugee law can look at claims that are presented by this population. And that is traditionally acknowledging how traditionally the law has been weaponized against this population. We don't need to go very far back, but even if we do, traditionally the law has been weaponized against persons with disabilities. Most egregiously, of course, we can only think of the Nazi regime and the extermination, right, of persons with disabilities, where people, this cohort, were seen, and in this case, citizens, as useless eaters, right? Persons who are such a drain on resources that we couldn't even contemplate letting them live and depriving them of the right to life itself. But of course, the law over here, although there was a legal basis for it, the law has also been weaponized against persons with mental health issues in other contexts and much more recently. Whether this has been how, in the evolution of human rights law, persons with mental health care needs were left behind from the equal protection of the law, in places and spaces such as when we speak of sectioning and the forced deprivation of liberty, but even so, the extent where healthcare, that which was presented as treatment for the purposes of helping individuals, ended up being persecutory or ill treatment in itself. Yes, we have all seen, or One Flew Over the Cuckoo's Nest, we're talking about Nurse Ratched, lobotomy and all that. But what I would like us to consider in this presentation is that even what we today consider to be acceptable forms of healthcare has, under international human rights law, been reconceptualized as harm. So when I speak of the possibility of looking at how the understanding of harm in expulsion claims has evolved over the years, I would like us to think of disability human rights. And by this, as I will explain, I refer to situations where the Convention on the Rights of Disabilities, improvements in the rights of persons with disabilities have changed how we see that which we have long understood as legitimate healthcare practices. I hope to do this by looking at a few selected rights to think about implications for mental health care, and then, of course, try to sum up by considering what, if anything, does this tell us for our individual who is before the court, whether as being assisted by a legal practitioner, whether, so at the point when the claim is being examined, and that person is saying, if I go back, if you send me back, it is not just a question that I am sent back to no healthcare. Even if healthcare is available, it is not appropriate. And by appropriate, here I mean rights compliant. So my key claim is, I'm asking you to, yes, think of the Paposhvili cases, the Savran cases, so like at the supranational level where the European Court of Human Rights and other entities have considered those cases, but I'm not asking you to focus on the exceptionality claims that the court makes in examining such cases. I am asking you instead to consider that the assessment of the harm feared shouldn't just remain at what we have traditionally considered legitimate. Instead, it should integrate disability considerations based on what the CRPD and international human rights law now considered as legitimate. And here, very briefly, what are disability human rights? I have been speaking about the adoption of the Convention on the Rights of Persons with Disabilities. Some or a lot of people will say this marked a revolution in the acceptance of the equal rights of all persons with disabilities under international human rights law. I say it is an evolution because when you look at even the incremental changes that happened over the years, yes, the CRPD is a watershed moment. and in particular for the rights of persons with mental health care needs, persons with psychosocial disabilities. And firstly, the first thing to point out is that where traditionally persons with mental health issues were somehow seen as different to persons with disabilities, the CRPD reintegrates these groups. So there is no question that persons with psychosocial disabilities, mental health care issues are entitled to the range, okay, of rights for persons with disabilities. Earlier on, I was speaking to one of the participants, and we were talking about, oh, there is now the social model of disability, a human rights model of disability. And yes, one of the big things that the CRPD has brought about is the understanding that we are not focusing, when we speak of disability, we are no longer focusing on the deficit that resides within the individual, but disability is very much a question of what happens when barriers interact with an individual's impairment. From the legal perspective, what this entails is a clear obligation on the state, not just to provide support, but before that, an obligation to dismantle the barriers that preclude that effective enjoyment of rights. And in this sphere, the CRPD committee, and even in other fora, we have it very clearly set out that we have the entitlement of all rights to all persons with disabilities without considerations of migration status. And although it should not need to be said, that very much includes migrants and refugees. Implications for mental health care, very briefly. Yes, we do have an obligation, and we have had this, right? The right to health, which is somehow always brought up as if it is an afterthought, even though we have had improvements in recent years. Access to good quality healthcare. The CRPD gives us a much broader understanding of what care is about. Care is not just about the medication that is ingested, that is provided, that is available. Care can mean support systems. Care can mean people who are there involved in the person's recovery or ongoing maintenance of their condition. The Court of Human Rights in Savran, in the first chamber decision, recognized this and gave a particularly good description of how important support people can be to the individual's management of a condition. Of course, the Grand Chamber disagreed, but we do have a broader understanding of care. At the same time, huge treatment gap globally because of the amount of healthcare that is needed and what is actually available. But that, I would say, is old news, right, for the migrant and refugee sphere, in that we know that this is the situation. The problems start, or rather the protective potential, is when we discuss what qualifies as appropriate mental health care. Healthcare that must be appropriate in both its nature, right? So no, lobotomies, cutting off someone's frontal lobe or whichever part of the brain is torture. It's never to be accepted. But also now we start talking about appropriateness in delivery, where what we have long considered to be treatments can now be reclassified as a human rights violation. And apologies, I had a slide on this, but it seems not to have made it here. So what are the rights in the CRPD that can therefore tell us more about what we need to look at in the assessment of harm? We do not just stop at the fact that healthcare is available. We look at whether that healthcare involves the non-consensual treatment. We look at whether healthcare also is delivered against the person's right to integrity. We look at, in particular, the role of mental health legislation. We look at the extent to which that person will be subjected to a regime that deprives them of choice, not choice in terms of what kind of treatment to get, but choice about deciding on the very essence of what we would consider the individual's private life, right? In that, am I going to be forced to accept medication that I don't want? Am I going to be sectioned? Am I going to be exposed to a regime of coercion, compulsion? simply because I have a mental illness. Now, this is not without, or rather this model, right? The argument that has been made is that the CRPD prohibits all forms of non-consensual medical treatment, for example. And this is where the Geneva impasse that Martin and Gurbay here have articulated, which refers to how even at the level of international human rights law, we have very different understandings of where the boundaries lie. So, for example, whilst in some quarters, forced hospitalization is never an option, regardless of the risk to that the person might be in other fora, the right to life has emerged as well. We have obligations under the right to life. So the obligations under the right to be deprived to liberty will necessarily be considered subordinate thereto. I do not purport to have a solution to that beyond the fact that it is, I would say, in the expulsion context, just like in all other healthcare contexts, we have an obligation to consider these main 3 points, which is considering mental health care in light of this new understanding of universal legal capacity, potentially allowing that coercive mental health care can be ill treatment in some contexts, and in the rejection of coercive care, not just following or relying on traditional understandings of the right to life that in order to save your life, we must treat you and detain you. But think of the model of mental health care in a much more disability-friendly way, which is go back to that conception where it is not just about dismantling barriers, but it is also about the provision of support to the individual. I conclude by asking you to consider, well, thinking about this model, thinking about these changes that have been happening at the level of acceptability and appropriateness of mental health care, how can we translate this into the expulsion context, into the protection context? And I would say that a good place to start would be, first of all, prioritizing the individual migrant status as a person with disabilities rather than as an ill person whenever we have mental health care issues that are involved, and engaging in much closer scrutiny of the treatment that is required and available upon return. Not necessarily by reference to our current entrenched notions of what is appropriate mental health care, but being open to this newer, or rather to this more comprehensive idea that is presented by disability human rights, which is meant to speak more as to what it means to be really human, enjoying one's rights. I remain open to questions, and I hope this was just an introduction. I'm very happy to continue the discussion in the response and later on. Thank you very much.
Thank you. Thank you very much, Nicolette. Thanks. Thank you. Thanks a lot. I think we are going to be hearing from the 3 academics before hearing from our practitioners, including Colin, if that's all right, so that there is all the elements we need for the discussion put on the table. And so in that spirit, I'm going to directly give the floor to Malak Ben Slamat Abdub, whom we said is at Queen Mary University of London. She's a PhD candidate with us, writing on statelessness. And so she's going to be discussing statelessness in the refugee status determination procedure. Malak, the floor is yours. Again, you have about 10 minutes. Thank you very much.
Thank you. So let me just share my slides. Okay, can everyone see my slides?
Yeah, if you click presenter mode, then we should be able to see in the large screen. Yeah, brilliant.
Okay, perfect. Thank you, Violeta, and thank you, Nicolette, for this very interesting presentation. So after this insightful presentation on disabled people, my presentation is going to focus on another category of refugees with special needs, which are stateless refugees. So there's an important amount of academic literature and interest when it comes to the refugee status, but there is a second status that provides legal protection and is very important, is very useful, which is the statelessness status, but it has traditionally been under-researched by academics and underused by practitioners. So this is what I'm going to focus on, that refugees that are also stateless and how the statelessness status can provide them legal protection. So the definition of a stateless person, which can be found in 1954 convention, refers to someone who is not considered as a national by any state under the operation of its law. This is the definition of statelessness. Now, just like the refugee definition, the convention provides a definition of what a stateless person is, but it doesn't tell us how to assess whether a person is stateless. It doesn't say anything about the stateless determination procedure. So it's up to state to decide how to establish statelessness. And again, underused form of legal protection. The UK only put a statelessness determination procedure in its legislation in 2013. That's quite recent. So there's not much case law about it. Although I try to argue here is that the statelessness status can provide an important form of legal protection. So first of all, we have to understand that there was overlap between refugeehood and statelessness. So if we are a practitioner, we have a client who's a refugee, let's have a look, let's pause a second to consider whether they are stateless or even at risk of statelessness, because refugees are vulnerable to statelessness, especially when they cross international border. Stateless people are more vulnerable to deportation and persecution. Making someone stateless by stripping them of their citizenship or by preventing some people to give citizenship to their children, that can represent persecution. Here I'm especially thinking about Palestinians, Kurds, Bedouins in Kuwait, these ethnic minorities that have traditionally been persecuted, especially via statelessness. Another thing that shows how statelessness and refugeehood are intertwined is the fact that the Statelessness Convention from 1954 was actually meant to be a protocol to the Refugee Convention. They were supposed to be part of the same convention, and they both stem from the same drafting materials. At the end, drafters decided to separate them both, which I think they shouldn't have, but that's another topic. So that many stateless people are refugees and many refugees are stateless. So why the stateless status is very important, and we need to take this into consideration. So if someone is refugee and stateless and come to the UK and they apply for the refugee status, and that's not accepted for different reasons, because it's not easy to prove. You have to prove that you have a well-founded fear of persecution, that it is linked to one of the 5 convention grounds, and because of the way international law is made, sometimes some people are eligible to the refugee status, but they are rejected, although we know that they should be provided protection. In that case, if they happen to be stateless as well, they can apply for the statelessness status after the asylum claim has been rejected. So it doesn't prevent them from applying to the statelessness status, and the application is free. And if they obtain it, if they are successful at obtaining the statelessness status, they can stay in the UK for 5 years, and then they can apply for settlement after that. So stateless status offer a lot of rights and protection. Because the 1954 convention, 1951 were meant to be the same convention, the Statelessness Convention is literally a copy-paste of the Refugee Convention when it comes to rights and protection, when it comes to all basic rights, especially freedom of religion, protection against non-discrimination. It's literally almost a copy-paste to the refugee status. If they're successful as well, their family members can join them here in the UK. Now, in order to secure the statelessness status in the UK, you have to be in the UK, like the refugee status, not recognized as a citizen of any country, not hold the citizenship of any country. Also prove that you're not that you cannot live in any other country. So this fourth condition was actually added by the UK. It's not in international law. They're trying to make it more difficult, but the way it is. So a practical example, if we have, let's say, stateless Palestinian who is married to an American citizen. She is stateless, of course, but she'd be eligible to live in the US as a spouse of her. So in that case, you have to prove that not only you're stateless, but you cannot live in any other country. And you have also to prove that you're not falling under one of the exclusion clause, so that you do not represent a threat to security, or that you do not benefit from UNRWA services, which normally they shouldn't do that, but it's okay. So the Palestinians that benefit from UNRWA services are excluded from the 1954 convention, just like they excluded from the Refugee Convention. The problem with the statelessness status, and this is why we say if we have a stateless refugee, it's better to first try the refugee status, and if that fails, to move on the statelessness, because there is no right to appeal for the refugee status, for the statelessness status. So sorry, there is only a right to administrative review. So how to prove statelessness, and this is what the challenge lies. The standard of proof is the balance of probabilities, and the burden of proof is actually on the applicant. So they have to prove that they are more than likely to be stateless. So the burden of proof is on the applicant, but the caseworker is expected to collaborate, especially in instances where available information is lacking. So some stateless refugees who cross international borders will have their identity documentation stolen or destroyed, and it will be much more difficult for them to prove that they are stateless. So we rely on identity documentation, testimonies. For example, the applicant can try to apply for citizenship in their country of origin, and if they receive a letter from the embassy saying you are not eligible, they can use that letter to prove to the Home Office that they are stateless. So I'm going to wrap up here. So the statelessness status offers a great alternative legal protection for stateless refugees who might not have obtained the refugee status, who might have not been successful at securing an asylum claim. So these rights and protection are the same as the refugee ones. It includes right to religious freedom, protection against discrimination, right to travel and own their own identity documentation. But unfortunately, not many people know about this, and there's not much case law about it. For example, my father-in-law, he was stateless refugee, and when he came to this country, he applied for the refugee status, but it was rejected for, I don't know why. And he could have secured legal protection via the statelessness one. He was eligible as a stateless person, but his lawyer didn't know about it, or I don't know why. And in that example, you can see how the statelessness could have saved him. He managed to stay for the reason, but it's a concrete example. The statelessness status is almost as protective as the refugee one. The only thing that the refugee status has that the statelessness does not is the protection against non-refoulement, and the fact that the convention says you cannot penalize a refugee for crossing borders irregularly, but you can do it for a stateless person. Now, that being said, the UK doesn't respect that thing for the refugee. And also, it's an underused form of legal protection statelessness. We don't have much case law about it. However, there's been a growing academic interest within the recent years. And in 2013, the UK passed a legislation establishing statelessness determination status. So it's there. It offers legal protection. So I encourage practitioners to use it as much as possible. Thank you.
Thank you very much, Malak, for such an insightful summary of the challenges facing the statelessness regime and the potentialities of its use as part of the RSD strategy that litigants could use in their own submissions to courts and elsewhere. I'm going now to pass the floor to Dr. Julia Joffe from University College London, who's going to be speaking about asylum-seeking children and the right to family reunification. So we're going to be moving from one topic to the next, and then opening up the floor to our practitioners, commentating on the different strategies and points that the academics have put on the table. So Julia, thank you for joining us today, and the floor is yours.
Thank you. Sorry about this. Yes. Okay, perfect. Thank you. So today I will be talking about a right to family reunification of children seeking international protection under the Convention on the Rights of the Child. And this work is based on my recent article published in International Journal of Refugee Law. When I talk about children seeking international protection, I mean children who are recognized as refugees, but also the ones who are seeking refugee status, but any other humanitarian status, including complementary subsidiary protection. So, although my argument is based on the Convention on the Rights of the Child, the core of the argument is based on the weight of the best interest of the child and what kind of weight should be assigned to best interest of the child in the cases of family reunification. Although in my article, I focus on the right to enter territory. So for example, when an accompanied child who has a refugee status applies for family reunification for their family to join in the territory, it also can be applied in deportation cases, and the case, as we heard, similar to ZH and Tanzania. And probably it will be easy if I'll show the text of Article 9 of the Convention on the Rights of the Child. So the starting point of my argument is that for some reason, Article 9 of the Convention of the Rights of the Child has been considered to be applicable only to children within the territory and to children citizens. And with regard to children who are seeking international protection, asylum-seeking children, there has been an agreement that Article 10 of the Convention on the Rights of the Child is applicable. And you can see from the text of these articles that they provide different sort of protection. So Article 9 talks about this strong obligation of the child not being separated from their family, from their parents. And Article 10 only talks about this, the obligation to deal with application for family reunification in a positive, humane, and expeditious manner. So we can see that Article 9 is a obligation of result, that the children shouldn't be separated from their parents and their families, whereas Article 10 is an obligation of context. So the application should be dealt in a humane way, but it doesn't mean that it can't be rejected at all. There's no obligation not to reject such application. So my main argument is that Article 9, in fact, applies to refugee children, children seeking international protection. As a result, it would provide entry in the territory of the state for purposes of family unity. And I criticize the prevailing academic view that considers that Article 9 and Article 10 are completely separate. A side argument of this is that the child best interest principles, and I'll discuss it in a few minutes in more detail. Actually, Article 9 assigns
not just primary consideration to the best interest of the child, but paramount, which is a higher threshold for considering best interest of the child. And I argue that this kind of high threshold of best interest of the child principle should be taken into consideration in the proportionality assessment of Article 8 of the European Convention on Human Rights. So just looking at Article 9, we can see that there is no express text that would exclude asylum-seeking children from the scope of this article. So there is no indication whatsoever that the scope of Article 9 is limited, and I'll show the entire article right now. So, and you can see, for example, paragraph 4 expressly talks about deportation. So if it would cover only children citizens or children within the territory, it would be illogical to mention deportation in the same article. Again, you can see that the obligation to not separate children is quite strict. I argue there is a passive voice used in this article, so it doesn't matter whether parents decided themselves to get separated from children or whoever the actor of separation is, the obligation is still the same, that the children shouldn't be separated from their family. And the only reason why they can be separated is except when necessary for the best interest of the child. And the Article 9, paragraph 1 does talk about some examples when it can be necessary, but it's basically when a child, there is a case of abuse or neglect of the child. So all of these exceptions are connected directly to children. And in this way, Article 9 is different from other provisions in international law that concern family life. For example, Article 17 of ICCPR or Article 8 of the ECHR, in a way that in those provisions, family life is protected, but there can be interference in family life, but it shouldn't be arbitrary or unlawful. But Article 9 assigns another condition when children are involved. So in that cases, the separation or interference to family life should be also necessary for the best interest of the child. And in this sense, it's quite different from the formulation of Article 3 of the Convention of the Rights of the Child. So Article 3 of the CRC talks about the best interest of the child being a primary consideration in all decisions with regard to children. And there has been a lot of discussion in terms of what a primary consideration means. Philip Elson was mentioned. I think he wrote quite a lot about what a primary or the primary. There's a difference in terms of which even article you use in looking at it, but it is clear that Article 3, even though it establishes a primary consideration for child best interest, it's not paramount consideration, whereas Article 9, which we see from the use of the word necessary, does provide for the standard of paramount consideration. So basically, it is, or I argue that it's impossible to deny family reunification just because of immigration control arguments. It can be only the argument that is connected specifically to the child. And the reason why this argument hasn't been put forward in academic literature, but also obviously academic literature has influenced international bodies who interpreted the right to family reunification for children seeking international protection based exclusively on Article 10. So the reason for this interpretation, because you have seen that the text doesn't draw this distinction, the reason for this distinction is the one statement of a chairman of the working group drafting the Convention on the Rights of the Child. And you can see the statement on the screen. So basically, this statement has been then used by academics to draw this distinction between Article 9 and Article 10. For example, you can see these are just some excerpts from the commentary to the Convention on the Rights of the Child, and many scholars who the child scholars, but also scholars in refugee studies, rely on this one statement by the chairman of the working group during the drafting to explain why the scope of these provisions is different. And I argue that this interpretation is incorrect, because first of all, as I explained earlier, it's at odds with express language of the provisions, and we all know that according to the rules of treaty interpretation and international law, text is the starting point and is part of the primary rule of treaty interpretation. And this prevailing academic opinion that was also reflected in practice ignores the relationship between the preparatory work, and the statement of the chairperson was part of the preparatory work, and the other elements of treaty interpretation like text and context of the Convention on the Rights of the Child. And finally, even if we have a valid excuse to look into preparatory work, I argue that it has been misunderstood or misinterpreted. So I won't go into too much detail about treaty interpretation, but basically there are two main articles in the Vienna Convention on the Law of Treaties that set out a general rule of the interpretation that also includes text, context, object, and purpose of the treaty, and Article 52 that talks about supplementary means of interpretation, and the preparatory work is a supplementary means. So even from the name of the article, you can see that preparatory work can't trump the text of the treaty. It can be only a supplementary means in order to confirm the meaning that we already received after applying Article 31 of VCLT, if the meaning is ambiguous, obscure, or manifestly absurd. So I would argue it's not a manifestly absurd to think that refugee children have the same rights as children citizens. Similarly, it is quite, the text is not ambiguous. So one other way is just to look whether we can confirm the meaning. And if we look at the preparatory work, we can see that, in fact, there was no detailed discussion after that statement of the chairperson. In fact, the representative of Federal Republic of Germany declared that silence shouldn't be interpreted as support of the statement. Three other countries clarified the interpretation of Article 10, but they didn't agree with the chairman's statement. And also, if we look at the preparatory work as a whole, the convention was drafted over the period of 10 years, and Article 9 and 10 were one article, Article 6, and only in the last year of drafting, they were separated into separate articles. And if you look at other statements, for example, there was a statement by a representative of France who points out to entirely different interpretation and underlines that children, migrants or refugees, non-nationals should, their rights to family unification should be respected. So if we look at the preparatory work, it doesn't show us that there was any kind of support of this one single statement of the chairman of the working group. So again, I argue that it's advisable and desirable just to lean onto the general rule of interpretation and just text of the treaty, context of the treaty, and object and purpose that provides for children, if possible, that they should grow up with their family, surrounded by family, and that's best for their development. So, and one other part that I don't explore in this particular article, but I explored in my PhD thesis, is potential influence on Article 8 of ECHR and its jurisprudence. So there, and I think it's quite known that Article 3, or best interests of the child, is mentioned quite a lot in the jurisprudence, in the case law on Article 8. So far, there have been no cases specifically with this kind of scenario, but there were cases, 2 cases against France that you can see on the screen, where there was a question of family reunification, and the court did rely on Article 10, and not Article 9, but it also was a particular case where the question was not whether the right to family reunification existed, but there was a question of that it took a very long time. So I argue that it was logical to rely on Article 10 because this was not expeditious or humane to drag those procedures for years. But my argument would be that if there is a case at ECHR that looks at Article 8 and there is a question of entry but also deportation, they should take into consideration best interest of the child and best interest of the child, how it's outlined in Article 9 of the Convention on the Rights of the Child and not Article 3, because the threshold is quite different. And that would be also in contrast to the case that was mentioned in ZH in Tanzania, where the court did look at Article 8 of ECHR, but they considered that best interest of the child should have primary consideration instead of paramount, as I argue. If you would like more details, I refer you to the article that was published recently. Thank you.
Thank you very much, Julia, for this very detailed and original presentation on this original take on how to interpret best interests of the child clauses and how they can be mobilized to operate change. And so with that in mind, I'd like to ask Colin to come forward. You have your own reactions, but I was wondering whether you both, Colin and Catriona, could start thinking about when we will start the discussion proper. How do you imagine incorporating, I mean, first of all, whether you imagine this and how you would imagine incorporating the solutions that the academics have been proposing in your argumentations, right? Like, be it as part of asylum claims or as defenses against expulsion or refoulement, or when acting as a judge as part of the ratio decidendi of your decisions more broadly. So do you imagine this happening? How? And if so, to what extent? It would be great to perhaps reflect on the strategic value of doing this and the feasibility, considering the political sensitivities surrounding all of these issues and considering the current situation with the government of the day. And perhaps taking a step back from the nitty-gritty of the arguments that have been submitted by our academics, how would you generally think that academic research could support litigation and decision-making? I mean, are the production of articles a good strategy, or would you think that events like this should be fostered and cherished and perhaps sustained into the future? Or would, for example, I don't know, organizing strategic submissions of expert witness accounts or third-party interventions, amicus curiae, things like this, would that have value in your view? Or perhaps arranging legal clinics and initiatives like that for strategic litigation, when we would like to see a legal change of a very specific characteristic. So I put all of these questions on the table. I first give the floor to Colin and then back to Catriona. And perhaps with these elements, we can engage in a fruitful discussion. Thank you, Colin. The floor is yours.
Thanks very much. I think you've covered everything there, basically. So I think that's a big yes to all of those suggestions. So I've just been sort of scribbling some notes for myself on how academic work influences the law in a practical sense. And this isn't something that's really addressed by Lady Justice Carr, I don't think, in what she wrote. It's a really interesting, really good article. But there's a kind of assumption about academic work magically kind of influencing the bench. I'll come back to that because that does actually happen. Magic does happen sometimes. The judges just read your articles and attend your conferences, and then they directly adopt it. Or even as she says in the article, you know, they become judges themselves, which is a really good shortcut for academic work reaching the bench. But if the ideas start with the academics, how do those then influence judges? How does it have an impact on their decisions? Because the judges have to know about it, and that's, you know, how does that actually happen? So sometimes they will just magically read it themselves. They'll be reading key journals, and they'll be keeping up to date with academic debates. They'll have contact, you know, universities and Oxford colleges and so on, and they'll talk about these things, and that's great. It doesn't happen so much in our sphere, I don't think, in sort of refugee immigration circles. You know, there's one of the things we're going to talk about this afternoon is the kind of community of law, but I don't think that's quite so well established in our sphere as it is in sort of commercial property, sort of other areas of law. So that's slightly less likely to happen, possibly. So generally, there needs to be an intermediary between the academic and the judge, and that's the lawyer when it comes down to it. So it's the function that we can perform as lawyers. Don't look at me though. You know, I'm just a lawyer, and I'm barely a lawyer, quite frankly, at the moment. I'm extremely part-time in my practice. I do very little casework. I'm probably in court just about once a month or something like that. So it's not just, you know, it really isn't about me. It's about how are you going to kind of communicate with other lawyers who aren't in this room right now, basically. And the truth is that most lawyers, and I would very much include myself in this until relatively recently, just don't follow academic debate directly ourselves. I've been doing an awful lot of reading recently, which is related to the fact that I'm not in court as much. You know, if you're in court, if you're earning your salary or your keep as a lawyer, you know, you're in court a lot, or you're doing a lot of casework. You just simply don't have the time in a lot of cases to be reading journal articles, which are sometimes a little bit difficult to read, you know, just a little bit. And you know, that's just not something that, it's not something that you would even think that you don't have time for. It just wouldn't be on your radar. You wouldn't even conceive of doing it, quite frankly. So there is a bit of a barrier there. There are some lawyers who are a bit different, who we might describe as pioneers or pathfinders, often lawyers who are not as busy in court because they've already, you know, gone up the scale a little bit. They're sort of top end of the legal profession. They're therefore not in court day in, day out. They've got the time to devote to a bit more wider reading, a bit more discussion. They've got kind of wider contacts in the academic world. Because they're getting paid a lot for the cases they do, basically. And once you reach a certain level of seniority, you don't have to be in court as much because you're getting paid more for the cases that you're doing. So you've got a comfortable life without having to do quite so much actual casework. And because you're experienced, you know, you can command higher fees essentially. And those kinds of people are the sorts of people who might have the time to read academic work and engage sort of directly. But for other lawyers, we're not kind of completely immune to influence from outside. You know, we are potentially open to influence through, for example, training courses, through attending conferences. Just when we were having coffee downstairs, I was regretting with a couple of people that I hadn't been at the RLI conference last week, the Refugee Law Initiative conference. I should have gone. I should have made myself go. I looked at it. It was a 3-day program. None of it was directly relevant to sort of legal practice, really. I mean, it's a bit harsh, but you know, 3 days, it's a long time for a lawyer to go to a conference. And maybe some practitioners did make the efforts, and I should have done, but didn't. Related to that, I've got some pamphlets that I sort of my publishers, my refugee law textbook gave me, and I didn't take long last week. I should have gone. So I can hand over that. You know, those kind of, there are opportunities to influence, but again, you kind of, you know, training courses have to be about something that's useful to lawyers. Conferences have to be accessible to them. Actually, sort of getting even free courses, it's really hard to get people to get lawyers to come on even a free training course, never mind to get them to actually pay for a training course. And the same with conferences as well. So there are ways that these things can happen. Also, articles in journals or publications that lawyers are more likely to read, perhaps, than some of the sort of more academic journals. A lot of barristers read counsel, for example. They do have idea-based articles pretty much every month. Not a lot, but they do have them. I don't really know what the equivalent is for solicitors. I don't know if the sort of Law Society Gazette covers that kind of stuff at all. But there might well be other possibilities of kind of reaching out to lawyers beyond the kind of journals that are classically published in by academics, which of course, I understand to some extent that your ref ratings or whatever you call them depend on peer-reviewed journals and stuff, and ultimately don't necessarily get paid for writing in a more kind of accessible way that's aimed at lawyers. But if you want to have impact, if you want your ideas to get out there, then that's what you have to kind of do. And of course, nothing wrong with not doing that. Your ideas don't have to have impact. They don't have to be devised with impact in mind. But what I'm talking about is if you do want them to have impact, then you have to think about these things. So you need a way in. And I think you also need to understand that there's a certain generosity of approach in this, because if you want your ideas to have influence, you've got to let them go. You've got to let them out there, and you've got to hope that it influences people, and you're not going to get credit for it ultimately in a lot of instances. Your kind of best case scenario is that the idea just gets out there, it percolates, and it becomes some sort of new norm, and it's not the Yo thesis of this or that or whatever. It's just a really obvious idea. It becomes a really obvious idea that everybody thinks was always there. That's kind of what you actually want to happen, which means letting it go, and it means being generous in your approach. In terms of sort of directly ways in, influencing court cases is obviously how you generally influence law. I suppose one of the things I might talk about a little bit this afternoon is the other way to influence law, which is through policy making and achieving legal change through legislation. But talking just about case law, there is one thing to be very aware of when you're dealing with lawyers is that lawyers are very short-term focused, and we have to be, because we are professionally bound to be. So there's always a tension between, and this very much happens in the sphere of immigration asylum, between the short-term interests of winning the case and the longer-term interests of winning the argument. And sometimes those two are perfectly compatible, but not absolutely always. And lawyers have to be very short-term about winning the case, not because we love to win cases, although we do love to win cases, but because we are professionally bound to represent our clients. We have to try and win the client's case. We have to do what we can to achieve that. Sometimes we end up running cases that do not have strong facts, that if we were following a really strategic approach, we wouldn't run them as the lead case, but we have no choice. We are representing the client. We just have to do what we can for them. So there can be something of a tension. Sorry, I looked away from my screen for a moment and it's disappeared. I want me to do a face scan, so we need to sort of zoom in for a second. So that's one thing to bear in mind. Sometimes there's no tension. So I thought it was interesting when we were talking about disability earlier, framing cases as being about disability rather than illness. That's sort of long-term approach. It's not incompatible with short-term success, though. Sometimes there are tensions there, but not in that instance, for example. So the kind of framing can make a difference, perhaps. Typically, you need a peg from which to hang a legal argument. So it's all very well having abstract ideas about interpretation of things, but how is that actually going to find its way into a case? How is it going to actually influence an outcome? Katrina talked earlier about the creation of rights of appeal in refugee cases in 1993. We can liken the creation of a statelessness procedure to that kind of process. We can liken the creation of trafficking protection mechanism, the NRM, to that kind of process. It gives all sorts of extra opportunities for influencing particular terms that are used in the law, for importing ideas from international case law, from international conventions and jurisprudence and so on. So there are real opportunities that are created by that. Katrina, again, she talked about ZH Tanzania. It is a really good example of how an international convention that isn't necessarily that useful in court directly, because judges, just aren't interested. Basically, you try pleading the CRC if you're doing an asylum case. Most judges will just sort of smile and they'll nod and then they'll ignore you. Whereas if you relate it to a convention that they do understand, like the ECHR, which is enforceable, it is judiciable, then you can have some influence that way. And ZH Tanzania is a really good example of that. And children's rights are an incredibly frustrating area to work in, because if you're talking about just the difference in approach between the family courts and the immigration courts, it's just absolutely incredible to my mind. But say, for example, if you talk about refugee children, it's a bit different to British children or to migrant children, because often the answer for the Home Office and for a judge, if you say, well, I've got a right to family reunion as well, that's fine. You can be family reunited over there. It doesn't have to be here. We're not separating you. It's your parents who are separating you by not taking you with them when they go, or something like that. Whereas with refugee children, it's a bit different. There is a bit more opportunity to argue, well, the refugee child cannot leave the country because they're a refugee, and therefore there's an opportunity to import arguments, which then might also, once judges are more familiar with things like Article 9, Article 10, might have wider influence. But you need that kind of peg. You need some sort of solid legal argument you can hang it from. And the CRPD again could be like the CRC. It can be used as an interpretation aid through Article 8. It's not, I'm not saying it's easy to do, but it can be helpful. And just to give you a slightly sort of trivial example from casework I've done, I've successfully argued, and this is not a particularly radical argument, I think, to have succeeded in, that enchainment in Somalia is kind of, it certainly was, I don't know if it still is, a sort of just socially acceptable de facto way of treating serious mental illness, and that is a breach of Article 3. It's not a particularly radical proposition, I don't think, but you can sort of use those arguments, and there's the potential to widen out concepts of what is inhuman, degrading, and what breaches your private life as well. And there is case law to help us try and kind of lever things open a little bit and have an impact. So I'll just end this bit by saying, have a think about what not just whether the ideas might conceivably be useful at some future point in the abstract, but how they might become so, and how to actually get them to the people that matter, and how they might therefore make use of them. Okay, I hope that was helpful.
Thank you, Colin. Thank you very much. So with these reflections in mind, I'm going to go back to the panel so that they can react. Sorry, no, we're going to hear first from Catriona, and then once we have the two sets of reactions from the practitioners, then I'll return to my academics so that they can have a round of reactions. Because I'm just mindful of the time, and we need to have a general discussion too. So let me collect Catriona's insights on this, and then I'll return to the panel.
Violetta, do you want me to reflect on the wider points or on the presentations?
We can do both. I mean, we can take it from the presentations and then go to the wider points, or vice versa, whichever you would prefer.
Well, agreeing very much with everything that Colin has said, I think that was really helpful, whether I was in a lawyer's shoes or in an academic's shoes. I think very important to emphasize is his point about letting it go, be generous. I think you can't possibly expect to put the argument in one case and win and have it taken up, and things will change. You need to be in there for the long term, even if lawyers are in there for the short term. If you as an academic are wanting to create change, it is long term, could even be very long term. That doesn't sound, well, it sounds frustrating, I think, from putting a hat on from where you're sitting, but yes, be in it for the long haul. Yeah, I mean, my sense is that there would be initial resistance, potentially, from any of the arguments that we've heard so far.
Do you want to elaborate on that, Katrina? Why do you think there would be resistance? I mean, why would that be the automatic?
I may be wrong, because as I said at the beginning, I've not been sitting for some while now. I'm just reflecting on what I would say would be the kind of the general ethos of the presentation of what would be a new way of interpreting any aspect either of protection or defence against expulsion. Trying to recharacterize disability, which is not to say I don't think these are all great arguments. I think they are, and I think you should, all of you, pursue them all vigorously. Most definitely. And I think, well, again, because I'm not sitting, I don't know how much this is true of the judiciary, but certainly there's been plenty of discussion on changing our view of focusing on vulnerability, which hasn't turned out to be as helpful as we might have wanted it to be. Or perhaps it was helpful in the beginning, but as it's transpired, as not being helpful. It's just caused a narrowing, in fact, of those who can try to bring themselves within that category. Whereas I think in Nicoletta's presentation, the viewing the person with a disability in the way that from the angle that she proposes, has got so much more possibility for it now, I think, at the moment.
But the resistance, Katrina, if I can push you on that, will come from the perspective that these arguments would be perceived as opening the floodgates. Or why do you think? I mean,
yes.
If they are,
yes,
yeah.
I think that's a big worry. The floodgates argument, the cost argument, particularly in the UK. I mean, I'm not there, but again, that's a caveat. I'm not there. But what I read and what I hear, it feels to me like a place that's exclusionary, shall we say. How much that has permeated the judiciary, I don't know. Colin may have a much better idea than me on that. Statelessness, what was I going to say about that? I think there being no right of appeal, and thinking back over statelessness cases that I did deal with, the way that they came through, and I don't know whether this still exists anymore, was through a human rights appeal. And perhaps Malak can respond to that. Can that be a way in which you can appeal a refusal of statelessness through Article 8 or even Article 3? Certainly that's the way cases came before me, some of which did succeed.
Can I answer?
Shall we just give Katrina a chance to conclude her comments, and then I'll give back to you.
My sense at the time, and this may not be current either, and it may be because it wasn't used and people didn't know about it, there seemed to be a reluctance really to engage with statelessness applications and cases and appeals that came through human rights appeals. And maybe more work like you have done, Malak, is going to help on that front to make it much more familiar. So I think that's great. Yeah, I think that's all I would say for now. Thanks.
Thank you, Katrina. So I'm going to give back the floor to our academics to react to the points that both you and Colin have made on the papers themselves, but also generally on the wider reflections. And if I can add my own and push you a little bit on matters of feasibility and this point about being generous and letting it go, because obviously the definition we need to work with in our conceptualization of impacts for the purposes of the ref, right, that academics in the room would know what it is, the research excellence framework by which the work of universities is judged upon by, let's say, the government for funding purposes every 6 to 8 years or so, requires traceability of impact. So that would probably be a bit of a problem for the letting it go argument. So back to you. Let's perhaps begin with the order of intervention, and so here first from Nicolette, and then Malak, and then Julia, if that's okay.
Thank you, and thank you very much, Colin and Katriona and Violetta, for your comments as well. I mean, you've certainly given us food for thought, I would say. No, that's good. And I appreciate that it is a very different perspective. So I was really struck, I mean, by your point, by Colin's point about the tension that can exist between the short-term focus of working an individual case and the more strategic, longer-term vision as to there is something, I mean, which I would say isn't just restricted to strategic litigation, but from those of us outside practice, ultimately that is where we want to get to. But you're right, sometimes we forget about all the multiple steps that needs to happen along the way. At the same time, I am someone who, despite what I present, I do tend to think that change is incremental rather than like things are not, I'm not someone who believes that things change overnight. And I would argue that, I would say that looking at the disability rights movement and how that group maintains, kept up, right? The action in the face of attempts by legislators, by policymakers, by courts to kind of put up the most resistance possible is a really good example of why we should keep the hope alive. And I mean, when I started, so when I, just to give some background, and because you mentioned the legal hook, right? The legal peg that we can pin this on. So for me, the whole discussion, the whole research question of why we need to think about this came from my very short time as a practitioner years ago, when my practice was basically primarily migrants with mental health care issues who needed medication. So forget about even making arguments about whether they would be subjected to forced medication institutionalization or not. It was simply a question: an individual with schizophrenia being sent to country X in a place where there are 4 psychiatrists for the whole country. So obviously the way in was an Article 3 claim, and where the decisions are extremely restrictive. And I would say what we've seen over the years is we take what there is as, so we've accepted and normalized what there is, that low level of protection, that even when a case like Paposhvili and Savran come round, they are treated as somehow really improving protection, because the entry point has been so narrow that we're just grateful to get the crumbs, right? That we are so entrenched in this idea that it's migrant first, person later, person with whatever protected status, that and as a lawyer, you cannot, as a practitioner or policy, someone influencing policy, you do not have the space to do anything but that. So, and I think the value of being an academic is that we are given that luxury of taking a step back, keeping the overall hope alive, and trying to see what entry points there might be. And that is where I really take on board the feedback that both you and Catriona, like I noted down, like what roadmap so do we need to have in order to bridge that gap between doing research and then disseminating it beyond just, you know, to our students in the classroom who are really tired of us repeating the same argument and me getting all worked up about it. And I was struck by your, by Colin's comment on language and in terms of the discourse, the language in journal articles and the need to find alternative avenues for publication which speak more naturally to practitioners. And I would say that in those fora, it should not be a one-way street, because so far we've been talking about how academics influence practitioners, but I think we also, for those of us who do doctrinal work more than anything, we are also really grateful when the information flow is reversed, in that when we understand as academics what are the actual issues in practice, what are the developments, what can happen to actually take our arguments forward where our arguments have been tested. Because the benefit of letting go of an idea with all of the challenges that come with attribution for ref, etc., is also sometimes you say something and you have no idea that it's out there. So it's about maintaining that link so that it also comes back to you and you revise, I revise my own argument. Like this works, this doesn't, but I still believe it should. So I will continue making the academic argument for it until one day I live in hope that this might be taken up. I think I'll stop there so I let other people speak, but I'm happy to.
Thank you, Nicolette. Thank you. I pass the floor to Malak and then Julia.
Thank you, everyone. So first, I'm just going to answer Catriona's question about statelessness and the human rights appeal. So there is no right to appeal under the statelessness procedure, the statelessness determination status, but there is indeed an opportunity to appeal if you make a human rights claim. So for example, saying that not being granted the statelessness status would mean that I would get deported in a country where I would face torture, anything that would fall under the human rights ground. So there is this opportunity indeed that we have to explore. However, at the end, it's still an additional barrier. It still creates an additional condition for the practitioner to prove that there is a human rights claim, which is difficult. And this is why, again, if you're a refugee stateless person, you should first start try to apply for the refugee status, and then if that fails, including the appeals, move on to the stateless one. Because the problem with the refugee status is that many times courts do say to Palestinians or Kurds or even Roms, you do face discrimination in your country, that's very true, but not persecution, not to the point where you have a well-founded fear. But again, we need more case law because the stateless status in the UK has traditionally been underused. We as academics can also push for legislative reform, because in other countries like France or Spain, there is a right to appeal for the statelessness status. And then about how to bridge the gap, how Nicolette mentioned, how Colin mentioned, you know, these academic conferences that go for days, the fact that there's journal articles are not that accessible. I totally agree. We academics need to make an effort in terms of writing in a more accessible manner, in terms of our in terms of the language that we use, but we also have this restriction of publishing in academic articles, what you feel sometimes like if you don't use complicated words and show that you're intelligent, then you won't get published. In terms of accessibility to journal articles, not just the language, but also whether these articles are open access. The fact that so many articles, in order to make them open access, you have to pay money to these journals that, to be honest, don't really need it. But so these are some food for thought that we need to think about. I agree what Nicolette said about bridging the gap. That has to be the other way around. how we as academics also need to inform ourselves about what's happening in the practitioning world. For example, if we are conducting research, including court observation as part of our qualitative research methods, actually going to court, observing, noticing what happens. That would be one of the suggestions that I would have about reaching the gap. And in our research, take into consideration what Colin said about the fact that lawyers are short-term focused about winning the case, not just long-term focus about winning the argument. So when we are writing, think about actual practical ways in which we can both win the argument, but also help lawyers win cases. And that's it. Thank you.
Thank you so much for the comments. I take them obviously on board and completely agree, at least with regard to my presentation, my work, agree with Catriona in terms of the hesitance, I'm sure, from courts to apply this approach. I received quite a lot of hesitance from academic community. So when I tried to publish this article, I've been called a radical. So obviously, I agree that at least with my argument, it would require a significant shift in state practice, and I mean that's obvious, and I don't expect it to change in 1 second. I think previous speakers did talk about the change happening step by step. So if we look at the European Court of Human Rights and Article 8 case law, we can see that only like 10 years ago, the court didn't even cite any other treaties or didn't even look at other international law. But now we see more and more cases, for example, where they do talk about Convention on the Rights of the Child and best interest. So at least in my work, and that's the strategy that I applied in my research, including for my PhD thesis, to use the best interest of the child and the Convention on the Rights of the Child as an interpretive tool, as Colin mentioned, rather than trying to make this argument, which I think is theoretically correct, that, for example, the best interest of the child is a stand-alone right that should provide different protections to children, but they just can't see the working in courts in the near future. So in this sense, I think that there is a potential for slow change in the case law, at least for European Court of Human Rights, even though we all know that it's not very sympathetic to migrants for a while now. In terms of just touching upon vulnerability as well, this is something I'm working on right now, and I have noticed that again, for example, with European Court of Human Rights, they seem to be more sympathetic to children rather than to migrants or refugees. So that has been a strategy for a lot of NGOs and advocates to sort of push on this pressure point that refugee children are children, so they should receive this additional or special protection. However, again, it makes me wonder whether we are by pushing this agenda to protect this population, we sort of undermine protection for everyone else, including adult refugees, and legitimize certain forms of violence with regard to adult refugees. And again, this touches upon on the tension that Colin pointed out, that we're trying to sort of help immediate or solve immediate cases and win the immediate cases, but how this strategy will play out in the long term, we will see. And it's not obvious to me that actually this proposed ways to treat children refugees better would actually turn out for the best for the entire population of refugees. And just finishing on some of the reflections on academic work, it's true that we need to think about operationalizing some of our theoretical arguments, but again, there's this tension in academic work and academic community that everyone has this pressure to produce something that is critically reimagine the entire field rather than something that will win a certain case. So I think just being conscious of this maybe not completely aligned aims of practice academia is also helpful to find a common path. Thank you.
Thank you. Thank you both. Thank you all three very much. I have two questions on the chat box regarding the vulnerability frame and the use of the paradigm. And there are two, so they are quite concrete questions, but perhaps we can then take it from there and expand the discussion a little bit. But so the first question is regarding vulnerability matters and access to treatment. Swedish practice totally disregards whether an individual can afford necessary treatment. It is sufficient that treatment is available somewhere or somehow in the country, I imagine country of origin. Is such a practice in conformity with the Disability Convention or not? So this is a question for Nicolette. The second goes like this. Access to updated information on medical provisions is specific in specific countries is essential in assessing vulnerability cases. The European Union Asylum Agency has an expanded mandate and works on many aspects of vulnerability in the reception system. It also manages the MedCOI information database for the member states. So the question is, does Brexit mean that the UK has no longer access to this database? And perhaps we can add, what is the impact in such a case? And for all panelists, and so including Catriona and Colin too, would you think that the vulnerability frame could be used to strategically incorporate some of the arguments that our academics have put on the table? So could vulnerability be the vehicle through which we incorporate disability, statelessness, and or children's rights considerations on the table? And if so, what will be the feasibility and how far do you think we can go? Thank you. So Nicolette, perhaps you can go first.
Thank you. I will start with the second question about the UK's access to MedCOI following Brexit. I don't know. I don't know whether I would guess not, but if someone else knows, please do answer. What I would say is that the database itself, whilst it can be helpful, right, in presenting what is available in a specific country or what is, it still remains at the level of what is available in theory, where there is information as to why it might be, what might be available in practice. It is also extremely selective. And as an example as to how reliance on these databases can be quite problematic in healthcare cases, one only needs to look at the Grand Chamber's decision in Savram versus Denmark, where most of the argument that was made by the government, or the bits and pieces which the court picked up, was based on the availability of care as presented in the database, in the MedCOI database. And in fact, I mean, Savram, for those who don't know, concerned an individual in Denmark who was going to be returned to Turkey, a country he had not been for many, many years. He was someone that over here we would call a foreign national offender, someone who had really committed quite a lot of crimes and who said, I will not get the treatment I need for schizophrenia in Konya, the area of Turkey that he could go to. And in relying on, in fact, one of the arguments that he made, the applicant made, in terms of the reliability of the information that was used by Denmark to reject his case, is that, well, you know, it's not just about this particular database. It's if the court is saying that Denmark should have made inquiries as to the actual availability of care, you have a consulate there. You can do more than just rely on a particular database, cut, copy, paste, and use it in the rejection of his claim. With regards to the first question as to Swedish practice, I saw the question as, is it good enough that we remain at the level of what is available in theory rather than what is available in practice? I would say that even at the level of European Court of Human Rights, following Papashvili, it is clear that even at the level of like a non-CRPD understanding, it is not enough to focus only on availability in theory, but we also look at availability in practice. more specifically CRPD related, we have the case by the CRPD committee directly involving Sweden, which is NL versus Sweden, which would now be 2-3 years ago. Sorry, we were talking how since COVID, I've lost all sense of timing. But the case concerned the actual availability of mental health care. The availability of healthcare in Iraq, if I'm not mistaken. And it's, yes, I mean, whether it is non-refoulement under Article 3, whether it is non-refoulement under the CRPD, it is certainly not enough to focus just on availability of medication, support. In theory, availability and access must actually exist in practice. With regards to the final question, to your question, Violet, I think I let the other answer, so I don't hog the whole. Yeah.
Yes, so about the question about whether we can use vulnerability as a vehicle to incorporate disability statelessness during refugee. Personally, and that's my personal opinion, I don't really like the use of the word vulnerability linguistically. I think it's problematic for different reasons. First of all, there's a risk by saying this category is vulnerable, these people are vulnerable, that we might increase the stigmatization of certain groups, that we might actually order them. And this ordering process is very, very problematic, making them feel like they're different because of the position they're in. Especially when we're talking about people that actually want to show their agency. They don't want to be portrayed as passive victims that need saving from us, that are subjects of pity. We need to recognize their agency and their political experience of exile, especially when we come to refugees. They're not just passive victims. They make decision of, I will leave this country to go there. I will apply for the legal status there. I will try to integrate myself in here and not in there. So they have agency, and portray them as vulnerable just because they happen to have a disability or be stateless or be a child. I think it can be counterproductive. I understand that in some cases, vulnerability has created an advantage of highlighting a specific case, but I'm saying in terms of the terminology, in terms of the linguistics, I would argue more by, I would argue for using phrases such as these people have special needs. These people have a specific legal situation. Describing them as vulnerable, it can be disempowering, it can be paternalistic, it can be oppressive, and it can have the opposite effect. For example, UNHCR has certain categories of people that they automatically classified as vulnerable refugees. One of these categories are women and girls at risk. And in one of my articles, I argued that this actually reproduces patriarchal narratives by automatically assuming that women and girls in certain situations are vulnerable, are oppressed, need to be saved. So one of the arguments is to say, oh, the linguistic doesn't really matter as long as you win the case. Not really. I disagree with this. I think when you're a refugee and you apply for the asylum status, it's not just about securing the residence permit. It's much more than that. It's having legally someone, a state, recognize your political experience of exile, legally recognize that you have been persecuted, that you deserve protection because of your history. And I haven't met any refugee that likes to be portrayed as vulnerable, as a victim. And we, not just academic, but practitioners tend to do this. For example, one specific example that I have in mind was a Jordan asylum seeker, a woman who fled because she was victim of domestic violence, forced marriages, honor crimes, and all of these things. And in her written application, when asked what would happen if you were forced to return to your country, she answered, I would kill my husband. And her lawyer changed it to my husband will kill me because he thought she is more likely to secure the refugee status. She presents herself as a victim. And that is a concrete example of how we disempower women. We take their voices for strategic use. I understand that, but I think it's actually negative because it demands them the agency. I'll stop speaking now. Thank you.
Thank you. Well, I agree with everything Mark said that there are obvious problems with the vulnerability framing because it again takes away the voice of populations that we are pervertly trying to protect. We also treat them as homogeneous group, and when we talk about refugee children, there is obviously a difference between a 5-year-old and 17-year-old, and we in a way constructed this hierarchy of deservedness, and which has really has real results and real impacts on this population, and like mentioned with UNHCR. So if there is this hierarchy of deservedness and vulnerability, then the resources are allocated in this way, prioritizing vulnerable population. So there are obvious problems with vulnerability framework, but at the same time, I think the reality is that international human rights law developed through this vulnerability framework because it wasn't enough to, or we thought it wasn't enough to have only ICCPR, a general human rights treaty that would protect everyone. So the international community went in a way through this path of creating more treaties that would protect so-called vulnerable groups, including Children Convention on the Rights of the Child, Convention on Disability with regard to women. So in a way, we can't deny that there are these treaties that function through the frame of vulnerability, but they also provide, in certain cases, at least for children, some additional rights and protections. So I think, again, if you are a practitioner, it is a little bit, I think, impractical to say that, well, I'm against vulnerability and I won't use all these tools to help your client. Again, if we look at European Court of Human Rights, at least with refugee children, again, case law, they are basing all these decisions that are different and more protective with regard to children as opposed to adults by exactly using the word vulnerability. So I think we really need to think carefully, and I'm not sure what is the answer, that theoretically I think we are all on the same page that the vulnerability framework is problematic, but at the same time this is the existing reality that potentially we also need to use to protect as many people as possible and win as many cases for the clients. So there is this tension, and I'm not sure how to resolve it necessarily.
Thank you. Thank you. I'll give the floor to Colin and Katrina for the replies. And then if I cannot see the room, but if anybody from the audience in person would have questions, please do raise your hand and Maya will keep track of who has a question. Thank you.
Thanks very much. So I've just jotted down a few things to say in response to that. One was, I should have said this originally, I hadn't really thought of this, but use free movement. So I don't know why I didn't say that earlier, but you know, it's widely read by practitioners. You know, it's not that hard to put together a sort of 800,000 word piece for free movement that is aimed at influencing practitioners and giving them legal arguments potentially. It does have to be clear. Does have to be practical, otherwise we won't put it out there. We're not going to be putting out really abstract stuff, generally speaking. But yeah, it's there as a sort of potential facility. So get in touch if that's something you're interested in. I jotted this down before some things that were just said was said. Just as a kind of something I've come across with practitioners where people have been doing court observation, where they've been talking to people who've gone through the legal process, the court process, and for example, lawyers get criticised for not saying certain things on behalf of their clients. Well, sometimes there's a really good reason why we didn't say those things. So you know, when I'm as the barrister trying to speak to the judge, I've got about 10 minutes, generally speaking, at the end of a 1 hour, 1.5 hour hearing. After about 10 minutes, the judge is going to turn off, basically. And okay, you can say, oh, well, they shouldn't, but they do. Yeah. And I've got about that long to bring them round and make sure that they allow the appeal. And of course, I'm going to edit what I say. Of course, I'm not going to be focusing too much on the overall framing and the strategy in place for winning this type of appeal generally. I'm going to be focused on what I can say to win that appeal on behalf of that particular client. And vulnerability is one of those tools in the box. Exceptionality is one of the main advocacy tools we have. It is harmful to the cause in the long run, but it's what we often need to win cases in the short run. There's where the tension is. Yeah. So I have to make out my client to be exceptional in some way in order to win the appeal. I'm simplifying here, but that is one of our key strategies. And I'm aware that by doing that, I am ratcheting up the problems for future clients. But that's what I've got to do for the client that's in front of me at any given moment, because of the floodgates argument. That is an argument that is very powerful in immigration asylum cases. It's never or rarely made explicit by Home Office representatives. Judges rarely say it, but it's often, if not always, on their mind. And so vulnerability and exceptionality is really important. Our clients are often very critical of us for very good reason. We haven't written to them, we haven't told them this, we haven't told them that, we haven't said this, we haven't said that. It's all true quite often, but also you're only hearing half the story. And sometimes the clients, I had this great evidence that the lawyer didn't use. Yeah, well, that's because you gave it to us, as we were arriving at court, and we literally couldn't use it because it was against the rules. And we even applied to the judge, but the judge said no, or whatever. And clients often have an imperfect understanding. I think lawyers have an imperfect understanding of what's happening at court. The clients really do, and it's not a very accessible process. They are very much excluded from it. It's weirdly not about them, it's about their case, which is very kind of disempowering for them. But I can't do anything about that, generally speaking, when I'm at the Newport Immigration Tribunal and the judge is like looking at his watch or whatever. I've just got to do what I can for the client that's in front of me. However, I would say don't be too downcast. So all this stuff about the long-term damage of the vulnerability frame, well, I could eat these words over the coming sort of months, possibly, but at the moment I'm presaging something I'm going to talk about this afternoon. 75% of asylum decisions are positive. How many more of them do you want to win their cases? How much better could we be at getting these cases allowed by the Home Office? And then half of the people who appeal, who are refused, win their cases. We're talking about overwhelming success in the asylum system. So don't be too downcast about it. Now, the reason that I might end up eating these words is that that's not necessarily fixed. The success rate was a lot lower. It was about 85% back in the 80s. It was about 4% in the early 90s. It ran at about 20% for a very long time in the 2000s. It's been creeping up for quite some time, and then it shot up about 2 or 3 years ago. It could go down again. It could be that the Home Office is only deciding certain cases. They've got a certain prioritization system. They're doing certain national. I've looked through the stats. I can't see any evidence of that at the moment. I can't see them prioritizing the high grant rate nationality things. Everybody's grant rate seems to be going up across all the different nationalities. I'm not a statistician. I don't do that professionally. But as far as I can tell, as far as other people that Migration Observatory and people like that have looked at, everything just seems to be getting better. More and more people are winning their cases. Whatever the strategy is that's behind that, or maybe it's tactics, maybe it's strategy, maybe it's all accident, I don't know. It's working. People are winning their cases. So don't be too downcast about it. So yeah, I think that's all I would say. There was a specific question about the Med COI. As far as I know, that's an open database. I don't think the UK is excluded from it. I think the information is open. If not, there's a great little organisation called Asylos that does really good sort of mini expert reports for asylum cases that's able to access that, and also all sorts of other bits of information as well. So I think the answer to that one is it's not a problem, but even if it was a problem, it needn't be.
Thank you, Colin. I give the floor to Catriona, and just to reiterate that even if I don't see you, Maya sees you in the room. So if you have any questions, don't be shy, raise your hand and we'll keep track of them. Thank you. Catriona?
Thank you very much. Well, Colin, I hope there aren't too many judges looking at their watches when you're there making your submissions. That's a depressing thought. About articles and other kinds of written interventions, I've just been thinking about a journal which goes to certainly to tribunal judges but probably wider, called Tribunals. And I can send a link to that to you, Violetta, or to Maya. It could be worth writing to them. I'm not saying that you would necessarily have articles in very regularly because it goes to all tribunal judges. But that may be a way, maybe an entry point of writing something perhaps in the second kind of language that we're talking about. So it's, I hesitate to say simplified, but it's written for shall we say it's written for a wider audience than you might, as an academic, originally think you're writing for. So there's that, and then there's also the Equal Treatment Bench Book, which now has a committee, and that could also be a possible place where you might be able to send work on children, for example, work on persons with disabilities. And it's just worth thinking about. Then on the list of questions that we had about how could academics participate in proceedings, really, I think you were thinking about, Violetta. It seems to me that probably third-party interventions or amicus curiae briefs are good things. But when should this be done? And Colin may be able to comment more helpfully on that than me because he's more up to date. Where, you know, whether you should try to do that, for example, in the upper tribunal, or should it be later than that? Should it be earlier? Question mark. I don't know what to say. I think that they are very, very helpful, and I would like to see more of those. The question is where do you start it? I'm not sure. Oh yes, just coming back to, was it Julia who was saying, do we undermine protection for other refugees if we advocate specifically for children? I wasn't sure I understood why we would be doing that, and perhaps you could just say a little bit more, because to my mind, as I said, such is the lack of case law and legal reasoning that we have about best interest, but also about other aspects of the Children's Convention. I can't see why more arguing for them would be undermining for other refugees. Thanks.
Thank you, Catriona. Before I give the floor to Julia, there are 3 questions in the room, and then I have 2 more here from the chat. So, and because time is short, let us collect the 5 of them and then give you all panelists a chance to reply. So, Maya, do you want to?
I hope I haven't passed anyone over, but Aisha, I saw that you had a question.
Yeah, just one question, one comment. I also thought about the new law journal. Would that be feasible? I don't know. Do lawyers read that journal? I'm not sure. And one question is for Katrina, or maybe Colin, you can answer. Prior to the right of appeal for asylum, prior to the fact that asylum seekers are granted the right of appeal, were lawyers lodging loads of judicial reviews, and were there things like Mackenzie Friend type arrangements in place? So just wanted a bit of insight about that. And if there were lodging judicial reviews, what was the quality of judicial reviews like? That's it, I'll just leave it there.
Okay, next question was right behind me. Sorry, I don't know your name. Queenie.
Yeah.
Maybe people can introduce themselves. So Aisha, can you maybe very quickly introduce yourself so that then people in here over the chat can know who's who?
Yes, sure. So I'm a PhD student here at Queen Mary. So, yeah.
Right. Hi everyone, I'm Queenie. I work at the Helen Bamber Foundation and I'm the current part-time master's student here at Queen Mary as well. My question is that a lot of our focus around this discussion, both today but also in the broader context, has been very much focused around the point of decision making. But from what we understand, what we hear really out there is that it's the process itself of getting to that point to get a decision that is so long, it's a burdensome process, it's hostile, it's exclusionary. And based on the three groups that you described today with different characteristics, is there appetite, both from a practice point of view, but also from an academic point of view, to push the argument beyond, instead of just bringing those facing mental health problems and issues up to disability, or those from statelessness, to try and match the refugee kind of threshold, but actually beyond that because of characteristics that they have? So just, very open question. Is there appetite for that, both in research, but also in practice and making that argument? And will it be accepted? Because, it's very much affecting their state, in every form, like physical, mental, emotional, all of that, through waiting for that decision to be made and what happens after that as well. Thank you.
And then Steve had a question as well, I think.
Yes, so I'm Steve Pears. I'm a professor of law at Essex University till Friday and Royal Holloway after that. I had a couple of questions. So one, they're all brief. One, has anyone mentioned the Journal for Immigration Law Practitioners yet? The Journal of Immigration, Asylum, Nationality. Because that may be a more direct route. I don't know how often though lawyers and judges read it, how often they rely on it, or how many academics go into it, or obviously some more of them could start to do so. On the question that Malak raised about the sort of way in which academics are meant to write, I think there's a kind of dichotomy between the academic writing, which is meant to be abstract and theoretical, and this interdisciplinary on the one hand, and doing impact on the other hand, which we're also ideally meant to do, which is a very different type of writing. And hopefully we can all do both, but maybe not everyone, is that comfortable jumping back and forth. And of course, it may be discouraged that you're doing writing for practitioners unless you can make an impact case. And I wonder if, to come back to bring together these two different points, Colin talked about these high recognition rates, but don't we also have a lot of cases sort of sitting in limbo, and also inadmissibility and possibly increasing with the new bill? And isn't perhaps the real problem for academics who want to change the system, not quite so much at the judicial phase, although it's obviously important that we have this discussion today, but at the policy making phase? And then the problem in impact terms, I think the idea that we're meant to be aiming at impact, I think sometimes entrenches us into a, if you want to have impact, a kind of conservative mindset, because no one is going to listen to us in the current government who have fundamental disagreements with, with the way in which the government is going on these issues. A little bit in the EU they might, but this government, no, unless you're policy exchange or connected with them, that kind of thing. So obviously some academics are, but the bulk of academics aren't in this field. So that is there a solution to this besides a change of government, which might not change things much anyway?
Thank you. Maya, are there any more questions from the room?
No, I don't see. Oh, no, there's one.
Just on the flag, there was a really good lecture done by Professor James Hathaway called The Quagmire of Vulnerability. It's on YouTube. It talks a lot about exactly what we've been talking about the sort of way how vulnerability can drive a wedge between refugees who are often themselves vulnerable anyway, and vulnerable refugees who are somehow deemed sort of more eligible for resettlement, more eligible for more rights, etc. So yeah, just highly recommend you go away and watch that. It is a fantastic lecture. It's about an hour long, but it's worth a watch.
Thank you. Thank you very much also for the tip. There is a question from Malak here from the chat box from Emilion Adekoya, who says, I definitely agree with you that agency is needed within the asylum process for the applicant. Here in the US, sorry. However, asylum is not seen as a right, but as an act of mercy extended at the discretion of the asylum officer or the immigration court. And to obtain this, the asylum seeker has to portray themselves as victims without dignity as the necessary price for asylum in the way they present their testimony. Does this requirement not defeat agency in itself? So that's one question. And then there is a long comment that maybe Michael, who's requested the floor, you can maybe put yourself to the panel. It's a reaction to Colin's comment on MedCoy.
Yes, sure. When it's my turn.
Please go ahead.
Oh, okay, straight away. Right, Michael Williams. I work in Sweden, and I've worked with cases in the legal system and also in an NGO with the abbreviation FARR. I listened to Colin's very useful comments. And regarding MedCoy, I was in contact with the asylum unit there, and they said that there is a part of MedCoy that is not freely accessible, even to member states. And in general, it is not a freely accessible database that anyone can gain access to. I wrote to them to ask whether people who are representing asylum seekers could have access to the database information during the case, and not just being a one-sided source that the other party had access to. And they sent me a long letter explaining, and in the chat I've just included some sections of that where they describe in detail the formality of the setup. Then I'd also like to talk about the issue of statelessness and add another tip, which possibly you know about. There is a European Network Against Statelessness. Our organization is a member of that. We participated in the index, the status index on Sweden that was presented about a year ago. And that organization is doing immense work in many of the fields we are discussing now, but at a very practical level of lobbying, spreading information, comparing, contrasting countries, putting forward policy suggestions to countries on how to introduce statelessness recognition procedures, which are often a prerequisite for being able to claim the rights that there are in the convention. If they've not established that you're truly stateless, which they don't here in Sweden, they can always say you might have a nationality that we haven't been told about yet, and therefore put them on hold. But with a procedure, there is a great chance. So ENS exists, and it's been around for 10 years, and is it brings together most of the actors in that field, and has had a very successful conference in Madrid recently with all major actors from international organizations to governments. The Spanish presidency is also being encouraged to do something to help move forward the situation of statelessness in general in Europe and even the rest of the world. So thanks for allowing me this time.
Thank you, Michael. So back to the panelists for a final round of responses before we break for lunch. We can again take it in the order of interventions and start with Nicolette.
Thank you. Thank you everyone for all your comments. I'll just pick up on Queenie's question, which is about, my understanding is you asked, well, it is the process which can be disabling in itself, given like how protracted it can be and all of that. I agree. And you asked, well, is there appetite to do research on that? I would always like to do more research, but obviously we have a focus. And I can't answer that on behalf of everyone, but I would like to link it to the vulnerability point, which we were discussing earlier. Because as critical as I am of vulnerability, and I think that with vulnerability, with disability, there are even additional reasons why vulnerability is problematic as a concept and its use. It can also be its use and the expansion, right, of protection through vulnerability can also, I would hope, through further research, be used to dismantle the system itself. in that if we are constantly carving out people who are vulnerable, who are rendered vulnerable by processes, by detention, where, you know, we speak of disability as 1 in 4 as experiencing a mental health condition, for example. And some might say, well, on the basis that judges use floodgates argument, this is a reason why we should not extend protection to this population. But then we rely on exceptionality. The individual clients, it needs to be vulnerable, highly vulnerable, exceptional. Well, once we take a step back from that and we see that suddenly everyone is vulnerable, you can say, yes, from a normative perspective, it has stopped having explicatory value. But then from the policy intervention, from the future lobbying and advocacy, if everyone is being made vulnerable and the courts are providing protection to this vulnerable person, then we might need to rethink the system itself. And I would see in the longer term, very long term, vulnerability can be weaponized against the very highly oppressive system that we have now, the highly disabling system, not just in terms of disability, but in terms of individual agency. And a final point with regards to the conversation we were also having about vulnerability and phrasing as a practitioner when you're trying, you know, to get your client through the door somehow, through that very narrow wedge, because that is all that there is for the individual. I think it's helpful to take a step back here again, and it is not about the individual practitioner who is doing that, or the individual migrant who is basically, I remember conversations with people, very serious mental health problems, telling me, oh, like, so if I self-harm to this extent, is it better than if I do it less? Because that is the perverse notion of vulnerability, no? Like the oppression Olympics in a way. But if, sorry, sorry, but we take a step back and remember that it is the system which is forcing the individual practitioner to phrase their client as particularly vulnerable. It is the individual refugee who is being forced to play the victim in order to access what little protection we have made available at the international, regional, or national level. So even adopting here the CRPD social model understanding that this is not about individual deficit, this is not about individual problems, but this is systemic. How do we challenge that? I do not have the answer to that, but I think we are all trying in our own individual ways. But thinking as collective and in terms of system rather than individuals would also, I hope, help us reconcile the different discourses and the different aims that we have in both of our professional disciplines. Thank you.
Thank you. So I'll jump first on what Nicolette said and your question. Thank you. I totally agree with what Nicolette just said. And it is indeed very important to talk about the process throughout which individuals have to go through before reaching that decision. And this is where obviously academic and practitioners should collaborate together. But then at the same time, academics are more focused on the long term, while practitioners more focused on the short term. And we have to take this into consideration to understand, just like what Nicolette said, is the system. It's not just the legal representatives, not just the individuals, but the whole system is systematic that forces refugees to portray themselves as vulnerable, that stills their voices. And I think as academics, because we are more focused on the long term, because we are not, our task is not to win the case short term, we need to point this out. We need to highlight this. How, you know, the system forces the individual to portray themselves in a specific way that might not match reality, that might strip them out of their voices, and how it impacts them throughout the process, not just to reach a decision. Because I feel like if we're not going to highlight it, it will not be highlighted in court. So as academics, we need to put this in a, we need to highlight this because it is harmful on the long term. Is there a solution to this? Just like Nicolette, I don't have it, but we do need to think about this, and we do need to highlight it and try to bridge the gap, but understand that we do have different aims. And just one last point, and I know I'm short of time, but about the statelessness index that Michael mentioned, it is that is created by the European Network on Statelessness, an organization that has been doing amazing things. I think that they provide an example of how we can bridge this gap between academics and practitioners, and how they can collaborate with each other while still understanding that we have different aims, that we academics are not there to defend UNHCR or defend certain practitioners, but we are here to highlight certain things and give a different point of view.
So I won't comment on what already was said. I'll just comment, answer the question that was posed by Catriona. So in terms of legitimizing violence towards adults, and the example I think that can be used in this case is immigration detention. So since 2012, there was a huge campaign of prohibiting immigration detention with regard to children. And it does seem to be the case that now, well, all of international bodies are on the same page that children shouldn't be detained based on in the migration context. But some states also follow this prohibition. But again, I wonder whether this was the right way and the right campaign, and shouldn't it be the campaign that refugees shouldn't be detained, because adult refugees who didn't commit any crimes shouldn't be, I think, in my opinion, and I think everyone is on the same page, shouldn't be detained, especially considering the high PTSD and other mental health problems in this population, and generally as victims of torture, persecution. So in this sense, I think we might see in the future that the governments would say, well, yes, but we are not detaining children, which in a way legitimizes detaining adults. And similarly, then there is a question of states, of course, restrictively interpreting what children are. And we already now see that, considering that in many countries there are no birth registration, and a lot of refugees don't have any documents confirming their age. And a lot of particularly unaccompanied children are teenagers. So I think we already see governments sort of pushing back against it, thinking that, well, but we are providing all this protection to vulnerable children, but what they mean by children are toddlers and babies, and not necessarily teenagers, who are a significant population of refugee children. And the example might be also one of the examples what I was thinking about when I was saying this is European Court of Human Rights case law on immigration detention. So I think there's a number of cases against France with regard to detention in one specific detention center of families with children, and the court did find violation of Article 3 in humane treatment with regard to children, but not with regard to adults, and those conditions were the same. So just like terrible condition, living near the airport where the sound levels are not possible for human beings just living around it. But the court made this distinction, and in a way, I think it can be interpreted that it's fine to treat adult refugees this way in this inhumane condition, but it's not okay to do it to children. So these are concrete examples, but again, I unfortunately do not have solutions, and I think that all of us would think that, well, at least the court found violations with regard to children, so that was a win for that particular case. But in terms of how it influences the case law in the future, there is this risk that it will sort of will make the life of adult refugees more difficult.
Thank you very much, Julia. Colin and Catriona?
Just very quickly then, so somebody mentioned the New Law Journal. I don't think many immigration lawyers who do claimant work read it. I don't think many immigration lawyers who do claimant work even read the immigration, the Journal of Immigration, Asylum and Nationality Law, quite frankly. I rarely do myself. I have terrible difficulty accessing it for various reasons. It's yeah, so and you know, we've only got one journal and we don't read it. So, you know, it's one of the things I'm going to be talking about this afternoon, actually, in terms of community of law and things like that. Yeah, I think it should be more widely read, though, and it's something we might try and do some work on. There were cases before 93, just not very many of them. So I've just I've pulled up my list of landmark refugee cases. There was, this might take Katrina down memory lane. There was Jaya Kumaran, there was Jonah, Dai K. I've never had to say that out loud. I've written it in skeleton arguments. I don't know how many times I've been saying it loud. Siva Kumaran from 88. So there were cases, but I think it's an interesting question about the facility to apply for judicial review was there. But in order for that to be an effective remedy, you also need funding for it, which again, technically was there, but you also need lawyers who know how to do it. And I don't think that was there at the time. People were learning. There was a community of immigration lawyers, but it was quite a small one, and that wasn't one of the kind of remedies that people were very familiar with. So it wasn't used that extensively. The thing about conservative mindset is a point really well made, but at the same time, which government was it that introduced the trafficking protection mechanism? Which government was it that introduced the statelessness protection mechanism? Trafficking, I've got reservations about why they did that and the framing for it and so on, but once it's there, it's something we can work with, we can build on and so on. So it is possible to achieve potentially useful changes from even with a conservative government in place and even seeing things from that perspective. So it's not necessarily hopeless. And again, on whose watch has the grant rate soared to its current levels? So there have been positive changes over time. On this question of vulnerability, I don't say too much more on this because we start to go in circles. I suppose it depends a little bit on sort of theories of change and stuff like that. And I think the reality is that refugees are just too big a group and too unpopular a group for advocacy to be effective on their behalf. And the principled position that, well, they should be treated better is all very well. But when it comes to something like the illegal migration bill, when you've actually got legislators, policymakers, campaign groups who kind of, this is their job to do this stuff, and it's true that they're not necessarily brilliant at it, so they're not above criticism at all, but they'll start by saying, well, what about children? Do you want to detain children? Well, how about other people then? If it's wrong to detain children, why is it right then? But you have to kind of, Jimmy open the door to start with, and you need something that people understand, people have sympathy for, people can relate to. And I think the big success story of the last sort of 15, 20 years even is using vulnerable groups to humanize everybody else and to understand that actually we are dealing with vulnerable people. Everybody's vulnerable, that's fine, everybody's human. And it kind of is humanized refugees for at least for key decision makers and policymakers, people at the Home Office, the people actually making these decisions, the judges who are actually making these decisions. And there's been a lot else going on as well, but I think that is part of the story of why there has been positive change over the last 15, 20 years.
Thank you, Colin. Back to Catriona.
Thank you very much. Well, I would endorse all that Colin has just said about vulnerability and the approach and the effectiveness of it, despite its shortcomings, shall we say. Before the right of appeal, no, there weren't loads of JRs. Again, as Colin has highlighted, there were not loads of people who knew about that area of work or were able to fund it. A lot of work was done by law centres, probably most of it, including in care proceedings, because there wasn't legal aid. Mackenzie Friends, I don't remember there being many of them. I suppose there was a particular reason why that was asked, but I don't think I could say anything very helpful about Mackenzie Friends. The Journal of Immigration, Asylum and Nationality Law, that certainly used to be in the libraries in Field House and Taylor House and the other tribunal buildings. I assume it's still there. So that could be worth bearing in mind. Changing policy at Home Office and other governmental Department of Education, perhaps level. Yes, I think it's obviously that's long term. I do think it's worth trying to do that. I mean, perhaps articles can go through all-party parliamentary group committees. Perhaps they can go through societies, perhaps such as the Society of Labour Lawyers or other similar societies. Are these doors that you can use as entries? I think those were probably the points I wanted to pick up on in the main. Yeah, thank you.
Thank you. Thank you very much, Katrina, and thank you to all our panelists. I think it's time to break for lunch, but I'd like to ask everyone for a round of applause in recognition of a very fruitful discussion and a very nice way of starting our dialogue between academics and practitioners. I've learned a huge lot on how to strategize, how to be generous, how to perhaps use concepts that maybe might not be ideal, like vulnerability. I mean, there is a lot of discussion on that. I'm sure the session in the afternoon, it's going to expand on these things and to make us reflect on how to utilize the knowledge that is being produced by academics as part of our ways of argumenting asylum claims and defenses against expulsion. So I'm sure there's going to be a lot more that we're going to be learning from this afternoon. But thank you all very much for participating in this session. We are breaking for lunch and we will resume at 2:15 UK time, unless Maya has anything else to tell us. I don't know if the time is going to change. Maya, the floor is yours.
No, so no time change, but a room change. People are here, so I can see that some people don't have a chair. Sorry about that. So we're going to move to the room just next door, which is, I think, room 2.1, because we're in 2.2 now. So we're going to move to room 2.2 after lunch, because it's a little bit bigger, and I hope all the chairs are there, because I'm not sure what happened to all of these ones. But yeah, that's the only thing. And yeah, lunch should be downstairs now, where we also had breakfast. If you were there, it's sort of like next to the reception. We can lead you there. Yeah, so that's good.
Thank you. Thank you.
Thank you. Thank you.
Should I start? Brilliant. Well, thank you, everyone. Thank you for inviting me to chair. As I said, well, maybe not everyone was here this morning, but I'm Steve Pearce from Essex University, about to be at Royal Holloway University as a professor as well. So our focus this afternoon is on improving protection for trafficked and smuggled persons. It's the same structure as this morning. We'll hear from the practitioners, then from the academics, some discussion between them, and then open our discussion to the floor. And I'll introduce people individually just before they each speak. So first of all, Julian Bild, solicitor and the Immigration Unit Lead at the Anti-Trafficking and Labour Exploitation Unit.
Thanks, Lou. So we're a small charity that provides legal representation to victims of trafficking, immigration, housing and support, employment and compensation. So I'm a jobbing solicitor. I have a client group of migrants. Saying that, the first example I'm going to give of using some actually failing to access some academic support concerns my only ever client in the British citizen. So you won't know this, but British citizens aren't entitled to legal aid to help with their trafficking cases. You only get legal aid if you have an allied, a linked immigration issue. So we took on this client to try and get him legal aid under what's called the exceptional case funding regime. And we did after about 8 months of struggle, but that's sort of not really relevant. So I'm just going to look at 3 of my current cases and how we might use, I'll get help from academics. So I'm going to give 3 examples of how I've used, or at least thought about using, academic work in 3 recent cases that I've had conduct with, broadly relating to psychology and mental health. That's the first case. Country information, the second case, and the definition of trafficking under the conventions. I could also usefully characterize these as academic studies that are inaccessible to immigration lawyers, and that's just the thing about paywalls. We're legal aid lawyers, the legal aid agency doesn't pay for us to have logins or to buy individual research documents. And it's quite difficult to tell from an abstract whether the document's going to be useful or not. So we're sort of reluctant to pay for it. So helping legal aid lawyers, particularly working for not-for-profits, in accessing some of these very useful, literature would be helpful. So inaccessible in the first case. In the second case, just fantastically helpful and determinative, and that's the country research I'm going to talk about. So we're working with an academic on producing a bit of country research that will allow our client group, Filipino domestic workers, to succeed in their trafficking cases. And then a longer term project, really prospective help from academia in stretching our understanding of the conventions, and that's in the context of agricultural workers who brought here on short-term tied visas. So in the first case, I'm just in the process of finalising representations which the NRM, the National Referral Mechanism, require from me by tomorrow. So this is the 9th deadline. But as I say, it took us 8 months to get legal aid, so we're hoping to finish those reps by tomorrow. He's a guy with learning difficulties who was effectively recruited by a drug dealer to help him distribute drugs. An idea for academic research, and perhaps it's been done or being done, is that almost none of our clients who are prosecuted for trafficking offences are helped to access defences. You know, there are defences under the Modern Slavery Act, but we find that almost always their criminal solicitors say, perhaps rightly, perhaps wrongly, plead guilty. And in his case, although there were lots of indicators of trafficking, he was told if he didn't plead guilty, he might get 2 years imprisonment. So if he did plead guilty, that's also an aside, but something that academics might want to look at why that's happening. So the only psychological evidence of his learning difficulties was a psychological report that had been prepared for his sentencing hearing. And it didn't really, because they hadn't been running a trafficking defence, deal with whether he was a victim of trafficking or not. But it did talk about, under a heading of suggestibility, whether he might have been particularly compliant or suggestible as a result of his learning difficulties. And that sort of was helpful research, but all the psychologist did, who was a bit equivocal about this, he was referring a footnote to what looked like a very interesting document, a bit of academic research on the relationship of intellectual skills to suggestibility, compliance, and acquiescence. And we wanted to be able to run a narrative in front of the NRM that his learning difficulties themselves meant that he had no prospect of extracting himself from this exploitative relationship. There was no force used, there was no threats. It basically, a drug dealer came to him, our client had a bit of a cannabis habit, and said, "Why don't you sell drugs?" And he said, "No, I don't want to sell drugs. I want to get a proper job." He'd never managed to hold down a proper job, but the drug dealer simply said, "Well, here's the drugs, I'm coming round tonight to collect the money. Here's the addresses I want you to deliver them to." And he sort of says, no, oh, okay then. And this sort of carries on for 6 months. Every morning he's delivered the drugs. He's told that the money's to be expected that evening, and he goes and delivers the budget. And he sort of talks himself, he refers to himself as a bunny. The drug dealer's telling him to hop and he goes and hops. But there was never any coercion or threat. So it's not an easy case to fit within the trafficking definition, but showing that someone who has learning difficulties can be so easily made to be compliant without needing to have any threats used. It would have been useful for us to just flesh out our narrative a bit. We didn't go on with the research. We hope he will get a positive CG decision. That's the final decision to confirm as a victim of trafficking. If he doesn't, we might beg, borrow, or steal that bit of research to seek reconsideration. The second, very quickly, case study concerns one of our client groups, which is overseas domestic workers who get trafficked usually into the Middle East and then trafficked into the UK. I won't detail the abuse that they suffer, but when we look at most of the literature, and that will include very general human rights reports, such as those prepared by the US State Department, there appears to be laws in place in the Philippines to protect victims of trafficking. They rate quite highly by the US State Department as tier 1, which means that they do protect. There are formally laws in place. There are formally services that will allow or help victims rehabilitate when they get home. But no literature about whether actually this happens. What does happen to Filipino domestic workers who have been trafficked when they're removed back to the Philippines? So with an academic, the sort of diaspora activist groups within the domestic worker populations in the UK have identified, I think, about 30 returnees, and they've looked in detail at exactly what does happen to them on return. And largely they don't access support or protection, and some 70% of them have said, we have no option but to go abroad again, even if it means we're going to be exploited again. And that kind of first-hand evidence of what actually happens to returnees is just fantastically determinative of an asylum claim based on the risk of re-trafficking. So we're launching that report later in the week, and hopefully it will persuade the Home Office that regardless of the support that's down on paper, it's not actually accessible. And then lastly, what we broadly call trafficking reports, but academics looking sometimes at individual clients, sometimes at groups of clients, and providing an opinion based on the definition of trafficking as to whether they're victims or not. And we're thinking how useful it would be for someone to do a bit of research on the agricultural workers scheme. So this year, the Home Office is going to facilitate 55,000 tied visas for people to come in the summer months to pick fruit, mainly in our fields. They're coming from places like Uzbekistan and Nepal and Indonesia, and very far people that would have come from the EU or perhaps Ukraine in the past, but are now coming and making ridiculous journeys, coming from extremely corrupt countries where they're fleeced initially by local recruiters, and we've heard of agricultural workers paying up to £6,000 to get a visa. They're fleeced again by the agents who subcontract to the agents here in their countries of origin. So they have local recruiters subcontracted to national recruiters, subcontracted to UK recruiters. And of course, also in the supply chain are the farmers here and the supermarkets. So you have these complex supply chains, and you can't really say that any particular part of the supply chain are acting as traffickers. It's the supply chain as a whole. So that doesn't easily fit into Article 4 of the Anti-Trafficking Convention, Article 4 ECHR, because you have a complex supply chain with different links doing different nasty things to our clients, but none of them can be referred to individually as traffickers. But at the end of the process are agricultural workers who not only make no money at all out of their visas here, but actually go back in debt. So there's clearly a debt bondage thing going on. You know, the output of those supply chains is workers who get no money at all for back-breaking work, picking our fruit and vegetables, but not easy to fit that within a trafficking framework. And we know that human rights conventions, they're continually being thought and rethought and applied to different sets of circumstances. So we're looking to some academic researchers, perhaps economists who can crunch the numbers, supply chain experts who can actually show that these schemes cannot work without massive exploitation of the workforce. There's simply not enough profit in employing people on minimum wage here who are brought from Asia so that every element of the supply chain can make a profit. And that means these workers go back with no money and often in debt. So it's a way of trying to reconceptualize the definition of trafficking to allow the trafficker to be a supply chain. Multiple agencies here ostensibly regulating the process, the Home Office, DEFRA, the Gangmasters Licensing Authority, etc. All of them, as with the supply chain elements, passing the buck to the others as responsibility for regulating the scheme. So none of them regulate it. And of course, Article 4 ECHR protection duties, again, you know, looking at the regulatory system as a whole, whether that can be targeted for a breach of Article 4. So those are the three areas that I'm currently on my mind as finding academic research, if I can access it. Very helpful.
Brilliant. Thank you very much for that very interesting, detailed breakdown of particular cases. I'll move now to Miranda Butler from the other part of our legal profession as a barrister at Landmark Chambers.
Thank you so much, Steve. I'm going to follow Julian's excellent example and talk about three different issues. I'm going to slightly take a step back because, like Julian, obviously I use country expert reports, trafficking reports, and those individual expert reports are essential in winning cases day to day. But I wanted to think a little bit about what does academia contribute to my practice, particularly as a public law practitioner who does a lot of systemic strategic claimant litigation. And the three ways in which academic work really impacts on what I do is, firstly, academics are experts, slightly building on what Julian's already discussed in such interesting detail. Secondly, I think academics have a role as pathfinders. And finally, I think they have a role as tastemakers, which is probably a much trendier word than what it actually looks like in practice. So, academics as experts. I have won and lost, but in less embarrassing terms, cases as a result of the type of robust, rigorous academic expertise and analysis that we as practitioners and even as civil society could not provide. So if I could give an example, I'm currently awaiting judgment in a court of appeal case called SPM. This is to do with the Home Office's decision to open and operate the only all-female immigration detention centre in the UK in a legal aid visit. There are some obvious issues about opening an immigration removal centre where people need legal aid in an area in which those vulnerable women, many of whom are victims of trafficking and victims of other forms of exploitation and abuse, may not be able to see their lawyers in person. And one of the core points we needed to establish as part of our overarching argument that this interfered with common law right of access to justice was to say, this is a legal aid desert. And we were massively assisted by the fantastic work that Dr. Joe Wilding's done about legal aid deserts. And it meant that a point that could have been argued over, could have wasted a huge amount of cost and time in court, just went by the wayside because she had so authoritatively established that there are legal aid deserts all over the UK, but in particular up in Durham, where SPM was detained, where Durham site is located, there simply are no immigration and asylum practitioners, and certainly none with capacity. that it meant that we could simply put that before the court in the full knowledge and confidence that it was going to establish that plank of our case for us. And whilst I'm so grateful to amazing NGOs like ATLU for the evidence and time that they often provide in jails, which is often essential, and I don't wish to overlook that, necessarily their experience and their evidence is limited to the work that they do. And academics can often give a more holistic, nationwide, region-wide assessment. And I think that can hold a particular degree of weight with court. And I wanted to think about this in the context of what does it mean to ask the court to assess evidence? And anyone here who has had the pleasure of reading the Rwanda judgment in the High Court will know that at least some of our judiciary at the moment is willing to show a huge amount of deference to the government's own analysis of evidence. Let's see what the Court of Appeal says on Thursday when they hand down their judgment on the appeal, but at least the divisional court essentially took a very hands-off approach to the government's assessment of evidence. This was a matter for the government, despite it arising in a fundamental rights context, which anxious scrutiny should apply. And what I was thinking about was if you have at least some parts of the judiciary that are willing to be quite deferential, not only to the government's constitutional right to make its own decisions, but also to its assessment of evidence within those decisions, how do you counterbalance that? You need unchallengeably authoritative material. And I think the best way to obtain that is through robust research done by academics, such as that of Dr. Baldwin that we relied on in SPM. And this is something that I see a lot in the decisions I challenge, that you have what you could call decision-making by mere assertion. One of the most shocking examples I saw recently was in an age assessment. My client is a Sudanese teenager who's been assessed as being in his early 20s. And the age assessors said, without citation or reference, many sub-Saharan Africans look younger than their chronological age, which is nonsense. And it was very easy for me to say that is nonsense, because there's been fantastic work done on adultification bias, which establishes that particularly where you're talking about cross-racial age identification, people from Black African backgrounds are more likely to be seen as older than their chronological age rather than younger. And once again, this is a way in which we can empower claimants to make their cases against a hostile and indifferent power structure. And you can do so in a way that is, to my mind, essentially unchallengeable, because I think we can sometimes be a bit siloed. And when you open up the door to something like the research on adultification bias, it's so well established that you can treat it essentially as a fact rather than a matter of dispute within the litigation. So that's academics as experts. Then more briefly, academics as pathfinders. So claimant litigation is inherently creative. It's one of the best and one of the worst bits about it. I sometimes think it must be quite nice to be a defendant. You just run the same arguments. Oh, the court should show deference to the decision maker's appropriate roles. Just copy and paste your summary grounds of defense every time. Whereas we have the lovely but also challenging task of trying to come up with new arguments, particularly to new types of decisions, to new legislation that's handed down. And I know that I am already trying to future-proof my practice by thinking about and reading what people much cleverer than me in the academic sphere are saying about things like the illegal migration bill. There's plenty of illegality in the illegal migration bill, but it is really useful for practitioners like me to have that, more considered analysis to inform that frantic work that we will have to do as bills like that start being implemented and we see potentially mass detentions, attempt to remove to third countries, ousters, for instance. And having someone do the thinking first, even though of course you have to do your own thinking when it's your case, is utterly essential. So finally, academics as tastemakers. I think this is a more amorphous, a slightly more diffuse role that academic literature has. But from my work both as a practitioner and from my time as a judicial assistant on the Supreme Court, I'm really aware that judges are aware of the milieu in which they're making their decisions, the reception those decisions have, and the critique of decisions, issues, legislation before them. That's not any suggestion as to their independence. It's simply a reflection of the huge amount of information that is inside. And I feel that when there is a substantial body of academic criticism of a new provision, that at least informs judicial reception and perhaps lends weight to legal challenge. And quite finally, I think it also plays a psychological role. My boss at the Supreme Court was the absolutely wonderful and hugely mixed Lord Kerr. And he was obviously usually by himself, perhaps with Lady Hale, perhaps sometimes Lord Wilson dissenting. That's a bit of a lonely place to be. And knowing that there were some brilliantly clever academics saying that he was right was very reassuring to him. So please don't stop, even if the Supreme Court disagrees with you.
Brilliant. Well, thank you very, very much for that, Miranda. And we'll move to Catherine Meredith, barrister at Doughty Street Chambers, who is online. So is everything working online for Catherine?
I can hear. Hello, can you hear me?
Great. We can hear you. We can't yet see you. Oh, yes, we can see you. Brilliant.
Probably a blessing of it.
Very good.
All okay?
Oh, okay. Yes, you can see you very clearly.
Thank you so much. Good afternoon. And I've got a massive case of FOMO at the moment because I very much wish I was there with you in the Hive in Lincoln's Inn Fields. So my I'm also going to follow the rule of three here and make 3 points about how I engage with academic work in my practice, and give a litigation and a non-litigation example. First of all, professionally engaging with academic work is important, and I'm not just saying that to get the crowd on side. It clearly brings a fresh perspective and way of thinking to difficult legal issues that we face in practice. And that can be old issues, but old issues that have been recast and new ones. As Lady Justice Carr said in the Harris Society lecture, academic work can help us to understand not only what the law is, but how it is changing and how it should develop in the future. And she also suggested a distinction or a tension between practical legal scholarship and philosophical insight, suggesting that judges may find the former useful and the second not so much. I would agree definitely that it can bring an important insight to understand what the law is and how it can develop. But I also think that both types of legal scholarship can help us lawyers in wanting to push the law. But we just have to be realistic as lawyers in the confines of our court craft in terms of knowing what can be achieved and how we go about that to bring about an end for a client or a group of clients, or to bring about wider change. So the examples I'm going to give are really with those thoughts in mind. So secondly, I've got 2 examples, one longish, one shortish, relevant to the theme of improving the protection for trafficked and smuggled persons. The first is casework related and the second is not. It's non-casework related. Casework related example is an intervention that I worked on for Anti-Slavery International in the case of VCL and AN and the United Kingdom. And the judgment was eventually handed down on the 16th of February 2021. And the applicants, as we know, in that case were 2 child victims of trafficking from Vietnam who'd been prosecuted and convicted of drugs offences because of their work as cannabis factory gardeners. The UK Crown Prosecution Service, the CPS, had effectively ignored their identification by the competent authority as victims of trafficking. The court communicated that case under Articles 4 and 6 ECHR, asking at the time whether or not those issues fell within the scope of Articles 4 and 6 ECHR, and if so, how? Now, that might seem like an odd thing to ask, but at the time, not very long ago, there was no decided answer on the point. At that time, as now, the case law of the European Court of Human Rights and domestic case law was developing, and the ECHR case law was following general principles borrowed from Articles 2 and 3 ECHR on the system's operational investigative duties. But as I say, there's no decided case law anywhere in the world on whether or not the non-punishment principle as applied to victims of trafficking fell within positive human rights obligations, in this case, Article 4. The court, as we know, found that positive obligations under Article 4 were breached because of the failure to take operational measures to protect, so finding that the non-punishment principle fell within the scope of the protective duties, where criminal offences were connected to status as victims. The court also found a breach of Article 6 ECHR because of the failure of the CPS to identify the victims or provide written reasons why they disagreed with the decision of the competent authority. But that meant that a fundamental aspect of their defence was not secured and undermined the overall proceedings, fairness of criminal proceedings as a whole. Now, there can be no doubt that this case changed the law. But what of the academic input, I hear you ask? Well, I would suggest in that case, a really important case that changed the law, there was probably a rich academic analysis and input in the submissions and the material that was put before the court from the parties and from the interveners. We know from the face of the judgment, from public knowledge, that one intervener was Greta, the group of experts on action against trafficking in human beings, the monitoring body of the Council of Europe Anti-Trafficking Convention, ECAT. At the time, at the helm was Professor Siobhan Mullally, the president, who is now the UN Special Rapporteur on Trafficking. Professor Mullally is also the established Professor of Human Rights Law and the Director of the Irish Centre for Human Rights at NUI Galway. So I think we can all draw our own conclusions that those credentials and the background and expertise will have been, I would suggest, would have been very influential to the court in reaching its conclusions on Article 4 and drawing and actually stating as a general principle that Article 4 ECHR and the positive obligations owed to victims of trafficking have to be read with ECAT and with the views expressed by Greta. And in my own work with Anti-Slavery International, we drew also on academic input firsthand from Dr. Anne Gallagher and her book, her brilliant book on the international law of human trafficking. And I'm pleased to say is an academic expert at Doughty Street and as many of you will know, has worked on many regional international soft rights, soft law instruments, including the UN guiding principles. So her experience and her expertise and her book that's very practical in nature, we drew on all of these different sources aimed at pushing the principles in the case, and in particular the best interest of the child in the context of the non-punishment principle. So the point I make is we can assume, and we know there was I think a high level of practical academic and analysis that was brought to bear in that case in a really powerful way. The second example I want to give of engaging with academic work in the context of protection of victims of trafficking is non-casework related. And that was in relation to collaboration in the parliamentary processes on the Nationality and Borders Bill, then Act 2022. So with the anti-trafficking team at Doughty Street Chambers, we submitted written evidence and and worked with NGOs in the field and academics. As we know in Part 5 of the 2022 Act, that simultaneously put the National Referral Mechanism, the NRM, on a statutory footing and dismantled it. The sharpest end of that is Section 63, disqualifying victims from protection on public order and bad faith grounds. And that, from the explanatory notes to the bill, to the Nationality and Borders Bill, as it then was in purported reliance on Article 13.3 of ECAT. Now, what did that mean? Where did this come from? How to defeat it? As I say, there's a lot on our hands, as we know as lawyers, in challenging this, and we still are. But on that single point, we worked with a huge NGO and practitioner coalition, including ATLU and others, and the International Human Rights Clinic at Duke Law University in the US, led by Professor Jane Huckabee and Professor Aya Fujimuro-Fanslow, provided immense support in thinking around defeating the public order and bad faith requirements. And their analysis was so welcome, not only from a solidarity perspective as this amazing US law clinic, but also because it was absolutely devastating, and will be really useful in challenges to come, in particular in terrorism-related challenges. And there's also brilliant research-led work conducted by the University of Nottingham Rights Lab, by Kate Garbers and several of her colleagues, not only on NAB, but when it entered into force and around the illegal migration bill. And all of that work, research-led and academic thinking, is hugely important and really useful, and will be as part of our ongoing challenges to this, to defeating this grotesque new regime. And my final point is that as practitioners, we do have to be realistic in where and how we deploy academic work. A lot of it because of precedent, and as Lady Carr's lecture suggests, there's quite a high threshold in terms of the court citing academic work directly. And when they have done that, we can see this is a really long game. And as one of the points that was made this morning, Lady Carr gives examples of the cases that show that quite high threshold and the fact it's a long game. A relevant example for us is in our sector, in our field, is HJ Iran, the Supreme Court case in 2010 on the question of what constitutes persecution and the discretion test. We all know that case, but I think it's important to remember Lord Hope in that case cited Professor Hathaway's book, The Law of Refugee Status, published in 1991. And that had already been cited in other Supreme Court cases in 2007 and in other jurisdictions in Canada, including in 1993. 17 years later, in HJHT, the Supreme Court drew on that corpus of case law from other jurisdictions and Hathaway's essential point that the right to dignity underpins the Refugee Convention to decide that the UK courts were so out of step with their analysis of the Refugee Convention that it meant that the discretion test had to be rejected, that gay men did not have to remain discreet in order to avoid getting killed on return. And it is pretty shocking that it took that long to decide that point against that corpus of case law and academic commentary. 2 years later, in Artis Zimbabwe in 2012, the Supreme Court reiterated that essential point in HJHT, that the right to dignity underpins the protections afforded by the Refugee Convention. And the point in the Supreme Court of Canada, that dominant view is that refugee law ought to concern itself with actions which deny human dignity in any key way, and that the sustained or systemic denial of core human rights is the appropriate standard. So again, reiterating that that was already the dominant view, leading to the finding that the freedom to hold and express political beliefs is a core or fundamental right, and so too is the right not to hold those protected beliefs. So a politically neutral person could, being forced to express a political view, could be at risk of persecution. Now, I don't want to end on a negative note. That's a realistic point. I think in this room, in this virtual room, or in the physical room, we're all human rights lawyers. So we're all at heart optimists. When I say lawyers, academic or practitioners. So we wouldn't be here if we weren't interested in drawing on those sources we can. But I think for practitioners, it's how we do it is important. And so the examples that I gave are the sort of the small and quiet way to achieve an aim, and the HJHT Iran is the big noisy way. But after, frankly, 20 years of Hathaway saying the same thing. But either way round, whether it's the small, quiet way to achieve change or the big, noisy way through collaboration, we will get there in the end. It just might take a bit longer because things are going backwards. But on that note, I will hand over to the next speaker. Thank you.
Brilliant. Thank you very much, Catherine. So I'll move to the next speaker, and I hope they are with us online. Dr. Naomi Maguliani, do we have you with us?
I believe you do.
Oh, excellent, brilliant. Okay, so Dr. Maguliani is at the University of Kent and the British Institute of International Comparative Law, and they'll be talking to us as moving on to the academics now about trafficked adult males as ungendered protection seekers on masculinities, vulnerability, and victimhood. Brilliant. So,
do you need me to share your slides, or are you able to do it?
I don't know if I'm able to. I can also not use them, and
because I can do it for you, or I can try and work out how to make you co-host. Oh no, it's working. Oh, fantastic. Okay. Right.
Great. So whenever you're ready.
Amazing. I feel like I'm breaking the rule of three, and I'm also bringing in slides into the conversation, which for a split second, I thought I would just go back on my choice and avoid doing. But Maya has them, so they can be made available at any point after today. So again, it feels like almost a break, but I would like to go back to some of the points that were mentioned so far in looking at part of my research that focuses on the obstacles faced by adult men in being identified as trafficked and in accessing different forms of protection. And more specifically, my research, generally speaking, looks at the gendered nature of anti-trafficking and the gendered biases of the framework, exploring again constructions of vulnerability, invulnerability, and victimhood. But today I will specifically talk about access to asylum with a focus on trafficked adult men. And in order to obtain asylum, trafficked persons and legal representative and practitioners tend to rely on the trafficked person being recognized as a member of a particular social group, and on establishing a well-founded fear of persecution on such a ground. And although none of the core anti-trafficking and asylum instruments and tools are written in a way that precludes access to protection to certain categories of trafficked persons, be that on the ground of biological sex or gender or type of exploitation, access to asylum for women and girls trafficked for the purpose of sexual exploitation has been consistently higher in absolute and relative terms compared to access to asylum for women and girls trafficked for purposes other than sexual exploitation. And an even higher gap is seen if the data on access to asylum for women and girls trafficked for the purpose of sexual exploitation is compared to the data on access to asylum for trafficked men and boys, regardless of the type of exploitation. So I started looking at a number of decisions of the upper tribunal, in particular between 2017 and 2020, and the pattern of recognition of membership of a particular social group for trafficked persons within the asylum process has been inconsistent at best. So in SB, for example, we have the broader category of former victims of trafficking. We switch then to TD and AD, and we have former victims of trafficking for sexual exploitation or women victims of trafficking. And the recognition of trafficked women, again, for sexual exploitation, as members of a PSG has been fairly widely acknowledged and accepted in asylum system, before asylum authorities, and also before tribunals within and beyond the UK. So there's multiple examples from other jurisdictions within the Council of Europe context, France, Germany, Norway, Finland, Italy, just to name a few. But there's been a sort of understanding or consensus around the fact that women trafficked for the purpose of sexual exploitation can constitute a PSG. And I'm not going to talk about then the risk on return, but just membership element for now. So, as I mentioned earlier, looking at judgments from the upper tribunal, and specifically at instances where the upper tribunal was called upon to evaluate trafficked men's membership of a PSG, a number of observations can be highlighted. And in particular, today I wanted to talk about the evaluation of the applicant's vulnerability and victimhood, which one might conclude, at least that was my conclusion, and happy to hear any dissenting opinions on that, that is vastly based on stereotyped gender assumptions around masculinity, especially hegemonic masculinity, and victimhood. So just to give some examples of that, in AN Albania, the protection claim submitted by a trafficked person for the purpose of forced labor was refused by the Home Office. In evaluating the appeal, the first-tier tribunal judge found that it was not accepted that the appellant, together with others in similar positions, had a distinct identity in Albanian society that was perceived as being different to that of the surrounding society. So therefore, the appellant was not found to be a member of a PSG. That finding was stayed by the upper tribunal, where the judge also held that it was not accepted that the appellant is intrinsically vulnerable to being re-trafficked, as he is, and I quote, a mature young man who has shown himself resourceful enough to travel across Europe to the United Kingdom. So the judge placed particular emphasis on male agency and resourcefulness, surely reinforced by the findings that the appellant was mature and young, and that the three elements were sufficient to find that he was not intrinsically vulnerable. No other elements were taken into account in order to reach the decision, and I link back to something that was mentioned earlier about that bondage that wasn't at all taken into account in the evaluation of vulnerability nor victimhood. In AB Albania, a case on forced criminality this time, the first-tier tribunal accepted that the appellant had been trafficked within Albania as a minor for the purpose of forced criminality, but it concluded that the appellant was not a risk on his account and was not a member of a PSG. So while the upper tribunal found that women forced into prostitution could readily be seen to form a distinct group who would be viewed as different by other parts of society, in the case of forced criminality, it found that it could not be accepted that the appellant was a member of a PSG in the absence of evidence of discrimination against such a group. We can go back again to further research on what happens upon return, if any discrimination is present or not. And the representative of the Secretary of State argued that the position of the appellant was not akin to the position of females who are forced into prostitution, who may be at risk on return due to their earlier victimization. Now we'll come back to this in a moment. But before doing that, it would be quite unfair to not also discuss some examples or meaningful exceptions to this trend of findings of invulnerability or lack of vulnerability, whichever way you want to put that. And some of these examples include, for example, HVT Vietnam, where the upper tribunal found that persons trafficked for the purpose of sexual exploitation, regardless of biological sex, have a so-called common immutable characteristic namely their experience of having been trafficked. And that shared possession of that characteristic establishes the existence of a PSG. Now, similarly, and not in a sexual exploitation case, we find a similar reasoning in TSN, Vietnam, and ED, Albania, a case of forced criminality and forced labor. But again, as I said, inconsistent at best. We find different framings of PSG. We find PSG defined very broadly as former victims of trafficking, especially when we have a sexual exploitation element. And we find very narrowly defined PSGs when we talk about forced labor. So a person that has no family connections in the country of origin, that would go back to a situation of destitution, that suffers from severe PTSD, and I'm quoting from a variety of cases that have come across the Appellate Tribunal. So in order to understand the reasons behind the lack, or at least the inconsistent and uncertain recognition of trafficked adult men as members of a PSG, I believe that both an historical and a sociological perspectives should be adopted. So while early criticism of international refugee law highlighted the portrayal as universal of what was deemed to be in fact a male paradigm, and the systematic neglect of gender as a critical consideration in every facet of the refugee definition or situation, gender has increasingly become an element upon which asylum claims, especially those relating to trafficking, are decided. And acknowledging the relevance of other researchers' observations on how the almost systematic categorization of women's gender-based persecution claims under membership of a PSG and not, for example, political opinion grounds, it demonstrates an underlying gendered politics. And it is therefore important to look at the role that gender plays in the adjudication of asylum claims, and it needs to be examined critically. And when I say critically, I mean across the gender spectrum. It's not something that only needs to be examined and assessed when the individual before the tribunal or before the asylum authority is a woman or a girl. And unfortunately, that oftentimes is the case. So the difficulties faced by males and adult men in particular are arguably, as I mentioned earlier, attributable to the gender stereotyping that is operationalized by asylum decision-making bodies, which has consistently failed to recognize the gender dimension of trafficking with respect to men. And they're also attributable to the nature of the exploitation to which most trafficked men are subjected. And this is not to fall into that binary distinction between women trafficked for sexual exploitation and men trafficked for other purposes. But across the board, and regardless of biological sex, forced labor and forced criminality are considered to be lesser harms than sexual exploitation on the one hand. And on the other, violations of socioeconomic rights as a ground for asylum are not yet fully recognized. So the combination of these two elements makes it so that even without looking at biological sex, if we only take into account exploitation types, we already have differential treatment when it comes to establishing membership of a PSG. So when men are considered as gendered subjects, their gender is usually associated with presumptions around hegemonic masculinity without a proper assessment of the fact that hegemonic masculinity is just one of many forms of masculinity. And that to a certain extent, it serves to legitimize unequal gender relations amongst masculinities, including with subordinate and marginalized masculinities. So in this context, men are harmed when their masculinity as a gender identity is violated, but also when it is imposed as a gender role. So when men are only understood through this particular lens as invulnerable, as not able to be victimized or not able to be deprived of agency or coerced, then that harms their claim and harms their possibility to achieve any sort of recognition and protection. So trafficked men are oftentimes subjected to a process of de-victimization, as again, victimization is deemed to be incompatible with hegemonic masculinity. And this understanding prevents an holistic analysis, at least, of vulnerability across the spectrum. And it follows that adult men tend to be perceived and recognized as victims only when a trafficking experience contributes to their feminization on the one hand, or infantilization on the other, be that through sexual violence or through a display of absence of agency. So in this context, however, men are not acknowledged as vulnerable, being men, but rather as lesser men or feminized men, which also links to often unfounded assumptions around their sexual orientation and gender identity, and to the lack of recognition that men can be targeted because of their biological sex. For example, for their perceived value of economic or labor capacity, higher propensity to engage in criminal activities, sexual dominance, sexual profit, and sexual markets. In parallel, when the notion of women is pinned down to a very sexualized and narrowly sexualized aspect of the category, it only serves to reinforce quite patriarchal discourses. So women, and in particular certain female bodies, are imposed a sort of prima facie vulnerability, while male bodies are imposed a prima facie state of invulnerability. And to deconstruct that is quite problematic. This leads to assumptions around consent, agency, participation, resilience, capacity. It also links to blurring boundaries between sexual exploitation and sex work. So how much of agency can there be? Can an individual willingly perform sex work? Or is that always exploitative? And on the other hand, to the opposite extreme between labor exploitation and human trafficking. So it's often perceived that forced labor only amounts to labor exploitation without the trafficking nexus, which again prevents individuals from accessing specific forms of protection that are only accessible in the first place to individuals that are deemed to have been trafficked. And I want to go back to a point that was mentioned earlier around risk on return being a crucial element in the evaluation of a protection claim. And there are a multitude of examples of claims being dismissed because men would not face obstacles reintegrating in male-dominated societies. This is a formulation that can be found quite consistently across cases before the upper tribunal. And it ignores quite significantly that trafficked men may experience both emotional and physical violence if returned to their country of origin. And in particular, they may experience rejection from family, feelings of shame and social stigma. There was a brilliant research done in Vietnam on risk of both re-trafficking, including because of substance abuse and that bondage, that are almost entirely disregarded, even in the context of country of origin information, which unfortunately quite often tend to rely on the stereotypical case of trafficking and not on more detailed and gendered understandings of risk on return. In addition, among the male cohort, the lack of self-identification and extensive use of avoiding narratives contributes to hindering the timely and correct identification of trafficked persons amongst the men cohort. And underreporting may also be linked with a lack of or lack of awareness of available support services. We could go back to talking about legal aid, but also shelter, for example. Now, this is not the case of the UK, but in a significant number of other jurisdictions, there are very, very limited shelters available for trafficked males in particular. More for boys, but for adult men, that seems to be quite the exception. I could mention Italy as one of these cases, which again, coupled with the avoiding narrative element, coupled with the lack of access to protection, oftentimes leads to destitution with no available support. So vulnerability really is the key word here. And without theorizing too much about that in this context, but happy to talk about that more maybe afterwards, the expectations linked to vulnerability and victimhood are clearly informed by a stereotype of who constitutes an ideal victim, as well as in stark contrast with what is expected, culturally speaking, of quote-unquote real men, who are more likely to perform masculinities by shielding. So the two performative elements of victimhood remain divergent rather than following a convergent trajectory. So the gap that is created should be understood and looked at through, again, a masculinity lens. And unfortunately is left unaddressed, often leads to the under-recognition of men's vulnerability, trauma, and risk on return, and thus ultimately of their victimhood and protection needs. And I think that's something that even within academia, before it reaches places and spaces outside of academia, there's a lot of shared learning and shared building between research on sexual violence and conflict against men and trafficking for any type of exploitation when the trafficked person is either an adult man or a boy, of a person, again, not reinforcing binaries here, but there's a lot of research that we in the legal field on trafficking could borrow and expand on. And I think something that I always wonder when doing research and in trying to get this research out of the academic sphere is that tension between legitimacy and the paywall, right? What is considered to be legitimate in the context of court proceedings, for example, from an academic standpoint, what can be used? That tension between ensuring that the research is the most accessible, but also legitimate enough for it to be considered of a certain standard and accepted as such in the court context. And I might for now just stop here. I think I might have run out of time, but happy to continue later.
Brilliant. Thank you very much to Noemi for that. I'll move to Dr. Maya Grindler, my eminent colleague at Royal Holloway, to talk about trafficked persons, asylum claims, and their implications for smuggled persons.
Yeah, and let me try to get the tech to work. Oh, yeah, yes. No, come on. Yes, okay, nice. Great. Well, I only have 10 minutes for this, which is entirely my own fault. So I'm gonna go through this quite quickly, but hopefully if anything's unclear, we can talk about it in the discussion Q&A. Right, so my research is about trafficked persons asylum claims and the implications for smuggled persons or irregular migrants more generally. And this research is very much based on the idea that trafficked and smuggled persons have very similar experiences and therefore possibly similar protection needs. And this is something I will go into a bit of detail in a moment, but just to explain a little bit what I'm doing in my research, I'm analyzing how UK courts approach asylum claims based on a risk of re-trafficking. So Noemi and I think, share a lot of the cases that we've looked at, although I think our sample is slightly different. So I'm analyzing these UK cases, and then I'm looking at whether similar arguments could be made in relation to individuals who, although they were not trafficked, so they probably wouldn't meet the trafficking definition, have similar experiences to trafficked persons during irregular migration. So basically, I'm interested in whether there is such a thing as a risk of irregular re-migration, which kind of parallels the risk of re-trafficking, and whether people who have no well-founded fear of persecution in relation to their country of origin could still be granted refugee status because they are at future risk of harm outside that country in the context of irregular re-migration. And I'm going to explain to you why I think this might be the case by looking at how trafficked persons are seen to be able to meet the three main elements of the refugee definition, so future risk, as well as persecution, which in turn includes a serious harm element and a lack of state protection element, and then the nexus to refugee convention grounds. So starting then with the future risk analysis, in UK case law, risk of re-trafficking is very much established based on a range of vulnerability indicators such as young age, female gender, poverty, lack of employment opportunities and experience, having little education, having no family or other support networks in the country of origin, or experiencing pressure from the family to earn money, having mental health issues, experiencing stigmatization, and having illegitimate children. And these vulnerability indicators are seen to converge to make it quite difficult for an individual to earn a livelihood in her country of origin so that she has no choice to be re-trafficked. I say she because, as Noemi just pointed out, most of these claimants who are seen to be vulnerable are female. But what I think is important about this body of case law is that it essentially admits that trafficked persons migrate for economic reasons, while acknowledging that this is not done voluntarily, but because their vulnerabilities leave them no other choice. And when we look at these vulnerability indicators underlying the risk analysis in the trafficking context, we can see that these vulnerabilities may apply not just to trafficked persons, but to irregular migrants more generally. So even without having been trafficked, individuals may, for example, lack education and employment opportunities. People who have migrated irregularly once before, but who have been returned, may well suffer from mental health difficulties because of what they've been through during the initial dangerous migratory journey. As Noemi also mentioned, they may also be stigmatized by their community. So this doesn't just apply to trafficked men, but also to irregular migrants more generally due to a so-called failed migration experience. And then irregular migrant women may well have illegitimate children because they may have been raped during the migratory journey, right? So basically, I argue that by applying the vulnerability analysis from the trafficking context to irregular migrants generally, individuals who experience these vulnerabilities may be able to establish a risk of irregular remigration. And the reason why I think it's appropriate to think of irregular immigration as a risk is that irregular migration is extremely dangerous. So I'm now coming to the second element of the refugee definition, persecution, and more specifically, the serious harm element of persecution. And in UK case law on trafficking-based asylum claims, there isn't really much of a discussion of this element before the courts, because the courts seem to think that trafficking itself is harmful. At the same time, the case law does show what types of harm trafficked persons experience, and this includes things like sexual exploitation in the majority of cases, because it's majority women, but also rape, abduction, physical violence, deprivation of liberty, forced labor, and domestic servitude. And then when you look at reports of experiences of irregular migrants during dangerous journeys, these experiences really are strikingly similar to what trafficked persons experience. So I think it might be possible to say that both trafficked persons and irregular migrants suffer serious harm and may be at risk of experiencing such harm again should they be re-trafficked or remigrate irregularly. Importantly, in the trafficking context, the fact that the majority of this harm happens outside the trafficked person's country of origin is absolutely no obstacle to a trafficked person's asylum claim. If anyone is interested in how I approach this problem doctrinally in my research, we can talk about that later. But the main point here, I think, is that the types of harm and the location of the harm feared are very similar for trafficked persons and for other irregular migrants. Moving on then to the second limb of the persecution inquiry, how are countries of origin actually able to protect against trafficking, especially seeing as this harm does largely take place outside of the country of origin's territory? Here the courts adopt two different approaches. One of them is a very law enforcement focused approach in which it is claimed that states can protect trafficked persons through actions such as prosecuting traffickers and having anti-trafficking legislation in place. And then, failure of state protection is found where there is no anti-trafficking legislation or it's not really applied effectively. In practice, this approach is not particularly effective because it does not address trafficked persons' need to approach traffickers, and no matter how many traffickers are prosecuted, this will never eradicate trafficking as long as there is demand for it. The second approach to state protection is somewhat more promising. I refer to this as the reception and reintegration approach because courts consider in how far states can address the risk of trafficking by providing trafficked persons with reception and reintegration measures, which give them alternatives to re-trafficking. In the case law, as I think Noemi also mentioned, these alternatives are often found, for example, in the shape of dedicated shelters for trafficked persons. And again, there's this problem of these shelters being available mainly for women, not for men. In addition, this type of protection is also insufficient because of limits on the length of time that an individual can stay there or what services are actually offered in that shelter. More worryingly, actually, courts have suggested that financial reintegration assistance alone can counter risk of re-trafficking, and have found state protection to be available where either local NGOs, international organizations like IOM, or even the sending country provide financial reintegration support packages for returned trafficked persons. There are also cases, though, where it's been recognized that this is an extremely simplistic approach to state protection and is not particularly effective. So in the reception and reintegration approach, a failure of state protection is found when there is a lack of these reintegration measures for returned trafficked persons. Applying the situation to irregular migrants, then the law enforcement approach will likely be as ineffective as it is in the trafficking context because it does not address the demand for smugglers. And likewise, the reception and reintegration approach is likely quite ineffective because countries of origins don't really tend to provide a lot of targeted support for returnees generally, such as shelters. In the trafficking context, as I said, they're mainly available to women anyway and not to men, so returnees generally don't have much of a chance there. And then, of course, we still have this financial reintegration support, but as I mentioned, it's very simplistic and not particularly effective because it doesn't really address all of these intersecting vulnerabilities that I spoke of earlier. So I think we might be able to say that there could be a failure of state protection, a failure on the part of the state to protect against both re-trafficking and irregular immigration. Finally, I'm going to talk about the convention nexus. And as so often, this is very much the most complicated part of the problem. So in the case law I've looked at, courts rely largely on the particular social group, trafficked persons or trafficked women, in which the relevant group is united through the common characteristic of having been trafficked and the differential social perception which arises from this status. And Noemi has, of course, just told us some of the problems with these particular social groups. The actual nexus element, so the question whether risk of re-trafficking is for reasons of being a trafficked person or a trafficked woman, is strangely barely discussed in the case law. But I do think that there is a nexus between being a trafficked person and risk of re-trafficking, but I think that this is due to the vulnerabilities which trafficked persons possess prior to being trafficked and which they acquire during the trafficking process. So what I propose is that actually the particular social group persons in vulnerable situation better explains why both trafficked persons and irregular migrants are at risk of re-trafficking or irregular immigration. And this particular social group links back to the vulnerability indicators, which I mentioned earlier. So I argue that we could say that an individual's vulnerabilities constitute immutable characteristics, at least at the time of refugee status determination. And they're likely to cause that individual to be perceived as different from surrounding society, especially where a person has mental health difficulties or experiences stigma. And then further, vulnerabilities are, of course, under this approach that I'm taking, reasons for exposure to irregular remigration and re-trafficking. So the persecution feared is for reasons of that individual's vulnerabilities. So basically, I argue that irregular migrants can also meet the final element of the refugee definition. So to sum up, I think that there is such a thing as a risk of irregular remigration. Based on the serious harm experienced during dangerous migratory journeys, states of origin are likely to be unable to protect against this, and irregular migrants may be able to establish membership of the particular social group persons in vulnerable situations. And so they might be granted refugee status. And I'm extremely interested in what especially the practitioners in the room think about this argument. So thank you very much for listening to this very quick breakdown, and I look forward to the discussion.
Thank you very much for that, Maya. And finally, we'll turn to Dr. Samantha Curry from Liverpool University, who's going to talk to us about legal aid and representation of trafficked persons.
Oh, so sorry, this should not work if we do.
Yes. Oh, thank you very much. Thank you, and thanks, Steve. Okay, well, hi everyone. It's a real pleasure to be here today among so many experts and practitioners that do such inspiring and important work. It's quite lovely to see so many names that I read on all these judgments over so many years. So what I'm going to do is to talk a little bit about legal aid as it applies to trafficked persons. And just to give you a sense of where I'm coming from with this, I'm sort of informed by 3 different projects that I've been doing over the last few years, 2 of which have involved collaboration with legal practitioners, one of which has been more academically focused. And what I'm doing is a little bit different from what the other academics have done, although I have noted that all the academics have stuck to PowerPoint, whereas the practitioners have avoided it, which is probably sensible. I'm not really advancing a particular argument as such that I hope practitioners will then run with. I'm sort of drawing on the research just to give a bit of a perspective on the sort of key themes that have come out of the research, and in particular a particular issue that comes up a lot, which applies in the context of fixed fees for legal aid and how that impacts in the trafficking context. Okay, so a couple of caveats first of all. Today I'm drawing on a smaller sample, so the research is qualitative in nature, so it's not intended to be representative of lawyers' views. The focus is very much on aiming to understand the experiences and perceptions of lawyers that I've interviewed who work in the anti-trafficking space and are representing trafficked persons regularly. And a particular thing I think it's important to highlight is that my sample here that I'm drawing on is a self-selecting one. So the lawyers I've spoken to are very much engaged and well-informed within the anti-trafficking space. And I think that's important to keep in mind. I haven't been able to bring into the research, certainly not at this stage, the views of lawyers less engaged and less knowledgeable in trafficking work and the specific legal framework around that. So that's the caveats out the way. Bit of further background information though before I talk specifically about fixed fees for the time remaining. These are just some of the key themes that I wanted to highlight to you about what practitioners have really highlighted over the course of the research. So they talk frequently of having constant battles with both the legal aid agency and the Home Office. This idea of constantly having to battle for even the most basic entitlements on behalf of their clients. I think it's also important to keep in mind the multiple and multi-layered legal needs that trafficked persons often have, encompassing the NRM, different immigration and asylum claims. I thought that Malak's presentation this morning on statelessness was really pertinent in this area as well, because I know, for example, that our law clinic that we have at Liverpool, that's run a particular clinic which has tried to bring in statelessness, and they did have some success in a couple of cases of getting statelessness leave for trafficked persons. So I thought that presentation was really excellent, Malik. Another theme to come through from the lawyers was that they are spending considerable time and energy rectifying really quite basic mistakes, sometimes on behalf of Home Office decision makers, and then other times on behalf of lawyers who have previously represented traffic clients before they've made their way to them. Another theme is how clients' criminal convictions based on forced criminality a lot of the time pose particular challenges, because once a deportation order has been issued, that creates considerable obstacles to overcome. And that links to the point that Julian made about how defences as envisaged by Section 45 of the Modern Slavery Act, for example, are not having the necessary impact. And Catherine alluded to this also. And then essentially, and this is a point I'll develop a little bit further in a moment, often lawyers spoke of how the only way that they could really conceive of doing a full and complete job in terms of legal representation for their clients was to do extra unpaid work outside of the legal aid system to ensure the quality of that representation. And that clearly then has significant personal and sometimes emotional impacts for the lawyers themselves. And I'll say a little bit more about this in the context of fixed fees. So moving on then to focus more directly on the issue of fixed fees. This is set against the backdrop of an immigration legal aid sector, which, as we know, faces huge challenges in terms of capacity. I'll give another shout out to the really important and impactful work of Joe Wilding in this context, who really exposed the scale of the problems. And so this research sort of has that in the backdrop and tries to drill in more specifically to look at the anti-trafficking context. And it was resoundingly reported by participants that fixed fees payable, the immigration legal aid fixed fees payable were too low as to facilitate the complex and long-running legal work necessary on trafficking cases. And it was really clear from the interviews with the solicitors, and other work corroborates this as well, that the time factored into the standard fixed fees is insufficient to adequately pursue the different legal avenues open to their clients. So a lot of the time the cases were seen as financially unviable to take on. And the sort of final thing I want to do is to run through 4 different responses that practitioners talked about to that problem of fixed fees in this context. Because I think there were 4 different responses that came out of the interviews that we've done. So the first quite basic response would be to just reduce the number of trafficking cases, or to just not take any trafficking cases on, because it was not seen as a financially viable option. The second response was to take on trafficking cases, but to limit the scope of the work undertaken on that aspect. And the most common sub-response within that would be, for example, to prioritize asylum claims and to not really pursue to the full extent the trafficking related legal issues. Clearly, that will only be possible for those that do have an additional protection claim. And there are obvious risks with that, should that claim then be unsuccessful. The third response would be to meet the escape fee threshold, which then allows the fixed fees to be avoided and triggers payment by hourly rates. And the threshold for that is if the work carried out would exceed at least 3 times the value of the standard fixed fee. And I'd really welcome practitioner perspectives on this, because there were 2 different perspectives from the lawyers on whether meeting the escape threshold would be seen as viable. So on the one hand, some lawyers viewed meeting the escape fee as feasible, desirable, and they incorporated this model into how they ran trafficking cases. And these lawyers tend to emphasize the importance of understanding how the legal aid fees regime works, and also about front-loading aspects of the casework. So taking a detailed witness statement early on, for example, obtaining a medical report early on. And the lawyers that took this approach tended to be highly specialized in running trafficking cases. On the other hand, not all practitioners saw meeting the escape fee as a viable route, and some deemed it too risky due to uncertainty as to whether the threshold would be met. And again, there's a link here just mentioned on the slide to some of Jo Wilding's findings, where she also found in her research that the risk involved in turning a file escape can sometimes create a pressure to remain within the fixed fee, and it can sort of feed back in to work capping. And there was also within the qualitative data different perspectives, and lawyers talked about how the culture of their own firm, for example, would influence whether the escape fee route was deemed as viable or not, and then also the size of the firm would come into it. So I'm not going to read through these quotes, because I know I'm really getting to the end of my time here, but these are just to give a bit of a flavour of the assessments that lawyers were making. So the second quote here, it does feel like you have to choose one or the other, either having very high caseloads and not doing much work on them and churning through them which I think a lot of firms do on asylum cases, or you can try and have fewer cases and do lots of work and go the escape fee route, but then you need to have an alternative source of cash flow in the meantime. And just another point I would really, sorry for the huge quote, another point I won't go into big detail on, but I'll just highlight because I would really maybe perhaps like again practitioner perspectives on this. The significance of geographical location on this seemed to be significant as well. So this is a lengthy quote from an immigration lawyer based in Liverpool. And basically they're explaining here that although they really see the value in being able to run cases in the escape fee way, they saw the particular geographical context as important in making that difficult. So they reference both Liverpool's status as a dispersal area and a location for home office interviews as putting particular pressure on the work they were doing there. So I'll just read the final bit of the quote here. So I've got colleagues that work in other cities that say they don't go above 30 cases, but they're doing escape fee all the time, whereas I'm 4 days and I think I've got about 105 cases. So views very welcome on that. And then just my final point before I stop talking is that the sort of final response, which links back to one of the themes that I highlighted earlier on. The fourth response that came out was that lawyers would take on the trafficking cases anyway, but basically on the basis that they would need to dedicate additional unpaid time to the casework, often out of the standard work times and personal cost. Many of the lawyers had serious misgivings about this and didn't see it as a sustainable way to work in the long time. What they saw it as necessary in the moment. And I've got there are lots of quotations from lawyers in different locations at different size firms, which emphasize the personal pressure that they were feeling as a consequence. And so I will just finish on a final slide here just to conclude. I think, clearly the sort of underlying point here is that the legal aid structures are undermining the potential for trafficked persons to access lawyers, and fixed fees are a clear disincentive for many to take on the work. And I think we can think about the impact in terms of the impact it has for the trafficked persons and the potential to access good quality legal advice. And then from the perspective of the lawyers as well, it's a highly pressurized and not really sustainable working practice in the long term. And to link it back to those capacity problems, it also compounds further, or certainly will do, the issues of capacity within the sector. So this is just a final quote which sums up some of those pressures. So the stress that you feel about basically being the only person this individual contacts, very often you're the only person they're talking to and the only support they've got. There's no other network and they're in crisis. And then you can't get the funding, so you're left with this impossible choice. Do I just help this person as far as I can, as humanly possible, because what's going to befall them is so much worse and they're at such risk? Or do I have to make the decision to keep on hammering the legal aid agency, trying to get the funding in place? So thank you very much for listening and for all of the presentations, and I will leave it there.
Brilliant. So thank you to Samantha, and thank you to everyone who's given a presentation. And so at this point, like the morning, we'll switch back to, first of all, to the practitioners for any comments they want to make via the rule of three or otherwise in response to what we've heard from the academics. So Julian, do you have any comments on reflections?
I think they were all brilliant talks and all fantastically interesting and sight for the work I do. The idea of men, the system does obviously stereotype men as being stronger and more resilient, but of course, given the traumas they've been through, and in any case, they might not exhibit aspects of hegemonic masculinity. You know, lots of my male clients have been subject to sexual abuse, and it's fantastically difficult for them to disclose it, perhaps more difficult because in their cultures, you know, the idea of being raped is, you know, it's why they're raped by the traffickers, because it destroys their sense of themselves. How do you keep a man in a cannabis grow under your control? You destroy their sense of self, and they become very easy to control. You rape them, and the difficulty of getting my clients to disclose that they've been raped, but when we build up a relationship of trust, sometimes we have to ask them direct questions, and they break down, and you realize that they're not lying about this, because no one can lie when you realize that they've disclosed rape. And of course, they're not more resilient than women in those circumstances, perhaps less so because of the culture they're going back to, where they're meant to be, you know, strong and looking after the family and everything else. So absolutely, you know, having listened to Naomi's talk, absolutely something I want to take back and think about. Absolutely, Maya, you know, my client from Sudan, who's luckily got refugee status, but was trafficked in Libya on the way here. Absolutely, if he was sent back to Sudan, he's just going to try again, and those things are going to happen to him again. And absolutely, Samantha, no answer to that question. Do you pile them high client-wise to get representation to the most people that you can, or do you focus on making every case a huge case? And you know, at Lou, we have small caseloads. We work our clients' cases to death, and we always succeed on them, but we're always thinking, you know, it's desperately horrible to say no, because support workers of course want to get their clients to act Lou, because we always succeed, and we always have to say no to almost all the people referred to us. It's horrible, and there's no real answer other than the legal aid practitioners being paid reasonable costs for the work. I mean, I used to, with Colin, do a lot of upper tribunal work. Our cost regime was reasonable costs, but we justified the work we did, and we were paid for it. And there were people at the legal aid agency who I know were looking at our files and saying, I want to be able to say this is not reasonable work. I want to be able to say you shouldn't have spent 20 hours with that client because everyone else spends 5 hours with their client. But we justified it with very detailed attendance notes, and they generally paid us for the work we do. In escape costs, we know that there are people at legal aid agency who want to say we're spending too long with our clients, and they don't, because they can't, because we justify the work we do and we succeed. So it's very difficult, isn't it, to firms who want to help the most clients that they can't afford to do escape fees work, or you know, having a lot of money, a lot of works in progress on a few. It doesn't work for most firms to have all that works in progress that they can't claim. But you know, what I would say is the firms that do work in their own time, I mean, just don't, because this work is super stressful, and if you're doing pro bono work on top of that, you're just going to burn out. You know, the idea that you can fill the legal aid gap by working even harder in your spare time, going home late every night, coming in at the week, will just destroy those case workers. You know, they won't survive that punishing thing. So all those talks were just brilliant, and just so apposite for the work.
Brilliant, thanks. Miranda, any thoughts?
I would endorse everything that Julian said, especially as to the brilliance of the talks. And that's the kind of visionary thinking that we as practitioners down in the trenches can so benefit from, because you don't have the time and perspective to step back and look at the big picture like that. But what I wanted to comment on, which from my perspective as an advocate, it's what I'm thinking about every day, is how do I change your mind? One of the things I often talk to friends about is, how much I think about how I get someone to care. I'm afraid to say I'm often in front of judges, but I don't think necessarily see my clients as the rounded, often horribly wounded individuals that they are. And I have to confess, listening to Noemi's fascinating piece, I often do fall back on the stereotypes, because the stereotypes often work. Here is this poor victim of rape. She's been destroyed by it physically, mentally, and emotionally. She's so vulnerable she can't rebuild her life. I often think about the fact that I always call my clients victims. I don't call them survivors, which is what I would do in my private life. But professionally, both as a matter of the way in which the law is framed, but as a matter of my role as an advocate, I'm almost trying to put the worst and most infantilized, feminized, vulnerabilized gloss on my clients possible, as supported by the evidence. And I do often really feel concerned that I'm disempowering my clients in that. You know, I'm currently representing a woman called Ellen. You can read her Admin Court and Court of Appeal judgments if you'd like to. We're taking a case to Strasbourg because the Supreme Court didn't want to look at it. And she is simultaneously the most vulnerable client I've ever had and the most resilient client I've ever had. Necessarily, the two things go hand in hand. But I'm so conscious I'm rather doing her a disservice when I'm also doing her asylum appeal. And I'm going through all the evidence saying, look at these horrible things that happened, look at quite how unwell she is. And I'm necessarily not painting her as I would like to, but I also think that's the most effective way to paint her as an advocate. And similarly, as an advocate, I was so interested in what you were saying, Maya, because I think it's very persuasive legally, but I already know that when in 10 years' time I'm trying to make that argument to the tribunal, a judge is going to say, Miss Butler, this person's chosen to leave Sudan. And trying to get someone to understand the complex realities as to why someone who wouldn't meet the traditional refugee definition might feel forced to leave is so hard, because there can be such a hostility to accepting the lived realities that lead to forced migration. And similarly, Samantha, one of the things that I, particularly in the admin court with its emphasis on procedural rigor, I'm often thinking about is trying to get judges to understand what it's like in a legal aid practice. And, you know, when the admin court is saying, well, of course, when you're filing a witness statement, you need to make sure that it's in the client's own language and you're also filing certified translation. Right? That's what the CPR does. That's what we try and comply with all the time. But realistically, if my client's on the street and he doesn't speak English and we need to run to court in the next 25 minutes, we're not going to be able to comply with that. And particularly in the downside case, when we were talking about the realities of whether lawyers from London are going to have the time, resource, energy, staffing to drive 5 hours there and back to go to Derwent-side to see their vulnerable clients, it's surprisingly hard to get some lawyers who've never worked with vulnerable people, sorry, I say lawyers now on the bench, to understand how hard that will be in terms of the aid agency and in terms of the emotional, financial and practical resources for firms. So this really reflects one of the challenges I see in practice.
Great, thank you. Now I hope we still have Catherine. If I turn to her next for comments on, I see Catherine's face.
Hi.
We can hear you, brilliant. Okay. You want to comment on what the academics have said?
Strange experience. I'm not sure what I can add to what's already been said, apart from I'll be in touch or tell all my colleagues to do so. So you'll be even busier, all of you, with all these the barrage of emails wanting to draw on your important work. I mean, like Julian and Miranda, I mean, I agree. I agree with the arguments that you've put forward, or the you know, the necessity of the work, and I don't know what can help except to say, in Noemi, that you may be interested to know. I mean, it just reinforces the examples that you've researched. That I recently had a Nigerian trafficking case for a man, very, very, very vulnerable. because of his childhood experiences, but which the tribunal accepted, but they did find that in the absence of demonstrating that he fell within a member of a particular social group, his asylum claim failed because he didn't show that he had a refugee convention reason. So despite everything else, I mean, the HD trafficked women Nigeria in its head note says that whilst the case was about women, it was relevant to men. So fortunately we had that to rely on, but clearly like how to write grounds of appeal stating the absolute obvious. But I mean, we won on for other reasons, but your research would be really important for a whole host of other cases. And Maya, yes, there's I mean, there's so many. I think this is really, really important work. And I mean, we see as practitioners so many of these cases where there's a misunderstanding about smuggling and trafficking. So A, as to whether or not somebody meets the definition, but also B, if somebody might have been smuggled, that they could actually argue that there's a real risk that they might be trafficked in the future, or they might be at risk. So it can work both ways, the backwards looking way in the types of examples of people who might have been trafficked and held for ransom, so harbored and held against their will for money, and that there might have been an exploitative purpose, but the competent authority deems them not to have been trafficked because the exploitative purpose hasn't been met in their view. But also, yes, people, as I say, who have been smuggled. And I think there maybe there's maybe those are less common examples, but you can still nevertheless make out an argument that because of vulnerabilities or indicators of trafficking, they could be trafficked in the future. And sometimes you get quite helpful medical reports about a person being so vulnerable they could be exploited. Yeah, Samantha, actually, I just sent you an email in the course of you speaking, saying that it'd be good to chat. So yeah, sorry about that, but you'll look forward to that when you turn your emails and you get back into your inbox. So thank you so much.
Brilliant, thanks. Noemi, do you want to respond to anything that's been said?
Yes, of course. Thank you very much for the feedback. I mean, I wrote a full page of notes, just building on what you shared post the academics presentations. But I think there's a few maybe elements in talking about victimhood as performative. And I'm really glad that, Miranda, you shared what you did about, you need to put up the best case you can, because in the end, in that moment, it's the client that matters, the person that matters. It becomes then the game of the wretched of the earth, right? Not to go too philosophical about that, but it becomes a pity, compassion, exceptionalism, and that does underplay agency. And the problem then becomes when there's either no legal representation or a different legal representation, then the bar is set so high in terms of vulnerability and trauma and risk on return that it becomes unattainable. So there's a lot about performance that comes both from legal representatives, it comes from verbal and nonverbal communication, and a lot is taken, like I did court observations, a lot is taken from verbal and nonverbal language and communication. But also in terms of performance, it then becomes the easy way out to make sure, to ensure that the policing keeps happening. And it's about policing mobility and borders and identities and sexualities. So it becomes, again, this idea of imposing specific types of gendered identities on individuals that are grounded in a particular cultural understanding that doesn't necessarily translate. So the judge is making a decision based on what they know and perceive as culturally and socially masculine or feminine, which is not necessarily true. And one of the elements that comes up quite clearly from looking at cases where we have women and girls, but non-sexual exploitation is that work is masculine, right? So work denotes a level of agency, and therefore it makes a woman less feminized and it makes a man more masculine when that element is present. And it's only feminized if, again, we go beyond the myth of single exploitation type and find these cross boundaries between forced labor and forced criminality and sexual abuse and sexual violence. I think what's interesting in the work being masculine is that in relating to agency, it also speaks about invulnerability, but on the one hand is the act or the display of agency, on the other is the simple being of, like, being a man automatically is associated with presumptions of invulnerability. So it's not an act, it's not a display, it's a being, which is where, again, why before I was talking about policing identities and sexuality. But on the paywall issue, if I may, but I've had over the last couple of years, very happily, people reach out asking for copies of particular outputs or articles. And I think all of us are very happy to do that. Extremely happy.
Yes, I was going to raise that point myself before I move on to the last two, that because it came up this morning as well. I mean, if there's a question of a paywall, it may be possible to contact the academic directly. There may be slightly different non-paywalled versions online in some other format, in one of the research social media sites. And there may be a way around it without having to blow your budget to these very wealthy publishing companies. Sorry, I'll move on to Maya.
Thank you. Yeah, oh my God, thank you all so much for your very generous comments. I was all ready for battle and pushback, because that is what I get from academic colleagues, actually. Let's see what comes in the audience. But yeah, thank you. It's very interesting to get your perspectives, and what Catherine said to me, I think it's very, very interesting, because she said that my argument could also be used to say that the people I'm looking at who weren't previously trafficked might be trafficked in the future. And it's actually a very conscious choice to not say that, because I personally find the trafficking concept quite problematic for a number of reasons. One of them being that it's very much associated with female experiences and sexual exploitation. Another one being that it's a criminal law concept that we've taken into refugee law, which throws up all kinds of problems. And I guess I would like to ask the practitioners a question, if that's all right, sort of based on these issues. So is the trafficking concept something that you just have to accept in your work, just take at face value? And also, is there, and this is based on something that Julian said, is there a temptation to kind of simplify it as much as possible? Because you said you have clients who experience forced labor, but also rape in that context. So it's actually much more complicated than just a forced labor case, but it's possibly difficult to make that argument. So I'm just really interested in how that concept plays out in your practice.
Yeah, I mean, it's about identifying vulnerabilities. You know, we're always looking not to explain what's happened in its own terms, but to think about future risks. And when we're getting our medical legal reports, we'll send a client to a psychologist for an assessment. And obviously it's best that they've disclosed exactly what's happened to them, because that's quite difficult. You know, they don't want to talk about what's happened to them. You know, the other thing that's very problematic is the circumstances here are so precarious that it's quite hard for them to identify and engage with that trauma that's obviously there. But, you know, one of the things at the moment we're trying to traffic and leave for people to access trauma services. You know, it's so ridiculously difficult at the moment, because the Home Office wants those services to be in place before they grant people permission to stay. And we say, well, you need permission to stay to allow people to be able to access their trauma and access their services. And we've got a JR we're working on at the moment about all of that. But absolutely, it's not about what's happened to someone so much as who they are, you know, and identifying who they are by getting as much disclosure as possible and then showing how vulnerable they are to everything happening again. But absolutely, you know, someone who is a victim of trafficking, perhaps the trafficking didn't happen, but it would have happened, and if they go back, it's almost certainly going to happen again. So absolutely, you know, smuggling, you know, and what's happening to someone here can be absolutely critical to evidencing vulnerability in future.
For me, I often think that the process of judgecraft, as it's practiced in the UK, is inherently small c conservative. A lot of the most effective advocacy is to persuade, is to make the easiest path for your judge, and that's very likely to involve the least novel or radical path. You're just doing what other judges have done. You're bound by the Court of Appeal at this point. These points are all in agreement. We obviously meet the trafficking definition on this ground. It's not even in dispute that we meet it on this ground. And I think what that can do, whilst hopefully it makes for more effective, more persuasive advocacy to say, you have to let us win, and you have to let us win because of this key issue. And whilst that might be persuasive, I think that can end up being quite reductive and simplistic, just as I've confessed to falling back on stereotypes sometimes. I think it can also mean that you're not encouraged to be legally creative. And I think it would be a bolder, and I'm sure a better lawyer than me, who would look at the judgments we have seen in the last 5-10 years, or choose your time period, and would conclude from them that novel legal arguments, particularly on behalf of marginalised groups, were welcomed by the court. And I think that means that a lot of the wins that we do have are ones where you manage to frame something as being less radical than its repercussions might actually be. I'm being terribly pessimistic there, but that's at least my experience. And I think some of the statistics about win rates for claimants at the moment would bear me out.
But I think that point about creativity is one area where the academic incentive structure is to do something else, because one of the grounds of assessing our research is of originality, and so something that's really good that pulls together all of the cases in a particular field, but doesn't say anything radical about them or suggest that there should be some profound transformation. It could be hard to get to the the sort of 3-star level that we sort of see as a minimum. And I think you could argue that's a big mistake that prevents academics from engaging more with lawyers than perhaps we'd otherwise do if the incentive structure were different. I looked at something from a colleague that was about gay stereotypes in advertising and how has that changed, defamation, how has that changed. A fascinating piece that would be very useful to any lawyer working in the field and anyone interested in the sort of question of how gay people are seen socially over the years. But it was hard for it to get to a 3-star, as good as it was, well researched as it was, which I think is tragic, really. But that is, what our incentive structure is and why it's potentially going in a little bit different directions sometimes. But Samantha, your chance now to comment.
I think I'll just make a sort of general point about how valuable I think the event today has been. And for reasons that Steve was just alluding to, really, I think what's been really nice across both sessions is that we've been able to tease out a bit the competing pressures that we both categories of the space. So obviously, practitioners are seeking to achieve the best results for the clients they represent at that time, whereas we're almost forced into this long-term trajectory where we're constantly thinking about ref, and obviously there's the impact element of that, but that's sometimes framed so specifically that it can be hard to really feel that you're hitting the ground with that as well. So I feel it's been really valuable to kind of talk a little bit about the different pressures that we face, because hopefully then we can develop a more secure footing for valuable partnership moving forward. And I think, personally speaking, I feel quite reinvigorated after this debate, because I felt in my recent work that I've been constantly trying to pester practitioners, some who may be here today. And so, there's feeling that kind of almost feeling reassured that you feel that practitioners feel that there is a place for academic research and that there is a joint way of moving forwards when otherwise the environment can feel all consuming and depressing. So yeah, I would just sort of, for my final comments on this, we just need to thank you for the valuable event and hope that we can continue some of the discussions after it as well.
Brilliant. So it's the turn of people in the audience and people online. I see someone online, Catherine, has already said, don't stop being creative academics. The legal system has to catch up. Look at HT, keep going. But so anyone else online, please do comment and I'll keep checking. But those of you in the physical room, any questions or comments? Yes.
Hi everyone, well, I'm Queenie. I'm from the Online Foundation and it's a question here. Less of a question, but more of a comment that when you're talking about the tensions with what these different things. I think one thing I wanted to highlight as well when we work with survivors of trafficking as well is that today we kind of talk very similarly in the afternoon around trafficking itself, but the reality for them is that oftentimes they've got multiple systems and multiple cases going on in housing, criminal, trafficking, asylum. Sometimes they've got 4, if not more, solicitors working with them and different things. But at the same time, as you said, Miranda, it's how do we do the most effective form of advocacy for them, and it's a tension between each practitioner, whether it's a legal practitioner or an academic finding some expert evidence for them, or the NGOs working in that space. How do we hold the survivor, where they are when they've got so many different things going on, but at the same time trying to find the most effective, most direct thing for them. But the mirage of the legal system and all these multiple things happening for them as they go through their cases, whether it's silent, etc. Whether it's an open question or a comment, how do we kind of balance that tension to support survivors?
Should I take multiple questions or yeah? So yeah, at the back. Well, either of you.
Actually for the representation, how do you explain that the aspects of the person is very gendered, how it's stereotype forces men to fit into a narrative of masculinity and resilience. As Miranda explained, sometimes you have to produce these stereotypes to win the case for your client. You've mentioned the consequences on men. You've explained that men do not fit into these stereotypes sometimes with this security protection. I just wanted to ask you what are the consequences on women. Do you think that women who do not fit into these stereotypes cannot secure refugee protection, or do you think it forces women to fit into the particular social group categories? I wanted to focus on the consequences of women.
Brilliant. And also at the back.
Thank you for this very insightful discussion. I'm not in the good teams. I actually had a college of development, but I was very interested again, obviously everything has been discussed, but more specifically during this comment about agricultural workers. So my PhD actually research bridged between labor migration and seasonal labor migration and forced displacement. And I took the case study of Syrian agricultural workers in Lebanon. Having done ethnographic research to assess basically what to bridge between the very divided notion about the difference between forced displacement and seasonal agricultural labor. And so I'm not very familiar with the UK seasonal migration system, but I was very curious to ask you, perhaps with reflections that could also be led to questions, 3 interesting questions. Also, I guess, given the limited research about the this intersection in agriculture specifically. So do you foresee the problem in the senior agricultural program in the UK? Do you foresee the problem to become a problem of irregularity if these workers manage to overstay? Because we have that you see in different case studies, including like Mexico and the case of Mexicans in the US and how they overstay, and then in terms of the problem of irregularity, so you're allowed to stay there for a short time and very forward. Also, we see how this also applied in also in Europe and Italy among other places. And how would this look like in Ukrainians? And after the Second World War, the Ukrainians were allowed to come into several parts of Europe on the premise that they were dealing with persecution or with communists of the Soviet regime. And how does this basically build a blurred line between post-displacement and post-labor? And especially when it comes to thinking of the Geneva Convention, which came into place in a context where there was a specific problem that was very urgent and that had to be dealt with, but which is now failing to account for the fact that refugees are also workers, and workers can also the workers who would be potentially joining the agricultural labor force in the UK, but also more generally would be as well refugees.
Brilliant, thank you. I see there's also a question online, and we'll come back, maybe deal with those, and we'll come back to yours. So the question online, we can't quite see all of it, is can any of those in the practice expand on the idea of using the stereotypes, the benefits, but how does that relate to avoiding desensitization? And I don't know who wrote this, I'm sorry, because it's disappeared, but as part of my research studies, we found an emerging theme of desensitization being problematic. Solicitor found it hard to convince judges of the client's claims when they may have heard cases with similar facts, and the solicitor who found themselves being desensitized too. We'll start with those 4 questions then. I don't know, should we start again with Julian? Whatever you may want to say in response to those.
Well, firstly, Queenie, I mean, there's an awful lot going on in our clients' lives. You're right. I mean, they're quite lucky if they've got teams of lawyers. You know, most of them don't have any lawyers doing anything for them. But I think we have to listen to our clients, because one of the things that everyone working with victims of trafficking tells us is that their clients just disappear very quickly and go to ground. And I think it's about thinking about what are the immediate needs of victims, because it's so common for victims to end up being re-trafficked while they're waiting for decisions or waiting for housing or waiting for status or whatever. You know, we had a client and we're thinking, Polish guy who was disqualified because of his convictions, and we're thinking really interesting case. These are the strategic challenge. You know, we weren't hugging him close enough. Very quickly, as soon as he got his disqualification decision, he disappeared. You know, so he had just come out of detention. His circumstances were very precarious economically, although he was from Poland and he could have got second status. No one helped him do that. He had no ID documents, etc. And I think we missed a trick in thinking we really hadn't got to know this guy well enough, and we were thinking how he was useful to us for strategic litigation purposes, but probably his immediate needs weren't being met. He had addiction issues and whatsoever. You know, what is the most important thing for the client at that particular time? And how do you keep them from finding themselves back in exploitation? You know, is it housing that is his immediate need, or is it healthcare, or is it a status document? You know, it's really up to them to have the space to be able to vocalize to us what's their most important immediate need, you know, that needs to be met in order to keep them on board when they're so vulnerable and so easy to find your clients disappearing back into exploitation. Difficult, the question about workers and displacement. Yes, our clients are coming, agricultural workers are coming now from very, very poor countries where probably they were able to eke out a living, but for environmental reasons can no longer do that. So they're often selling land and getting into enormous debts to come here, finding that the work here is simply not helping them because the debts, that they're not getting the hours they've been promised, they can't go back because of their debts, and absolutely falling into irregular status immigration wise. And we're finding that when they're, you know, the scheme operators for their own reasons are saying, go home, we'll re-employ you next season and you can make up your money. And then the scheme operators are saying, well, there's too many problems in Indonesia, we're not going to go back there. So all those workers we've promised future employment are just left high and dry. Nepal, investigative journalist, labour activist, doing some brilliant work in disclosing the corruption involved in these visa schemes. And then the labour operators here just moving to another country, you know, and that really makes us think these schemes can't work. You know, the labour operators refusing to deal with this, you're just moving from country to country to country so they can get maximum exploitation. So absolutely, you know, knowing that they're not going to get work next time they fall into irregular, probably exploitative labour, maybe enough to send a little bit of money home, maybe not, but absolutely we're finding very much in the care sector now. So just not the temporary worker schemes, but actually the skilled worker schemes where people are paying huge amounts of money to get employment here. We've heard of one guy who spent 28 grand to get his visa from some corrupt employment agency. Came here, there was no job available for the first 3 months. Then he got the occasional shift, and what happens when he starts complaining? He gets dismissed. The care home, the agencies inform the Home Office that the only response from the Home Office is to cancel their visa. What does he do if faced with £28,000 of debt to get him here? He can't go home. You know, so again, because the Home Office's own response is, well, you're no longer working for them. Okay. The regulators will say, well, we have safeguards in place. Of course, there are no safeguards. Yeah, more and more of these people will fall into irregular migration, and because of the recent legislation, they won't put their heads above the parapet. They will know that if they go into the NRM, they're at risk of being disqualified, sent home, etc. So it's going to be harder and harder for us to access these people. And of course, much easier for them to be, you know, it's an act and a bill which is really allowing traffickers to fulfill the threats they've always been made. You put your head above the parapet, you escape from us, and you will be detained and sent home. There's no access now, and there'll be even less access to any system of protection with the legislation we've got going through Parliament at the moment. So it's just, why not just hand people straight to the bloody smugglers? Because that's what the Home Office are doing, you know, ensuring that people will be forced into exploitation with no way out, no support from the government, from NGOs, from the law. And it will really be a massive increase in exploitation, I think, that we'll see from the legislation. So a lot of questions there, and I can't answer them all from an academic perspective, but a lot of what you're saying rings true, absolutely.
Thank you. Oh, Miranda?
Sorry, just to pick up on Julian's last point, I think everything that he just said about the illegal migration bill is one of the reasons why quite possibly passing the bill will be in breach of the UK's positive obligations to create a framework for victims of trafficking. But just on the desensitisation point, totally right, this is such a problem. I have seen it in practice. I'm sure all the practitioners here today and many others will have as well. And to a certain degree, my experience is you can't make someone care. You can try, but at the end of the day, you can appeal. It's very hard to say to someone who doesn't want to care. But the best way I've found, and I should thank my fantastic solicitors for doing the hard work on this, as well as my clients, is to let the judge hear my client's own voice. Fundamentally, the individuals I work with, the survivors of trafficking, are the best advocates themselves. They are the ones who know what they've been through. They are best able to express that, especially if they can be supported to do so. And that's why the casework that impresses me is the low number casework that you were talking about, is the exceptional casework where you have a dedicated team of lawyers who can work holistically, who understand all the sides of the case, who can do the joined up thinking, and who can make someone safe enough to make those disclosures and help me do the advocacy, essentially. And if you're lucky, that might avoid desensitization, at least in some cases.
Brilliant. Catherine, if you want to comment?
Very briefly, because looks like it's time for tea and biscuits, but just to say on the desensitization point, to add the last point of the last part of the sentence is not only judges becoming case hardened, but also people in the sector becoming case hardened too, or desensitized. I think, as Julian said earlier, that so many people in the sector, particularly if they're doing lots and lots of cases, or doing becoming burnt out, it's a major issue. And I mean, I'm sure everybody's aware that, I think this is why we just need to help each other out. It's why I should have, I've got something else to come to, but I would have liked to be there in person. And because of the pandemic, we're all much more siloed and not working with each other. But it's really important that we do that. And the academics that have spoken, we're all working in these. We shouldn't feel lonely. We should have greater mentorship. There's obviously support that ILPA runs, like free sessions in terms of mentorship or trauma-focused therapy and all of that. And often I speak to, I've spoken to solicitors or caseworkers where they're, barristers have an easy job because they're not directly speaking with clients all the time. They don't have clients on the phone. But just to reiterate, we should have, if anybody's working on that in terms of greater mentorship or support for anybody working in the sector, in NGOs, solicitors firms, chambers, academics, we should do that to stop ourselves getting desensitized and to be able to carry on doing the work as best we can. Good luck.
Thanks. And Noemi, there was one question specifically for you, and you might want to comment on the others.
Yes, I will also be brief. I also couldn't hear, I think, all of the question because of the audio, but I think I got the core of it. If I didn't get it wrong, it was asking about what about the stereotyping of women, right? Did I get that correctly or not?
I think so, yeah.
Okay. I usually make this premise when I share my work, which is this is not a battle between the sexes for hegemony of victimhood. Far from that. There are other brilliant scholars working on women and females and the consequences of the stereotyping and the erasure of agencies. We've talked about a bit before. There's Vanessa Munor, Alison Joby. There's so many, Abigail Stepnitz, many scholars that are working on the specific concerns around the stereotyping of women in this context. Clearly, me focusing on men doesn't take away from that research. I think it just adds to that. I think that the stereotyping is detrimental across the board, across the gender spectrum. I do think that not all women clearly are stereotyped equally. There is clearly elements of intersectionality that build into the stereotyping. And if we think of particular groups of trafficked persons, whether we define them or we categorize them by nationality or by class or by race, by religion, we will see different layers of stereotyping that happen within courts and before asylum authorities. Some are clearly more evident than others, and I will just go back to the point that I made earlier about stereotypes are culturally based. It's an imposition of a reflection of what the dominant culture is in a particular space and time. Therefore, clearly, certain types of womanhood are particularly stereotyped vis-a-vis others that are more understood and or tolerated to a certain extent better. And again, just to redraw the point, which unfortunately might not very much help in the practice of challenging the negative decisions, but it is an element of cherry picking, right? Who is protectable and who is not. And unfortunately, the stereotyping is, as I said earlier, the easy way out, because it's easier to justify negative decisions based on what the person should have done, could have done, starting from the position where the judge deciding has never been in a situation where they could have, should have done anything that a trafficked person might have had to do. So it's a very particular positionality that the judges hold and that asylum decision makers hold. And unfortunately, on women, again, I could be talking for hours about this, but there's other brilliant scholars doing a lot of work on that, and I will defer to them on that front.
Thank you. Maya, do you want to comment on?
I mean,
This
ever
question?
so briefly, I think the only issue I could possibly speak to is the issue of irregularity and forced labor. And I think sort of the position I would take on this is, even though as Miranda said, there is this hostility to accepting the realities of irregular migration and on the part of decision makers. But I really do think that sometimes we need to take a slightly broader perspective and think about, okay, what is going to happen to this person if they're sent back somewhere? Yes, they're going to try again. This will likely entail experiences of irregularity in transit countries, in countries of destination. So I think it's really important to kind of understand, you know, that people often don't have a choice and to kind of have to take that into account into the protection inquiry. So just very, very briefly.
Yeah, and I'll be very brief as well. Just I think Queenie's point, just really agree with the complexity of the legal situation that trafficked persons are facing. But that multiplicity of legal issues, I think I would still put forward the kind of view that securing immigration status can be the critical first step. So then going on to hopefully address the other legal issues as well. Because that security of immigration status should hopefully then at least provide a foundation for access other forms of support, and then hopefully to address the other legal issues as well. And then a final thing, like just re-emphasizing Julian's point as well about how I also think it's important to keep in perspective that the majority of people are unlikely to access legal advice at all. So just kind of that perspective as well, but it's still quite a scarce resource.
Thanks. Would you mind asking a question in the coffee break? So we get a coffee break. Sorry about that. We just ran out of time, and I maybe should have disciplined everyone, but everyone was saying such interesting things. Well, thank you very much to all the speakers. And for those of you participating in asking questions, thank you by all of them. And of course, that we still have a keynote speech to come after the coffee, so which we're very much looking forward to. So brilliant. Let's enjoy our coffee break.
Should be downstairs again in the same place. Hopefully.
We have a new version. I'm so sorry. The new version of it. Can you quickly just put it in reverse? I don't understand. Can I show you I saw your email. There's a new version of the slides. I'm just trying to.
So if you can't,
Have you got your number with you?
no, only like.
it's time for the highlight of our day, which is the keynote, of course. And our original keynote speaker, Zoe Benjamin, unfortunately couldn't make it due to unforeseen circumstances. So Colin, you very, very kindly and at extremely short notice agreed to step in for her. And I'm extremely excited that this has happened because tonight Colin is going to give us an overview of the community of law, as he calls it. Before he does so, I'm just going to have a stab at introducing Colin properly and list some of his extremely extensive accomplishments. And I'm hoping that I've not gotten any of this wrong. So as Violetta mentioned this morning already, Colin is a barrister at Garden Court Chambers, and he's also the editor of the Free Movement website, which I'm sure you're all already familiar with, but if not, I can highly recommend visiting freemovement.org.uk because it's got updates, comments, training, and advice on really all things UK immigration law. But Colin not only writes the most amazing and really accessible explainers for the Free Movement website, he's also the author of Welcome to Britain, Fixing Our Broken Immigration System, which I believe was first published by Byte back in 2020 and updated in 2022 to include some of the more recent legislative changes to immigration law in the UK. And then also in 2022, Colin actually published a book called Refugee Law with Bristol University Press, which is probably the most accessible textbook on the 1951 Convention that exists. So I can highly recommend taking a look at that. And then Colin has also published in academic journals, for example, in Critical Social Policy, where he wrote on the UK's hostile environment, how it deputizes immigration control. So Colin has this really deep understanding of the world of immigration law practice, but also very much moves in academic circles. So we're extremely lucky to have him as a keynote speaker, and I can't hear to wait what he has to say. So I'm just going to hand over to him now.
Thank you very much. Thank you. There's a copy of both books actually at the back. If somebody wants to wander off with the hardback of Welcome to Britain, I'm happy for them too. I don't know how you'd arrange between yourselves who did so, but the refugee one, leave that one behind, please. There are though some pamphlets that Bristol University Press printed for me to hand out or send to the people at last week at the Refugee Legal Initiative conference. I was basically too shy to, I wasn't going in person, I was too shy to post them and say, look, does anybody want these? So help yourself to those, and I think the discount thing still works, so it's half off from Bristol University Press. Yeah, the most accessible is quite, it's slightly barbed. If you look at the size of the textbook now, absolutely huge. So yeah, I was aiming to write something a bit shorter at least. I'm not sure how far it succeeds in being sort of genuinely accessible, but it is shorter, I can say, than some of the existing stuff out there. And what I thought I would talk about today actually comes out of some of the reading I was doing for the refugee law book. So I really arrogantly thought at the outset, look, I know quite a lot about refugee law. How hard can it be to write a book explaining what I know? And it turns out inevitably that I really didn't know as much as I thought I did, and that there was a huge amount of reading to do, an awful lot of research. And some of the contents of the book is, I think, maybe slightly esoteric, slightly personal, especially in sort of first and second chapters about issues like this, the community of law, which I think is a concept that I came across, I think from an article in 1997, talking specifically about Strasbourg, and the definition that was given, is given a couple of times in the article, is a partially insulated sphere in which legal actors interact based on common interests and values, protected from direct political interference. So that dates to 97, and it was about Strasbourg, basically. It was about the kind of culture of compliance with human rights judgments and the effectiveness of the European Convention on Human Rights in being implemented and to a high degree respected by member states. Now, as lawyers, obviously, we often focus on the cases where respect isn't shown and where breaches are established and so on. But at the same time, it's been much more effective in practice than a lot of other international conventions, and states usually at least pay lip service to it, and often will comply, although obviously there are plenty of instances where they don't. And there are three kind of ideas going on in this definition. One is literally having that network of people, and by legal actors, the authors aren't talking about, and this is a very concise version of their definition, but they make it plain in the journal. They're not talking just about practicing lawyers, they're talking about academics, researchers, campaigners, charity workers, governmental actors as well, the whole kind of sphere of law, really. They're talking about an active means of communication and a network of communication that actually works, where people have got, Steve used this phrase earlier, he talked about the incentive structures, and that might be partly financial, but there might be other incentives as well that encourage people to interact with one another, common interests, common values, perhaps finance, but also kind of social, cultural value and prestige that can go with being involved in human rights work. At least some people hold it in esteem, luckily. And it's a bit strange, perhaps, in these times where politicians are doing their best to impinge on law with their politics, but at least protected to some degree from direct political interference. And I think perhaps this is a slightly glass half full rather than glass half empty way of seeing things. But the fact that certain politicians are attempting to intervene, often in very crude ways, is perhaps could be seen in an optimistic light, as they see the need to intervene, and they haven't been terribly successful yet. They're trying to sort of interfere with the way that we do things, and they're trying to discourage people from doing the work by changing the incentive structures, and so on, by directly criticizing lawyers, by directly criticizing judges. But the fact that they see the need to do that in some ways suggests that the current situation is not as bad as we might think in some ways. So that's the idea of a community of law. And I'm going to talk about immigration and asylum stuff. I'm going to start by talking about asylum. I want to give you some context first of all. I want to talk about some successes, because we sometimes don't talk about success in this sector. And then I want to end by talking about ways to influence policy, ways to influence law, and also trying to stand back from the sort of nitty-gritty. What are the big things that are going on at the moment that perhaps aren't extensively researched? So context, immigration numbers. So this is my attempt to extract information from the ONS figures. And it is like an extraction exercise. It's not straightforward to get net migration figures at the moment, because the stats are going through a sort of phase where they're being recalculated and they're using experimental stats and so on. So there's three different measures that I've come across on the ONS website. And what I've done is I'm not looking at net migration here, I'm looking at immigration. Obviously, net migration is immigration minus emigration. So if we look at the immigration numbers, the number of people who are actually coming to the country as migrants, migrants, of course, is a loaded word. It has different definitions. The international definition is usually somebody coming for more than a year, so their usual place of residence changes. In some ways, controversially, that includes foreign students who are almost always going to go back to their home country. So some people say it shouldn't, but that's the international sort of UN definition that's usually used. And we can see that the numbers of people who've been coming to the country have increased quite substantially in recent times. And we're talking about well over 1 million people in the space of a year moving to the UK. Now, I'm not a proper statistician. I kind of dabble on a very amateur level with this stuff. I've never quite gotten my head around how the statisticians have taken account of the loss of free movement rights. So I think that there were estimates on EU citizens who were coming in and out, but because they didn't have to, they didn't have to apply for a visa, it was free movement. I think they were quite hard to count, frankly, in a way that, you know, students aren't. You can literally, you know, interrogate the Home Office database to tell you how many student visas were issued and how many people actually arrived and so on. You couldn't do that with EU citizens. So I suspect that data was a little bit less reliable, but nevertheless, I'm sure there were ways of trying to calculate it. But maybe it was higher in the past. But certainly, you know, this is looking at pretty hard data from the Home Office of actual visas that have been issued, and the numbers have gone up. If we also look at the stats on asylum, again, we can see that the numbers are going up. I don't particularly need small boat arrivals to be part of that chart, but I just reused the chart that I was using for something else. So that information is there as well. But the point is to show that peak of over 100,000, and this is not actually asylum applications, actually, to clarify. So the title says applications, it's applicants, it's the number of people including dependents. So if you see the earlier peak in 2002 being expressed as about 80, 85, 86,000, something like that, that was main applicants. So the information I'm using here is including dependents. There's over 100,000 in 2002, and it's heading up in that direction again. I don't know how closely you follow this, but Rishi Sunak, the Prime Minister, gave a speech a few weeks ago saying, it's working, our plan's working, look, numbers are falling. And then the weather's been really nice and loads of people have been arriving in small boats over the last few weeks. So, you know, we don't really know what the stats are going to look like for this year. They were a bit down on previous years. It doesn't look like they're going to be going up as much as they have been. You know, that straight line up doesn't look like it's going to be continued at this point. But it doesn't look like the numbers are going to fall substantially either in 2023. So we're talking about a lot of people arriving to claim asylum as well. So a lot of migrants, a lot of asylum applicants, refugees arriving. You'd expect there to be some hostility in the right-wing press from right-wing politicians and so on. And we are certainly seeing that. But let's talk about some successes first of all. So this is the grant rate. I was talking about this this morning. The grant rate in the late 80s, until the late 80s, was about 80–85%, apparently. It was a much more informal asylum application process. There wasn't a right of appeal, as we were hearing from Katrina Jarvis earlier, but of people who came forward and asked for asylum, you know, the vast majority of them got it. Over 80% of people were getting it. It plummeted in the 90s after you started to get an increase in the number of people coming to claim asylum. It was down to about 4% in 1994, according to a parliamentary question from Michael Howard, who was then the Home Secretary. About 4% of appeals were also succeeding at that time. What that doesn't capture is that quite a lot of people were applying for refugee status, being rejected, but getting exceptional leave to remain, discretionary leave these days. So that 4% figure isn't necessarily accurate according to the sort of stats that we're looking at here, because this includes everybody who gets asylum, basically, not just refugees, but also people who get humanitarian protection and things as well. But we can see that it was kind of bumping along at about, you know, 30% or so for quite a long time. And then it started to go up in 2018, 19, and it's gone up to 75%. It seems to have peaked in a previous calendar year at about 76%, I think. It's fallen down to about 75% according to the most recent quarterly stats going back 12 months. But it's very high. You know, that is a lot of people getting asylum from the Home Office at first instance. And of the people who get rejected and who lodge an appeal, about half of them are getting asylum as well. So that's what success looks like as well. And we were talking about, you know, the problems with things like the vulnerability frame, with using stereotypes to persuade judges. I was very open with you about that this morning. Miranda was being very open about it just earlier. But I think this is one of the things I'm going to say at the end. This is a pet theory rather than sort of well-researched conclusions. I feel like that kind of vulnerability frame where you advocate on behalf of special, you know, particular groups. I've called it special pleading myself in the past for children, for women, for sexual minorities, you know, for different groups, one by one. I felt very, I had very mixed feelings about that in the past because, well, what about everybody else? But the overall grant rate has really risen over that period, and so has the appeal success rate. So I think, you know, there have been considerable successes. it's not necessarily durable. This could go into reverse, and there are signs that that might well happen. I'm ignoring for a moment the fact that the illegal migration bill means that there will be a 0% success rate, because literally nobody will have their asylum claim processed. I'm assuming, and I'll come to this later, that that's going to be a temporary measure, because it just seems so unsustainable. Any future government's going to have to reverse it, I think. It looks like fairly sort of sustained at the moment. But say, for example, if you get slightly different groups coming in or something like that, then that could change over time. So I looked at this, I think last year, 2022, what are the potential reasons for why there has been a change? I tried to sort of check off all of the things that I could think of. So again, a blog post is not a properly thought through, well-researched piece of journal article or something like that. But looking for statistical oddities in the way that things are reported, and that is perhaps one of the explanations for the jump up to 75%, because I don't want to get into the weeds too much, but Dublin cases were basically being double counted as a refusal. So even where they were later granted because the person was allowed to stay, they'd been counted as a refusal previously. So if they were then refused, that would be 2 refusals. If they were then granted, it would effectively have neutralized itself. So actually that suggested that the grant rate had been higher all along, rather than that the 75% was sort of false reporting. So there's a potential statistical oddity there. I looked at whether a change in the composition of the countries of origin might be responsible for this. So, for example, are we just getting more people from more dangerous countries, where more people from Syria, from Afghanistan, from Iran, countries that are accepted to be a lot of refugees from those countries, in contrast to previous years? Or is the composition of those nationalities going up compared to other nationalities? Couldn't find anything like that in the data. It's wouldn't completely exclude that, but basically the success rate for all nationalities would seem to be going up. So it wasn't just sort of limited to particular countries. Is the world just more dangerous in the last sort of 5 years or something? Well, people laugh. You can't, surely not. I mean, there's loads of bad stuff going on, but there's always been loads of bad stuff going on. It could be argued that Syria is quantitatively different, and in the same way that Venezuela is, perhaps it's generated a lot of refugees in a small space of time. But there have always been civil wars and so on. I wondered about quality of country information perhaps being responsible in part for that. And there's some interesting, I think, interaction between academic work, expert reports, the Home Office semi-professionalizing their country information units. I mean, there's still problems with it, but you should have seen it 20 years ago. It was an absolute disaster area. And they've tried to adopt some academic standards in doing their work. I say, very open to criticism still. There's a lot to criticize about them still, but they are better than they were. Tribunal, the Immigration Tribunal, maybe is doing a better job than it used to be. Frankly, the idea that there's a feedback loop where that gets fed back to civil servants who then make better decisions is unlikely. We know the Home Office, it's not that sort of functional at a management level. But country guidance cases might have made a difference. There have been some quite good country guidance cases for some countries, been quite bad ones for other countries, but perhaps the balance is that the people who are coming to the UK are from the countries where actually there have been useful, good country guidance cases, and the countries where there have been bad ones. I'd single out Sri Lanka, Somalia. There aren't that many people coming from those countries at the moment. Perhaps the definition of refugee has widened out. Our understanding of what it means to be persecuted, understanding of particular vulnerabilities, the particular impact that things can have on certain groups, the convention reasons, and then that's perhaps true to some extent. Cases like HJ Iran make a big difference on the ground. Culture of disbelief has perhaps been eroded away, and again, that's perhaps due to academic work on the ability of people to storytell. The assumptions about people having perfect memory recall have perhaps been eroded away over time. People accept that people make mistakes. I don't know. Maybe that's a bit optimistic. And again, this one's a bit optimistic as well. Maybe the Home Office has changed from within, strangely. And bear with me for a moment. Maybe things like having the resettlement schemes. So resettlement started in 2002, I think, or thereabouts, with David Plunkett as Home Secretary. Very, very small numbers, just a few hundred people per year for a long time. Dramatically expanded in 2015 by David Cameron to include Syrians. Quite a few Home Office officials were dedicated to that. There have then been other schemes since then, perhaps officials seeing their role as being a protective one, where refugees can be positive. There are good refugees. They're not all just bad refugees. Maybe that's something that's kind of spread within the Home Office. And that is pure guesswork, and it's pretty optimistic guesswork, frankly. But yeah, I'd be interested to see somebody looking at these kinds of issues. Part of anything, how can we protect what we've got? We don't even know really what's caused this actually. And this is no coincidence as well. So this is the last of the sort of success story slides. I think it's a little bit controversial to call this success in some ways, but there aren't that many former asylum seekers being removed these days. Now, you wouldn't know that if you listen to the rhetoric that we see from the government and the kind of image that they present of themselves as being really tough and everything. But if you look at the number of enforced removals, it's actually about 20,000 in 2004. Sorry, 2006. Oh, that includes voluntary as well, actually. It's never been that high, actually, as 20,000. But it was a lot higher in previous years, and it's been very low over the last few years. You'd expect it to be very low during the pandemic, obviously, when there's very little international travel, but the overall trend for a long time has been downwards. Maybe that's going to change. With Rwanda, the government is hoping that it can remove tens of thousands of people actually to Rwanda, and everybody who has arrived since the 7th of March 2023 is supposedly going to be removed to Rwanda. And the Home Office itself, there was an NAO, a National Audit Office report on this last week, 2 weeks ago. The Home Office itself expects there to be 85,000 people in its new backlog. They've split the backlog in two for some stupid reason. They've got the legacy backlog, they've got the flow backlog. The flow backlog is going to be 85,000 people by the end of the year. They themselves expect, almost all of whom will have to be removed to Rwanda according to their own law. Never mind all the people who are arriving after that date. So the idea that they're going to go from a few hundred people per year to thousands and thousands of people seems a bit unlikely, and not impossible. And there are differences because Rwanda wants to take the refugees, and one of the obstacles to removing a failed asylum seeker is that it's quite hard to persuade the receiving country to take them sometimes. But it certainly, on the face of it, looks pretty challenging. What have they got in response to all this success? Well, the illegal migration bill looks pretty ineffective. It looks very likely to fail in practice, even if the courts do give the go-ahead. And we're going to be seeing a judgment about this on Thursday. It won't be the last word. Whoever loses is very likely to appeal. I don't know what the timescale might be for an appeal, but probably months rather than sort of weeks or years. It'll be somewhere in the middle of that, basically. I've been quite pessimistic about this. I suspect the government is ultimately going to give the go-ahead and allow people to be removed, subject to an individual assessment. It's going to be very hard for the government to do that in real life, though. I think they realise that. The idea that they're going to have massive detention camps for tens of thousands of people is unlikely. What we'll probably see in practice is what Julian was talking about, people just not coming forward. So people will try to enter. Maybe that the absolute numbers will fall to some extent. I mean, there's no real research to suggest that these kind of deterrent policies really work, but perhaps there will be a fall in the number of people who are coming in, but it won't be as dramatic as the government hopes for or expects. But what we might see is people coming in and not claiming asylum and basically trying to keep their head down, whether they're trafficking victims or survivors or not. Coming in by clandestine means, not being rescued in the channel, not being detected once they're on the beach, basically trying to sneak in, using the back of lorries. You get out in laybys instead of being detected at ports and so on. At the moment, people are actually trying to get rescued. They get to the halfway point and then they want to be detected. They're fine if they reach the beach. They're not trying to not get to the beach, if you see what I mean, but they're happy about being detected because they're then safe. Well, if they do know that there's no prospect of asylum, that they're going to be detained automatically and they're going to be removed to Rwanda, will that stop them from coming? People who haven't got refuge where they already are in France. You know, people say, well, they should claim asylum in France. Well, they could do that now, but they you know, in theory, but for various reasons they haven't or they can't, or they've already been rejected. And again, this is one of those areas where we don't really know what's going on. We don't know much about what's driving refugees to come to the UK. There have been some research, but there's not a lot. You know, and so there's nothing really to inform policymakers or advocates on this kind of stuff. But it looks like it's not likely to work as the government hopes. And I don't say that to be blasé about it. It feels to me like some people are going to end up being frog marched, you know, forced onto flights to Rwanda, and it's going to be awful for them. Don't think it's going to be that many people when it comes down to it, and that's not to say that's great. You know, it's going to be terrible for the people it happens to, but it doesn't look like an effective policy. It looks like a really hard policy to actually enact on the ground. It could even be counterproductive. So if they're not able to remove a lot of people to Rwanda, then people maybe keep on coming because the chances of being removed to Rwanda will be seen to be very slight. And in fact, if you are an overstayer, if you come in as a visitor or a student and you don't want to leave the country again, you could then claim asylum. You won't be removable to your home country anymore because your asylum claim will never be assessed. Because your asylum claim, this is sort of built into the structure of the bill, because your asylum claim won't be assessed, they don't know whether you're a refugee or not, and therefore they can't send you back to your home country because that could be refoulement. Okay, so they've got two lists of countries. If you're from an EU country and Albania, you can be sent back to your home country. If you're from any other country in the world, you can't be sent to your home country. You can only be sent to a third country. So if you're from Brazil, from India, you know, some of the countries that we know there are some overstayers who get removed. You can see them in the removal stats. They'd be able to claim asylum, and that would stop them from ever being removed to India or Brazil, basically. So it can actually increase, you know, at the same time that the number of genuine refugees actually, not they'll still be here perhaps or arriving, but they won't be claiming asylum because there'll be no point. At the same time, the number of genuine refugees coming forward to claim asylum falls. The number of people who aren't necessarily genuine refugees might actually be increasing. It could be counterproductive, not just ineffective. I don't know. It's you know, we'll have to wait and see, I guess. It's also incredibly expensive. Now, you know, once you start talking about the amount of money that the government's got, it all starts to be a bit meaningless. But they've spent £3.6 billion on asylum support over the last year, which is an absolutely astonishing amount of money. You could buy some really useful stuff with £3.6 billion. And the reason why they've spent that much money on asylum support is because of this huge backlog that they've allowed to build up, plus their sort of abysmal managing of kind of the hotel accommodation. You know, you've got Home Office officials have literally been bidding against each other with the effect that it's been forcing up prices. They're that useless at what they do. They're that incompetent, and they've been plundering the international aid budget to do this as well. You know, so international aid rules allow you to take a certain amount of the international aid budget to support refugees in your own country for the first year of their stay, and so that money has been diverted basically from international aid in the Horn of Africa, where there's developing famine, from the floods in Pakistan, where the UK response has been, you know, we pledge less money than other countries that do not have historical links to Pakistan. And they've been spending basically loads of taxpayer cash on subsidizing UK hotels and giving it to UK hoteliers. And it's just absolutely mind-blowing what they've been doing. And then, you know, what their solution is allegedly to, you know, spend more money on barges and on building detention centers. Yeah, it's actually more expensive to do that stuff than to keep people in hotels, which is relatively cost effective. So it's incredibly expensive as well. I think this is a success. You might disagree with this. And they accept the protection imperative. So I'm going to come back to this in a second when I talk about the community of asylum law. They accept that refugees need to be protected, but they have a very different philosophy to those people in this room, I think, where they say well, we do accept that we should protect refugees, just not those refugees. We want to protect these other refugees instead. And to be fair, now, you know, you have to be careful with saying to be fair to people like the people we're talking about here. You know, a lot of Ukrainians have received asylum in the United Kingdom. We're fairly high, if you compare us to other European countries, we're fairly high up the list actually, but we're obviously further away from Ukraine. We've got quite a lot of people who've arrived from Hong Kong. They're not refugees within the definition of the Refugee Convention, perhaps. They wouldn't style themselves as refugees, or they'd reject that styling. But you know, that there have been safe and legal routes. There are certain people who've been given asylum in this country in the broad sense. And so you can't criticize the government for not having lots of places on safe and legal routes. It's just that we're talking about very, very different people. And the people who want to come by irregular means that a lot of us are interested in are not the people that the government wants to be giving protection to. They want to kind of pick your own approach to refugee protection. But I think the fact that they accept that refugees need protection is interesting, and it's something we can work with and kind of build on to some degree. You know, you then contest who we're talking about and so on. And it contrasts a little bit with migrants, actually, and that's kind of not so good story, I think. So if we talk about go back to this little community of law idea, in asylum law, you've got this sort of amazing ecosystem of different organizations doing really good work. You know, there's ILPA, there's Asylum Aid, there's Amnesty, there's UNHCR. You know, back in the day, there was the Refugee Legal Centre, the Immigration Advisory Service, where I used to work with Julian. You've got loads of, you know, it's APLU now. There's so many amazing, sometimes small, sometimes slightly bigger organizations who are kind of working in this sphere. And it's brilliant. And there's loads of lawyers who know what they're doing. They're trained up. There's a kind of self-sustaining, I think, community of lawyers who can pass on their experience and their knowledge to a further generation. It's not as easy as it used to be because the funding's a lot harder. You know, IS and RLC used to train up a lot of people, including me, and they don't exist anymore. But there is quite a body of lawyers. And if you talk to people, I haven't talked about Malta earlier, for example, over lunch here, there just aren't any lawyers to do that stuff in some countries. There isn't a body of lawyers, a cadre of lawyers who are able to do this stuff. We've got quite a few academic centres here in the UK. Obviously, there's this one, but there's others as well. There's also international centres which specialise in asylum law and refugee law. You've got really good, I think, communication between them, you know, circulars, conferences. There's the Journal of Immigration, Asylum and Nationality Law to some degree. I mean, there's free movement as well. You know, there's a lot of kind of networking and communication between us, and all these kind of permeable boundaries between us as well. There's a lot of, you know, lawyers also function as campaigners, go on to become judges. It's I think what Jeff Crisp has called a very highly networked field of law, which is all good. But if you contrast that with immigration law, I just don't see that actually in the sphere of immigration law for non-refugee migrants. There are quite a lot of lawyers who do quite a lot of immigration law, but we tend to be pretty sort of siloed. You've got a lot of lawyers who do, basically, they don't represent migrants, they represent employers, and that's a very large contingent of the sort of immigration law community now. There's only one organization really doing specifically immigration law, ILPA. Maybe that's wrong. Maybe I'm missing a few people out here. There's the one journal, in contrast to loads of different journals doing sort of asylum and forced migration stuff, which is the Journal of Immigration, Asylum and Nationality Law. It's taught in very few universities. There's only really a handful that actually have immigration law kind of modules and so on. I don't think it's a very healthy community on that level. Which I think a lot of immigration lawyers would be surprised to hear me say, because you know, we kind of know each other and everything, but I don't feel like there's a kind of discipline of immigration law. It's not an academic field in the same way that it is in asylum and refugee law. You don't have people kind of working on definitions, and I don't think there is one of the things that's great about asylum is that this isn't my idea. This is taken from the journal articles I was referencing at the beginning. You've got people who have what's called a dual imperative. They want to perform their professional functions as campaigners, as lawyers, as judges, as academics, but they also share an imperative to protect refugees. There's kind of common ground that refugees need protecting. Now, there might be disputes about which refugees we're talking about and how best you protect refugees and so on, but there is this kind of desire to protect refugees, a recognition that they need protection because of the situation in which they find themselves, where they don't have a state to provide that protection to them. And I just don't think we get that with immigration law and with migrants, where there's no real common ground, for example, between the immigration lawyers who are doing claimant work and the immigration lawyers who are doing government work. There's no consensus on what rights immigrants should have, how they should be treated, what kind of legal principles should apply to them. We don't know each other socially, we don't mix, there's no kind of network effect. And you know, the judges have got no kind of pool of experience, of knowledge, of academic work, I think, to draw on in order to inform them. And you end up with decisions like the one last week from the Supreme Court. It's a really obscure subject in a way, and it's to do with the golden visa scheme, the tier 1 investor scheme as it was known. And you've got the Home Office simultaneously saying, we've got the points-based system, it's a strict liability, effectively tick box system. Nobody has to think, you know, we're not looking at the overall purpose or whatever here. There's no discretion involved in this, and therefore we can reject all of these migrants' cases if they don't exactly meet the terms of the rules. And then as soon as somebody comes along with, like they called it the Maxwell scheme. I mean, who calls a financial scheme a Maxwell scheme? But this kind of thing where you borrow money as an investor, you borrow money from one company and then you pay it to another company who then invests it for you, and you have no choice about where it goes. And one company is owned by Mr. So-and-so, and the other one is owned by Mrs. So-and-so, and the money all goes off and gets invested in Russian companies. That is not the purpose behind the UK investor visa scheme. You know, the idea of the UK investor visa scheme is that you invest the money in the UK. I'm not saying it's a good thing or a bad thing, but that's the idea behind it. That was not how this Maxwell scheme was working at all. But you know, there was a very strong argument to say it did comply with the exact requirements of the rules. On a tick box approach, you know, it ticked the boxes basically, but the Home Office say, oh, well, no, it's not about the tick box, it's about the purpose of the rules and the scheme and so on. It's like, but a minute ago you were saying, yeah, and you see this real inconsistency of approach where, I mean, to be harsh to the courts, you know, they are consistent, they are consistently deference to the government, and that requires them to be inconsistent in their approach in individual cases, essentially. And yeah, I wonder if they could get away with that, actually, if there was a proper body of immigration law with accepted principles, with people actually sort of working on this stuff. Maybe that's naive, I don't know. So I'm going to end by talking about just some ideas for sort of how you influence law. One way is to expose gaps or lacunae in the law. You need to know what the law is in order to do that and understand preferably the dynamics of how it works in practice. You can highlight unintended consequences. You can expand the definitions we were talking about earlier, or you can widen the group to whom the definition applies. And you've got to communicate it to your target audience. And in asylum, a lot of that's kind of done for you in a way, in a kind of highly networked community. You know, there's all sorts of resources you can draw on to try and achieve all of those things. And the communication can kind of take care of itself to some degree. I mean, not completely, but you know, you can give speeches at conferences. You know, there are events you can talk at. There are journals to publish in and so on. And it's not as much of an uphill struggle as it might be elsewhere. For example, in immigration law. You can also attempt to influence future law. So yeah, let's talk about influencing the interpretation of existing law. You can also work to change the law. So you can expose problems, again, as we've already talked about. Formulate potential solutions is something you can do, and I think it perhaps helps to make work more persuasive if you look like you're not just complaining about things. But obviously it's not we don't have the resources of government behind us to formulate really great solutions to some of the problems we might identify. It's a kind of optional extra. There are reasons to do it if you can, and you may well have ideas yourself if you come across problems. You may come across other people with ideas. So it's certainly something to think about, even if it's not absolutely essential. Communicating effectively becomes much more important here, though, because you're trying to reach outside the community of law and influence policymakers who aren't attending our conferences, aren't reading our journals, don't have necessarily the kind of shared values that we talk about, and you need to try and persuade them. And sometimes that's pretty uncomfortable, like we've talked about with using vulnerability in order to try and shift the dial a bit on things like credibility and so on. And one of my, again, it's sort of a bit of a pet theory, and I've got no real backup for this. It was kind of my impression as things were happening, was that immediately after the Brexit referendum, there was this, I don't know if you remember this, but this rash of stories about white middle-class professional Europeans who were suddenly seemingly being screwed over by the Home Office because they were applying for permanent residence, which was the only thing that they could do at that point in time. It was to be valueless further down the line because permanent residence is something you have under EU law. EU law was going to end. And they were being refused by the Home Office because for all sorts of daft reasons, they're having to fill in these really long forms. And suddenly all these articulate people who knew journalists and were able to get their stories into the newspapers, there was a lot of that kind of coverage going on. And it's like when I've seen coverage of lots of white families in the Daily Mail with the immigration rules and the income threshold and things like that. Oh, it's supposed to affect these migrants, not these ones, and so on. And that's the sort of implicit story there. And it's a bit frustrating when you suddenly see a bunch of middle-class white people getting loads of coverage of their immigration problems, when we've been seeing this for a long time for a lot of, this is not new. What, the Home Office is broken? Oh, who knew? But it was great. It created this narrative of a broken department, a broken Home Office, which got a lot of traction. A lot of politicians who wouldn't normally be open to that kind of narrative suddenly got the point. And then I think it also arguably created space for the Windrush stories to be told as well, because the newspapers were more interested in immigration stories. They were more interested in the narrative of a broken Home Office. Some of the newspapers have actually invested fairly heavily in their immigration coverage. There are now journalists who are essentially dedicated to immigration stories. So I think it kind of, although I had quite mixed feelings about that at the time, I think it might have been beneficial in the long run because it did kind of open the space for other people's stories to be told as well. So that kind of, it can be quite an uncomfortable process where you're trying to reach out beyond our people, so to speak, and to other people and think about what might actually persuade them. It's you have to compromise sometimes in doing that. And that can help to achieve change, I hope. So finishing off with looking at some stuff that's going on at the moment. So I've added this one in there. I made a couple of changes. I felt okay because I've only done this at the last minute anyway. So I made a couple of changes. I've added this in because of listening to sort of what people were talking about during the day. What sustains the community of law at the moment? And again, incentive structures, but also Jo Wilding's work has been referenced a couple of times. Her book on the legal aid market, which I think actually on the back of the pamphlets I've left it there. It's from Bristol University Press as well. She's an ex-colleague at Garden Court, and her work on the legal aid market is just something nobody really thought of doing previously, but it's been really important, and it does seem to be helping to shift the narrative a little bit about legal aid and make people realize that really the market properly is broken. And there's probably more to be done on that front about what kind of what motivates lawyers to do the work. We've talked about the dangers of burnout, but there do have to be financial incentives. People do have to be able to earn a living doing it. That sometimes might be uncomfortable because it means that there has to be profit probably in the sector. It means that somebody's going to be walking away with more money than other people if it is a sort of market-based system. There might be firms that pile it high and sell it cheap, so to speak, but I'd rather have that than nothing. I'm not saying it's a binary choice. It's either we've got to have it like it is or a little bit better than it is or nothing. But again, if you contrast the situation in the UK, where there is this kind of legal ecosystem, to other countries where there's just nobody doing the work, just nobody, or it's all done pro bono. We do actually have it pretty good in this country in some ways. Not to say it can't be better and that we should just take what we've got, but actually, remember that we do have some strengths or successes in this country. Looking at the bespoke refugee stuff, so talked about Ukraine, talked about Hong Kong, this idea of the kind of pick your own approach that the current government is clearly very keen on. What kind of national preferences exert themselves? Is it about sort of race and gender? We're fine with white Ukrainian women coming in, thank you, but we're not okay about dark-skinned men. Is it that? Is it to do with geopolitics? Is it a bit of both? What's going on? What are the kind of things that assert themselves when different countries opt for this kind of bespoke approach? I don't know. I tried to put together a kind of history of refugee stuff from basically a bit of reading and a bit of Wikipedia and a bit of Googling. It's not exactly very great research there. Looking at the previous schemes that we've had in the UK and how those worked, I wasn't trying to do any analysis. It was literally just a narrative, but I think that'd be interesting. What goes on with this kind of bespoke stuff? That's certainly one of the things that's going on at the moment. The scale of arrivals, what is happening to this, million plus people who arrive in this country? The debate is always, it seems, about just the numbers arriving. I'm much more interested in what happens to people once they get here. How are they treated? What happens to them under the rules? How are they disadvantaged by the immigration system compared to how they might be treated? The level of fees that they have to pay, the sort of financial penalties they get hit with, the way that they now have to use a lawyer because of the complexity of the system and the fees that we charge as lawyers. It's a sort of unseen lawyer tax or whatever on migration. There's all sorts of interesting things going on about kind of integration and settling in and disadvantage that migrants might experience once they're here. What kind of arrivals? We've seen some quite good work, I think, on exploitation in the agricultural sector. That's hit the newspapers to some degree, and there should be more coverage of it because it's appalling. It's an incredible scandal. There's been good coverage. The trafficking thing is an interesting one, where it's a right-wing government who introduced the trafficking protection mechanism, and the modern slavery. Well, they didn't introduce it; it was already around before 2010. It was kind of reformed since then. But the Modern Slavery Act, introduced not for good reasons, arguably, but actually once it's there, you can kind of do something with it. There's some sort of interesting things about exploitation and what are the risk factors there? What happens to people? I know 40,000 people just being recruited to care homes with visas in the last year. You can see that in the immigration stats. What's going to happen to them? And the shortage occupation list, are they being paid below market wages? How do they get? It's hard for them to move employers. There's all sorts of stuff going on there, and it's quite a substantial number of people that we're talking about. Why has the grant rate changed so much? Now, sort of going through that earlier, I'm not going to go over it again. And why? This is a big one. Why are the policy responses so abysmal? Why are why is the government so bad? It seems at responding to all of these kind of big trends, and they seem to be ineffective even on their own terms, and also what they're trying to do is terrible as well. It's what's going on inside the Home Office? What information are they drawing on? Is it just that it's really heavily politicized and that's the whole answer, or is it that there are other failings going on in the Home Office? Because sometimes you do see the politicians talking the talk, but the civil servants kind of walk the walk, and they do other stuff quietly in the background that's actually beneficial. Arguably, the change that we've seen in the grant rate over the last sort of few years reflects civil servants getting on with it and actually recognizing genuine refugees, while their ministers spout off in the media about this and that. So it's not that I think we can perhaps go beyond the kind of headlines and politics, and what's going on with policymakers as well. Okay, so that wraps things up. I'm not quite sure how long I talked for, so I'm sorry if that was too long, and I hope that was useful.
It's all extremely interesting. I'm just going to stop the screen sharing so we can see whether people have questions online. And obviously, people in the room, please also post your questions to Colin after this really interesting talk. I really can't tell you how much I appreciate it. Like, you have taken us on this amazing tour of what's currently going on in UK asylum and immigration law, and I think it was just such a rich talk because it gives people so many ideas of where research might be useful. So I think this is really one of the things that you've really given us, incredible research ideas. And I think what came across from your talk to me was that it's probably socio-legal or possibly even non-legal research that's needed. And of course, we've not really invited any non-lawyers to present today. And this is also bad news for the doctrinal lawyers in the room, but incredible. So, you know, from what's actually going on within the Home Office to what's actually happening to the people who are arriving, super interesting, super valuable ideas for research. So thank you so much for that. And I'm hoping that, you know, people in the room or online, or maybe people who come to know about all of this later will take up some of this research, and in a couple of years' time, maybe we can reconvene and actually find out what the answers are. But I certainly have questions for you, but I want to see if anybody in the room has any questions first, or people online, please feel free to put it in the chat or raise your hand if you prefer. Julian has a question.
It's very nice to listen to a glass half full presentation. Thanks for that. There's a couple of things. One, have there been any research as to why so few people from Hong Kong have arrived? Well, estimates that there are about 3 million people who are entitled to those settlement visas, and maybe less than 5% have actually chosen to upstick. The other thing is, I mean, can Cruella be so unprepared for illegal immigration for the Rwanda thing? You know, she still wants to be leader of the Tory. Has she got something up her sleeve? I mean, there were talks about discussions with Fiji and Niger and Botswana and that. Is she going to pull out another 5 countries?
It's possible, isn't it? Yeah, it's possible. I mean, it could, you know, sort of you put all your eggs in one basket and say, oh, Rwanda can't receive that many refugees and so on. Well, maybe others could be produced who will do, although there haven't been any hints of that so far. I do wonder if they don't really plan to do it. Like, they're hoping the election happens, the courts stop them, because it just seems such an impossible task that they're setting themselves, as well as, you know, I'm just talking from a practical point of view, never mind the morality of what they're talking about. On the Hong Kong side, I think it's about 140,000 have come so far. Seems like quite a lot. And it's true that there are more who, and basically almost anybody in Hong Kong is eligible under the expanded scheme, because it was originally people who've got British nationality overseas with brackets. But, you know, that couldn't be anybody since 1997, basically. And then it was extended to dependents as well. So it's quite a lot of people in Hong Kong. You know, a lot of people don't want to move countries. Some people do want to move countries, a lot of people don't.
I noticed that in your sort of success stories of resettlement schemes, you left out the Afghan resettlement scheme, and justifiably so. I wonder whether you think that shows the limit to how well resettlement schemes can work, particularly for certain nationalities, even when we have such a strong link to their country.
Yeah, it's yeah, I've got nothing useful I can say about that, really. It was what the government did was good in that, you know, considering how taken by surprise they were and how incompetently the evacuation seems to have been handled. Setting that aside for a moment, which is quite a big thing to set aside, you know, they evacuated as many people as they could. A lot of civil servants worked very hard to achieve that. But then I don't know what happened after that. You know, once they were here, they just seem to have been abandoned. I think some have managed to find their own accommodation and sort of move on out of the hotels, but a lot haven't, and they clearly just haven't been given the help that they really needed. So yeah, it just seems like a really big failure. Since you know, it's quite a lot of people. I think it's about 20,000 people or something like that were evacuated quite quickly, and then almost nobody's arrived since then. And there's still several thousand of the 20,000 in hotels with, you know, on the point of eviction at this point. Right? Yeah, they're just going to be turfed out soon.
Yeah, I mean, that's the charity I currently work for. And we're dealing with a lot of people who are still in, well, either in Afghanistan, or a lot of them are in Islamabad. And in particular, of course, the resettlement rate from Islamabad in the past few months, I think, has been 2 individuals.
And it's not easy to help people, but if you contrast how they've been effectively just abandoned with, you know, the efforts that were put into the Ukrainian scheme and so on, it's quite instructive.
Sorry, just wanted to add some context to the Hong Kong question from Hong Kong. I think it actually brings up a really interesting concept as we talk about, you know, immigration and refugee and asylum in itself, in that sadly I don't think this push is strong enough for people to feel like they want to move. So I think oftentimes you're in comfort zone, you have that very strong push to go. And very frankly, from what I'm hearing from communities, the pull to the UK isn't quite that strong either. So it's kind of like not enough push, not enough pull, which is why those numbers seem quite low. And I think obviously there's a whole history of like colonization. And I think that cultural background of, you know, if you come to the UK from Hong Kong, you're not necessarily a refugee. You're going to see that you're very much like what they call an economic migrant, and that you come because you want to find a job where you want to go to like eat and whatever it's Oxford, etc. So it's become only the non-privileged are coming. And I think there's also that generational gap that comes with it, and that people were trying to get out of Hong Kong because of the left democracy and the left of free speech, etc. They're very much the millennials, if I can say so. And you know, if you take into account the economic status of a lot of them in terms of how much they're earning or how much savings they have, they actually just cannot afford to come to the UK. And whereas the slightly old generation, the boomers and the Gen Xers, etc., they have the money and the power, but they also have that historical safety of being part of the larger population. So, you know, not a question on the floor. That's kind of why people aren't really coming out of that. And at the end of the day, it's going back to that history of integration in that, you know, if the small communities here are less people like this fun because how do they integrate, like where do they integrate, and all these questions.
Any other questions from the audience? Steve has a question.
Yes, I thought in addition to the interdisciplinary point, where I mean, I thought as politics is sort of been part of the history, which, you know, it's not with you that there's a toxic culture about immigration. You know, you track back, you know, to the early last century, for instance. And it would be, I think it's a specific issue about the media and culture wars and the way there's a feedback loop between the media and politics. There's also, I think, a comparative law angle, and that how much of what's going on in the UK is paralleled elsewhere, particularly the EU and the United States. And we know some very difficult discussions about asylum in the EU and the United States as well. So the politics is quite similar. I don't know if there's, you know, if anyone wants to come in from more experience of other countries to comment on the comparative law, comparative politics. But one thing that struck me in that context was there may be, I don't know how you measure it, I think more of an immigration law community among EU lawyers. And perhaps that's because there's a, you know, partially harmonized law across the European Union, and that's something that people can talk about on a transnational basis, the lawyers, the academics, politicians are either implementing it at national level or you know, negotiating at EU level. And there's also anyway, I think a lot of crossover anywhere between immigration and asylum. So a fair number of academics and practitioners are maybe doing some bit of both. So I don't know if it's quite as sharp a distinction as you said, although it's a lot of people just doing corporate work visa stuff, and they're not going to do asylum, but at least some portion are doing about.
Yes.
Just, without wishing to give ourselves too much of a pat on the back, how much of these higher grant rates, both at appeal and at first instance, is actually down to legal representation and the representatives themselves being of higher quality now than they perhaps were before.
I don't know. I don't know. I think the previous generation of lawyers were pretty good as well. I think there's been a change in the judiciary. That's very noticeable. So at least at the lower levels, a lot of immigration lawyers have gone on to be judges starting in about 2005, basically. And I think that's a trend that's kind of accelerated. And a lot of immigration judges used to be very much from outside the sector, kind of ex-colonial officials, kind of home county solicitors. There's nothing wrong with being those things, but they were not very sympathetic to refugees, basically. Sometimes more sympathetic in immigration cases, but there has been a change in the judges, definitely.
You think that's why we get better results potentially in the tribunal than at the High Court?
I think it might. I don't think you can easily compare actually those two things. But so, and you can. I think you do get a fair hearing more often than not in an immigration tribunal now in a way you didn't used to back when I started my career. Think of some of the characters there were just absolutely appalling, And there's still some bad ones out there now, but that's not the norm anymore.
Maybe I can come in with a question which kind of relates to what Steve said a little bit about the overlap between the asylum community and the immigration law community, but also to the issue of courts and their decision making. So you really you illustrated so well what sustains the community of law, but and I'm sorry to move to possibly a glass half empty kind of view, but kind of seeing that the UK government is really trying to take away all of the tools we have. They're trying to take away the Refugee Convention. They're trying to take away the ECHR, which of course also affects migration. What can we still do if they take all of our tools away? That's kind of the question I have, and I find it quite threatening, and I'm sure that practitioners are worried about that as well.
Well, I'm not sure how far they can. There's reasons to be concerned, and I'll come back to that in a second. But say, for example, the Refugee Convention is it's always going to be there, I think, and it's there for a reason because it's not great, but it's the best there is. It was carefully drafted. There was a lot of compromise involved in its drafting, and it's very hard to think of any other practical way forward. And it's kind of other countries, I suspect, will expect, there'll be pressure from other countries to conform because, why would other countries cooperate with the UK on various things if the UK isolates itself and refuses to do its very limited bit on the refugee protection? So that's maybe optimistic, and that could be wrong, but I don't know. I'm not sure how easy it is to take away some things like that. But more pessimistically, when you see government attacks on immigration lawyers or right-wing media attacks on lawyers, for example, for being as bad as people smugglers and for being complicit in people smuggling, in some ways that seems utterly absurd. But I think we need to understand how important those attacks are because they're trying to change the cultural value of doing the work. They're trying to make people ashamed and afraid of doing that work. And I don't see any sign that they're succeeding yet, but they seem to be alive to some of our successes, and they're thinking of ways to try and neutralize them, frankly. I think there are reasons to be concerned about that in the future, and then maybe they will see those sorts of attacks ramping up. And I'm picking on lawyers because I'm a lawyer, so I'm particularly alive to that. But we might be seeing other ways of attacking the sector and the community of law, and trying to undermine the sort of value incentives and so on. I think the Home Office, the right do have they don't see themselves as evil, and they have a different way of seeing things, and I think we should recognize that. And if we want to persuade people perhaps need to engage with it. It's not accept it, but engage with it to some degree. So, you know, they see it as wrong that people are breaking the rules, and they see it as right to protect refugees, but only certain refugees, and it's common sense to discriminate between refugees and to pick some and not others. And you know, that is a different way of seeing things, but they don't see that as being morally reprehensible or evil in some way. And you know, there's a big segment of public opinion behind that. I don't know how big. I wouldn't even hazard a guess as to, you know, where the balance lies or anything. But you know, there are a lot of people who think like that. It's a majority or whatever, but there are people who think like that.
Yeah, and I think it was so interesting in your talk how you said, you know, there might be additional tools that we don't think of as much, such as the fact that there are certain groups of people that even this government is willing to protect. So that's very important. And this is also why I think it's so important to stick together as the community of law and to have these exchanges and kind of get these ideas flowing around. So unless anyone has any other pressing questions, I might call it a day on this note and thank Colin again and all of our speakers so much for all of your insights. Thank you. There are hopefully drinks downstairs now. I've not seen them being delivered, but I hope they're there. So please do join us for a drink now. Oh, that's brilliant. I didn't want it to end. Where's the
I'm to get that on.
Yeah, no problem. It's always interesting to deal with university tech because I'm really, really bad at it. So I always need all the people